This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit librivox.org. The Anti-Federalist Papers. The Anti-Federalist Papers, Section 30, Brutus Letter 10. Read by M.L. Cohen, Cleveland, Ohio, May 2007. 24 January 1788. To the People of the State of New York. The liberties of a people are in danger from a large standing army, not only because the rulers may employ them for the purposes of supporting themselves in any usurpations of power which they may see proper to exercise, but there is great hazard that an army will subvert the forms of the government under whose authority they are raised, and establish one according to the pleasure of their leader. We are informed, in the faithful pages of history, of such events frequently happening. 2 instances have been mentioned in a former paper. They are so remarkable that they are worthy of the most careful attention of every lover of freedom. They are taken from the history of the 2 most powerful nations that have ever existed in the world, and who are the most renowned for the freedom they enjoyed, and the excellencies of their constitutions. I mean Rome and Britain. In the first, the liberties of the Commonwealth was destroyed, and the Constitution overturned by an army led by Julius Caesar, who was appointed to the command by the constitutional authority of that Commonwealth. He changed it from a free republic, whose fame is sounded and is still celebrated by all the world, into that of the most absolute despotism. A standing army effected this change, and a standing army supported it through a succession of ages, which are marked in the annals of history with the most horrid cruelties, bloodshed, and carnage, the most devilish, beastly, and unnatural vices that ever punished or disgraced human nature. The same army that in Britain vindicated the liberties of that people from the encroachments and despotism of a tyrant king assisted Cromwell, their general, in wresting from the people that liberty they had so dearly earned. You may be told these instances will not apply to our case, but those who would persuade you to believe this either mean to deceive you or have not themselves considered the subject. I firmly believe no country in the world had ever a more patriotic army than the one which so ably served this country in the late war. But had the general who commanded them been possessed of the spirit of a Julius Caesar or a Cromwell, the liberties of this country had in all probability terminated with the war, or had they been maintained, might have cost more blood and treasure than was expended in the conflict with Great Britain. When an anonymous writer addressed the officers of the army at the close of the war, advising them not to part with their arms until justice was done them, the effect it had is well known. It affected them like an electric shock. He wrote like Caesar, and had the commander-in-chief and a few more officers of rank countenanced the measure, the desperate resolution had been taken to refuse to disband. What the consequences of such a determination would have been, heaven only knows. The army were in the full vigor of health and spirits, in the habit of discipline, and possessed of all our military stores and apparatus. They would have acquired great accessions of strength from the country. Those who were disgusted at our republican forms of government, for such then there were of high rank among us, would have lent them all their aid. We should, in all probability, have seen a constitution and laws dictated us at the head of an army and at the point of a bayonet, and the liberties for which we had so severely struggled snatched from us in a moment. It remains a secret yet to be revealed whether this measure was not suggested, or at least countenanced, by some who have had great influence in the producing the present system. Fortunately indeed for this country, it had at the head of an army a patriot as well as a general, and many of our principal officers had not abandoned the characters of citizens by assuming that of soldiers, and therefore the scheme proved abortive. But are we to expect that this will always be the case? Are we so much better than the people of other ages and of other countries, that the same allurements of power and greatness which led them astray from their duty will have no influence upon men in our country? Such an idea is wild and extravagant. Had we indulged such a delusion, enough has appeared in a little time past to convince the most credulous that the passion for pomp, power, and greatness works as powerfully in the hearts of many of our better sort as it ever did in any country under heaven. Were the same opportunity again to offer, we should very probably be grossly disappointed if we made dependence that all who then rejected the overture would do it again. From these remarks, it appears that the evil to be feared from a large standing army in time of peace does not arise solely from the apprehension that the rulers may employ them for the purposes of promoting their own ambitious views, but that equal and perhaps greater danger is to be apprehended from their overturning the constitutional powers of the government and assuming the powers to dictate any form they please. The advocates for power in support of this right in the proposed government urge that a restraint upon the discretion of the legislatures in respect to military establishments in time of peace would be improper to be imposed, because, they say, it will be necessary to maintain small garrisons on the frontiers to guard against the depredation of the Indians and to be prepared to repel any encroachments or invasions that may be made by Spain or Britain. The amount of this argument, stripped of the abundant verbiages with which the author has dressed it, is this: it will probably be necessary to keep up a small body of troops to garrison a few posts, which it will be necessary to maintain in order to guard against the sudden encroachments of the Indians or of the Spaniards and British. And therefore the general government ought to be invested with power to raise and keep up a standing army in time of peace, without restraint, at their discretion. I confess, I cannot perceive that the conclusion follows from the premises. Logicians say, it is not good reasoning to infer a general conclusion from particular premises. Though I am not much of a logician, it seems to me that this argument is very like that species of reasoning. When the patriots in the Parliament in Great Britain contended with such force of argument and all the powers of eloquence against keeping up standing armies in time of peace, it is obvious they never entertained an idea that small garrison on the frontiers or in the neighborhood of powers from whom they were in danger of encroachments or guards to take care of public arsenals would thereby be prohibited. The advocates for this power farther urge that it is necessary because it may and probably will happen that circumstances will render it requisite to raise an army to be prepared to repel attacks of an enemy before a formal declaration of war, which in modern times has fallen into disuse. If the Constitution prohibited the raising an army until a war actually commenced, it would deprive the government of the power of providing for the defense of the country until the enemy were within our territory. If the restriction is not to extend to the raising armies in cases of emergency, but only to the keeping them up, this would leave the matter to the discretion of the legislature, and they might, under the pretense that there was danger of an invasion, keep up the army as long as they judged proper, and hence it is inferred that the legislature should have authority to raise and keep up an army without any restriction. But from these premises nothing more will follow than this, that the legislature should not be so restrained as to put it out of their power to raise an army when such exigencies as are instanced shall arise. But it does not thence follow that the government should be empowered to raise and maintain standing armies at their discretion, as well in peace as in war. If indeed it is impossible to vest the general government with the power of raising troops to garrison the frontier posts, to guard arsenals, or to be prepared to repel an attack, when we saw a power preparing to make one, without giving them a general and indefinite authority to raise and keep up armies without any restriction or qualification, then this reasoning might have weight. But this has not been proved, nor can it be. It is admitted that to prohibit the general government from keeping up standing armies, while yet they were authorized to raise them in case of exigency, would be an insufficient guard against the danger. A discretion of such latitude would give room to elude the force of the provision. It is also admitted that an absolute prohibition against raising troops, except in cases of actual war, would be improper, because it will be requisite to raise and support a small number of troops to garrison the important frontier posts and to guard arsenals, and it may happen that the danger of an attack from a foreign power may be so imminent as to render it highly proper we should raise an army in order to be prepared to resist them. But to raise and keep up forces for such purposes and on such occasions is not included in the idea of keeping up standing armies in times of peace. It is a thing very practicable to give the government sufficient authority to provide for these cases, and at the same time to provide a reasonable and competent security against the evil of a standing army. A clause to the following purpose would answer the end. As standing armies in time of peace are dangerous to liberty, and have often been the means of overturning the best constitutions of government, no standing army or troops of any description whatsoever shall be raised or kept up by the legislature, except so many as shall be necessary for guards to the arsenals of the United States, or for garrisons to such posts on the frontiers as shall be deemed absolutely necessary to hold, to secure the inhabitants, and to facilitate the trade with the Indians, unless when the United States are threatened with an attack or invasion from some foreign power, in which case the legislature shall be authorized to raise an army to be prepared to repel the attack, provided that no troops whatsoever shall be raised in time of peace, without the assent of 2/3 of the members comprising both houses of the legislature. A clause similar to this would afford sufficient latitude to the legislature to raise troops in all cases that were really necessary, and at the same time competent security against the establishment of that dangerous engine of despotism, a standing army. The same writer who advances the arguments I have noticed makes a number of other observations with a view to prove that the power to raise and keep up armies ought to be discretionary in the general legislature. Some of them are curious. He instances the raising troops in Massachusetts and Pennsylvania to show the necessity of keeping a standing army in time of peace. The least reflection must convince every candid mind that both these cases are totally foreign to his purpose. Massachusetts raised a body of troops for 6 months, at the expiration of which they were to disband, of course. This looks very little like a standing army. But beside, was that commonwealth in a state of peace at the time? So far from it that they were in the most violent commotions and contents, and their legislature had formally declared that an unnatural rebellion existed within the state. The situation of Pennsylvania was similar. A number of armed men had levied war against the authority of the state and openly avowed their intention of withdrawing their allegiance from it. To what purposes examples are brought of states raising troops for short periods in times of war or insurrections on a question concerning the propriety of keeping up standing armies in times of peace, the public must judge. It is farther said that no danger can arise from this power being lodged in the hands of the general government, because the legislatures will be a check upon them to prevent their abusing it. This is offered, as what force there is in it will hereafter receive a more particular examination. At present I shall only remark that it is difficult to conceive how the state legislatures can, in any case, hold a check over the general legislature in a constitutional way. The latter has, in every instance to which their powers extend, complete control over the former. The state legislatures can in no case, by law, resolution, or otherwise, of right prevent or impede the general government from enacting any law or executing it which this Constitution authorizes them to enact or execute. If, then, the state legislatures check the general legislatures, it must be by exciting the people to resist constitutional laws. In this way, every individual or every body of men may check any government in proportion to the influence they may have over the body of the people. But such kinds of checks as these, though they sometimes correct the abuses of government, oftener destroy all government. It is further said that no danger is to be apprehended from the exercise of this power, because it is lodged in the hands of representatives of the people. If they abuse it, it is in the power of the people to remove them and choose others who will pursue their interests. Not to repeat what has been said before, that it is unwise in any people to authorize their rulers to do what, if done, would prove injurious. I have in some former numbers shown that the representation in the proposed government will be a mere shadow without the substance. I am so confident that I am well founded in this opinion, that I am persuaded, if it was to be adopted or rejected, upon fair discussion of its merits, without taking into contemplation circumstances extraneous to it, as reasons for its adoption, 19/20 of the sensible men in the Union would reject it on this account alone, unless its powers were confined to much fewer objects than it embraces. Brutus. End Anti-Federalist Papers, Section 30, Brutus, Letter 10. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit librivox.org. The Anti-Federalist Papers. Anti-Federalist Papers, Section 31, Brutus, Letter 11. Read by M.L. Cohen. Cleveland, Ohio, 2007. 31 January, 1788. The nature and extent of the judicial power of the United States, proposed to be granted by this Constitution, claims our particular attention. Much has been said and written upon the subject of this new system on both sides, but I have not met with any writer who has discussed the judicial powers with any degree of accuracy. And yet it is obvious that we can form but very imperfect ideas of the manner in which this government will work, or the effect it will have in changing the internal police and mode of distributing justice at present subsisting in the respective states, without a thorough investigation of the powers of the judiciary and of the manner in which they will operate. This government is a complete system, not only for making, but for executing laws. And the courts of law, which will be constituted by it, are not only to decide upon the Constitution and the laws made in pursuance of it, but by officers subordinate to them to execute all their decisions. The real effect of this system of government will therefore be brought home to the feelings of the people through the medium of the judicial power. It is, moreover, of great importance to examine with care the nature and extent of the judicial power, because those who are to be vested with it are to be placed in a situation altogether unprecedented in a free country. They are to be rendered totally independent, both of the people and the legislature, both with respect to their offices and salaries. No errors they may commit can be corrected by any power above them, if any such powers there be, nor can they be removed from office for making ever so many erroneous adjudications. The only causes for which they can be displaced is conviction of treason, bribery, and high crimes and misdemeanors. This part of the plan is so modeled as to authorize the courts not only to carry into execution the powers expressly given, but where these are wanting or ambiguously expressed, to supply what is wanting by their own decisions. That we may be enabled to form a just opinion on this subject, I shall, in considering it, first, examine the nature and extent of the judicial powers, and second, inquire whether the courts who are to exercise them are so constituted as to afford reasonable ground of confidence that they will exercise them for the general good. With regard to the nature and extent of the judicial powers, I have to regret my want of capacity to give that full and minute explanation of them that the subject merits. To be able to do this, a man should be possessed of a degree of law knowledge far beyond what I pretend to. A number of hard words and technical phrases are used in this part of the system, about the meaning of which gentlemen learned in the law differ. Its advocates know how to avail themselves of these phrases. In a number of instances where objections are made to the powers given to the judicial, they give such an explanation to technical terms as to avoid them. Though I am not competent to give a perfect explanation of the powers granted to this department of government, I shall yet attempt to trace some of the leading features of it, from which I presume it will appear that they will operate to a total subversion of the state judiciaries, if not to the legislative authority of the states. In Article 3rd, Section 2nd, it is said, quote, "The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority," etc. End quote. The first article to which this power extends is, "all cases in law and equity arising under this Constitution." What latitude of construction this clause should receive, it is not easy to say. At first view, one would suppose that it meant no more than this, that the courts under the general government should exercise not only the power of courts of law, but also that of courts of equity, in the manner in which those powers are usually exercised in the different states. But this cannot be the meaning, because the next clause authorizes the courts to take cognizance of all cases in law and equity arising under the laws of the United States. This last article, I conceive, conveys as much power to the general judicial as any of the state courts possess. The cases arising under the Constitution must include such as bring into question its meaning, and will require an explanation of the nature and extent of the powers of the different departments under it. This article, therefore, vests the judicial with the power to resolve all questions that may arise on any case on the construction of the Constitution, either in law or in equity. First, they are authorized to determine all questions that may arise upon the meaning of the Constitution in law. This article vests the courts with authority to give the Constitution a legal construction, or to explain it according to the rules laid down for construing a law. These rules give a certain degree of latitude of explanation. According to this mode of construction, the courts are to give such meaning to the Constitution as comports best with the common, and generally receive acceptation of the words in which it is expressed, regarding their ordinary and popular use, rather than their grammatical propriety. Where words are dubious, they will be explained by the context. The end of the clause will be attended to, and the words will be understood as having a view to it, and the words will not be so understood as to bear no meaning or a very absurd one. Second, the judicial are not only to decide questions arising upon the meaning of the Constitution and law, but also in equity. By this, they are empowered to explain the Constitution according to the reasoning spirit of it, without being confined to the words or letter. Quote, "From this method of interpreting laws," says Blackstone, "by the reason of them, arises what we call equity," which is thus defined by Grotius, "the correction of that wherein the law, by reason of its universality, is deficient." For since in all laws all cases cannot be foreseen or expressed, it is necessary that when the decrees of the law cannot be applied to particular cases, there should be some where be a power vested of defining those circumstances, which, had they been foreseen, the legislator would have expressed, and these are the cases which, according to Grotius, "lex non exact definit, sed arbitraro boni viram permitted." The same learned author observes, "that equity thus depending essentially upon each individual case, there can be no established rules and fixed principle of equity laid down, without destroying its very essence and reducing it to a positive law." From these remarks, the authority and business of the courts of law under this clause may be understood. They will give the sense of every article of the Constitution that may from time to time come before them, and in their decisions they will not confine themselves to any fixed or established rules, but will determine, according to what happens to them, the reason and spirit of the Constitution. The opinions of the Supreme Court, whatever they may be, will have the force of law, because there is no power provided in the Constitution that can correct their errors or control their adjudications. From this court there is no appeal. And I conceive the legislature themselves cannot set aside a judgment of this court, because they are authorized by the Constitution to decide in the last resort. The legislature must be controlled by the Constitution, and not the Constitution by them. They have, therefore, no more right to set aside any judgment pronounced upon the construction of the Constitution than they have to take from the President the chief command of the Army and Navy and commit it to some other person. The reason is plain. The judicial and the executive derive their authority from the same source, that the legislature do theirs, and therefore in all cases, where the Constitution does not make the one responsible to or controllable by the other, they are altogether independent of each other. The judicial power will operate to effect, in the most certain but yet silent and imperceptible manner, what is evidently the tendency of the Constitution. I mean, an entire subversion of the legislature, executive, and judicial powers of the individual states. Every adjudication of the Supreme Court on any question that may arise upon the nature and extent of the general government will affect the limits of the state jurisdiction. In proportion as the former enlarge the exercise of their powers, will that of the latter be restricted. That the judicial power of the United States will lean strongly in favor of the general government, and will give such an explanation to the Constitution as will favor an extension of its jurisdiction, is very evident from a variety of considerations. First, the Constitution itself strongly countenances such a mode of construction. Most of the articles in the system which convey powers of any considerable importance are conceived in general and indefinite terms, which are either equivocal, ambiguous, or which require long definitions to unfold the extent of their meaning. The two most important powers committed to any government, those of raising money and of raising and keeping up troops, have already been considered and shown to be unlimited by anything but the discretion of the legislature. The clause which vests the power to pass all laws which are proper and necessary, to carry the powers given into execution, it has been shown, leaves the legislature at liberty to do everything which in their judgment is best. It is said, I know, that this clause confers no power on the legislature which they would not have had without it. Though I believe this is not the fact, yet admitting it to be, it implies that the Constitution is not to receive an explanation strictly according to its letter, but more power is implied than is expressed. And this clause, if it is to be considered as explanatory of the extent of the powers given, rather than giving a new power, is to be understood as declaring that in constructing any of the articles conveying power, the spirit and intent and design of the clause should be attended to, as well as the words in their common acceptation. The Constitution gives sufficient color for adopting an equitable construction, if we consider the great end and design it professedly has in view. These appear from its preamble to be, quote, to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and posterity. End quote. The design of this system is here expressed, and it is proper to give such meaning to the various parts as will best promote the accomplishment of the end. This idea suggests itself naturally upon reading the preamble, and will countenance the court in giving the several articles such a sense as will the most effectively promote the ends of the Constitution has in view. How this manner of explaining the Constitution will operate in practice shall be the subject of future inquiry. Second, not only will the Constitution justify the courts in inclining to this mode of explaining it, but they will be interested in using this latitude of interpretation. Every body of men invested with office are tenacious of power. They feel interested, and hence it has become a kind of maxim to hand down their offices with all its rights and privileges unimpaired to their successors. The same principle will influence them to extend their power and increase their rights. This of itself will operate strongly upon the courts to give such a meaning to the Constitution in all cases where it can possibly be done as will enlarge the sphere of their own authority. Every extension of the power of the general legislature, as well as the judicial powers, will increase the powers of the courts, and the dignity and importance of the judges will be in proportion to the extent and magnitude of the powers they exercise. I add, it is highly probable that the emolument of the judges will be increased, with the increase of the business they will have to transact and its importance. From these considerations, the judges will be interested to extend the powers of the courts, and to construe the Constitution as much as possible in such a way as to favor it, and that they will do that appears probable. Third, because they will have precedent to plead to justify them in it, it is well known that the courts of England have by their own authority extended their jurisdiction far beyond the limits set them in their original institution and by the laws of the land. The Court of Exchequer is a remarkable instance of this. It was originally intended principally to recover the king's debts and to order the revenues to the crown. It had a common law jurisdiction, which was established merely for the benefit of the king's accomplishments. We learn from Blackstone that the proceedings in this court are grounded on a writ called quo minus, in which a plaintiff suggests that he is the king's farmer or debtor, and the defendant hath done him the damage complained of, by which he is less able to pay the king. These suits, by the statute of Rutland, are expressly directed to be confined to such matters as specially concern the king or his ministers in the exchequer. And by the articuli supercartis, it is enacted that no common pleas be thenceforth held in the exchequer contrary to the form of the Great Charter. But now any person may sue in the exchequer, the surmise of being debtor to the king being matter of form, and mere words of course, and the court is open to all the nation. When the courts will have a precedent before them of a court which extended its jurisdiction in opposition to an act of legislature, is it not to be expected that they will extend theirs, especially when there is nothing in the Constitution expressly against it, and they are authorized to construe its meaning, and are not under any control? This power in the judicial will enable them to mold the government into almost any shape they please. The manner in which this may be effected, we will hereafter examine. Brutus. End Anti-Federalist Papers, Section 31, Brutus, Letter 11. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit librivox.org. Anti-Federalist Papers, Section 32, Brutus Letter 12. Read by M.L. Cohen, Cleveland, Ohio, May 2007. 7 February 1788. In my last, I showed that the judicial power of the United States under the first clause of the second section of Article 8 would be authorized to explain the Constitution, not only according to its letter, but according to its spirit and intention. And having this power, they would strongly incline to give it such a construction as to extend the powers of the general government as much as possible, to the diminution, and finally, to the destruction of that of the respective states. I shall now proceed to show how this power will operate in its exercise to effect these purposes. In order to perceive the extent of its influence, I shall consider, first, how it will tend to extend the legislative authority; second, in what manner it will increase the jurisdiction of the courts; and third, the way in which it will diminish and destroy both the legislative and judicial authority of the United States. First, let us inquire how the judicial power will effect an extension of the legislative authority. Perhaps the judicial power will not be able, by direct and positive decrees, ever to direct the legislature, because it is not easy to conceive how a question can be brought before them in a course of legal discussion in which they can give a decision declaring that the legislature have certain powers which they have not exercised, and which, in consequence of the determination of the judges, they will be bound to exercise. But it is easy to see that in their adjudications they may establish certain principles, which being received by the legislature will enlarge the sphere of their power beyond all bounds. It is to be observed that the Supreme Court has the power, in the last resort, to determine all questions that may arise in the course of legal discussion on the meaning and construction of the Constitution. This power they will hold under the Constitution and independent of the legislature. The latter can no more deprive the former of this right than either of them or both of them together can take from the President, with the advice of the Senate, the power of making treaties or appointing ambassadors. In determining these questions, the court must and will assume certain principles from which they will reason, in forming their decisions. These principles, whatever they may be, when they become fixed by a course of decisions, will be adopted by the legislature, and will be rule by which they will explain their own powers. This appears evident from this consideration, that if the legislature pass laws, which, in the judgment of the court, they are not authorized to do by the Constitution, the court will not take notice of them, for it will not be denied that the Constitution is the highest or supreme law, and the courts are vested with the supreme and uncontrollable power to determine in all cases that come before them what the Constitution means. They cannot, therefore, execute a law which in their judgment opposes the Constitution, unless we can suppose they can make a superior law give way to an inferior. The legislature, therefore, will not go over the limits by which the courts may adjudge they are confined, and there is little room to doubt but they will come up to those bounds as often as occasion and opportunity may offer, and they may judge it proper to do it. For as on the one hand they will not readily pass laws which they know the courts will not execute, so on the other, we may be sure, they will not scruple to pass such as they know they will give effect, as often as they may judge it proper. From these observations it appears that the judgment of the judicial on the Constitution will become the rule to guide the legislature in their construction of their powers. What the principles are which the courts will adopt it is impossible for us to say, but taking up the powers as I have explained them in my last number, which they will possess under this clause, it is not difficult to see that they may and probably will be very liberal ones. We have seen that they will be authorized to give the Constitution a construction according to its spirit and reason, and not to confine themselves to its letter. To discover the spirit of the Constitution, it is of first importance to attend to the principal ends and designs it has in view. These are expressed in the preamble, in the following words, that is, quote, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution," end quote, etc. If the end of the government is to be learned from these words, which are clearly designed to declare it, it is obvious that it has in view every object which is embraced by any government: the preservation of internal peace, the due administration of justice, and to provide for the defense of the community seem to include all the objects of government. But if they do not, they are certainly comprehended in the words, quote, "to provide for the general welfare," end quote. If it be further considered that this Constitution, if it is ratified, will not be a compact entered into by states in their corporate capacities, but an agreement of the people of the United States as one great body politic, no doubt can remain but that the great end of the Constitution, if it is to be collected from the preamble, in which its ends is declared, is to constitute a government which is to extend to every case for which any government is instituted, whether external or internal. The courts, therefore, will establish this as a principle in expounding the Constitution, and will give every part of it such an explanation as will give latitude to every department under it to take cognizance of every matter, not only that affects the general and national concerns of the Union, but also of such as relate to the administration of private justice, and to regulate the internal and local affairs of the different parts. Such a rule of exposition is not only consistent with the general spirit of the preamble, but it will stand confirmed by considering more minutely the different clauses of it. The first object declared to be in view is, quote, "to form a perfect union," end quote. It is to be observed, and it is not a union of the states or bodies corporate. Had this been the case, the existence of the state governments might have been secured. But it is a union of the people of the United States considered as one body, who are to ratify this Constitution if it is adopted. Now, to make a union of this kind perfect, it is necessary to abolish all inferior governments, and to give the general one complete legislative, executive, and judicial powers to every purpose. The courts, therefore, will establish it as a rule in explaining the Constitution to give it such construction as will best tend to perfect the Union or take from the state governments every power of either making or executing laws. The second object is "to establish justice." This must include not only the idea of instituting the rule of justice, or of making laws which shall be the measure of rule of right, but also of providing for the application of this rule, or of administering justice under it. And under this the courts will in their decisions extend the power of the government to all cases they possibly can, or otherwise they will be restricted in doing what appears to be the intent of the Constitution. They should do, to wit, pass laws and provide for the execution of them, for the general distribution of justice between man and man. Another end declared is "to ensure domestic tranquility." This comprehends a provision against all private breaches of the peace, as well as against all public commotions or general insurrections. And to attain the object of this clause fully, the government must exercise the power of passing laws on these subjects, as well as of appointing magistrates with authority to execute them. And the courts will adopt these ideas in their expositions. I might proceed to the other clause in the preamble, and it would appear by consideration of all of them separately, as it does in taking them together, that if the spirit of this system is to be known from its declared end and design in the preamble, its spirit is to subvert and abolish all powers of the state government, and to embrace every object to which any government extends. As it sets out in the preamble with this declared intention, so it proceeds in the different parts with the same idea. Any person who will peruse the 8th section with attention, in which most of the powers are enumerated, will perceive that they either expressly or by implication extend to almost everything about which any legislative power can be employed. But if this equitable mode of construction is applied to this part of the Constitution, nothing can stand before it. This will certainly give the first clause in that article a construction which I confess I think the most natural and grammatical one, to authorize Congress to do anything which in their judgment will tend to provide for the general welfare. And this amounts to the same thing as general and unlimited power of legislation in all cases. To be continued. 14 February 1788. Continued from last Thursday's paper. This same manner of explaining the Constitution will fix a meaning, and a very important one too, to the 18th clause of the same section, which authorizes Congress to make laws which shall be proper and necessary for carrying into effect the foregoing powers, etc. A voluminous writer in favor of this system has taken great pains to convince the public that this clause means nothing, for that the same powers expressed in this are implied in other parts of the Constitution. Perhaps it is so, but still, this will undoubtedly be an excellent auxiliary to assist the courts to discover the spirit and reason of the Constitution, and when applied to any and every other clauses granting power, will operate powerfully in extracting the spirit from them. I might instance a number of clauses in the Constitution, which, if explained in an equitable manner, would extend the powers of the government to every case, and reduce the state legislatures to nothing. But I should draw out my remarks to an undue length, and I presume enough has been said to show that the courts have sufficient ground in the exercise of this power to determine that the legislature have no bounds set to them by this Constitution, by any supposed right of the legislatures of the representative states may have to regulate any of their local concerns. I proceed, second, to inquire in what manner this power will increase the jurisdiction of the courts. I would here observe that the judicial power extends expressly to all civil cases that may arise save such as between citizens of the same state, with this exception to those of that description, that the judicial of the United States have cognizance of cases between citizens of the same state claiming land under grants of different states. Nothing more therefore is necessary to give the courts of law under this Constitution complete jurisdiction of all civil causes, but to comprehend cases between citizens of the same state not included in the foregoing exception. I presume there will be no difficulty in accomplishing this. Nothing more is necessary than to set forth in the process that the party who brings the suit is a citizen of a different state from the one against whom the suit be brought, and there can be little doubt but that the court will take cognizance of the matter, and if they do, who is to restrain them? Indeed, I will freely confess that it is my decided opinion that the courts ought to take cognizance of such causes under the powers of the Constitution, for one of the great ends of the Constitution is "to establish justice." This supposes that this cannot be done under the existing governments of the States, and there is certainly as good reason why individuals living in the same state should have justice as those who live in different states. Moreover, the Constitution expressly declares that "the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states." It will therefore be no fiction for a citizen of one state to set forth in a suit that he is a citizen of another, for he that is entitled to all the privileges and immunities of a country is a citizen of that country. And in truth, the citizen of one state will, under this Constitution, be a citizen of every state. But supposing that the party who alleges that he is a citizen of another state has recourse to fiction in bringing in a suit, it is well known that the courts have high authority to plead to justify them in suffering actions to be brought before them by such fictions. In my last number, I stated that the Court of Exchequer tried all cases in virtue of such a fiction. The Court of King's Bench in England extended their jurisdiction in the same way. Originally, this court held pleas in civil cases, only of trespass and other injuries alleged to be committed vi et armis. They might likewise, says Blackstone, upon the division of the alla regia, have originally held pleas of any other civil action whatsoever (except in real actions, which are now very seldom in use), provided the defendant was an officer of the court, or in the custody of the marshal or prison keeping of the court for breach of the peace, etc. In process of time, by a fiction, this court began to hold pleas of any personal action whatsoever, it being surmised that the defendant has been arrested for supposed trespass that "he has never committed," and being thus in the custody of the marshal of the court, the plaintiff is at liberty to proceed against him for any other personal injury, which surmise of being in the marshal's custody the defendant is not at liberty to dispute. By a much less fiction may the pleas of the courts of the United States extend to cases between citizens of the same state. I shall add no more on this head, but proceed briefly to remark in what way this power will diminish and destroy both the legislative and judicial authority of the States. It is obvious that these courts will have authority to decide upon the validity of the laws of any of the States in all cases where they come in question before them. Where the Constitution gives the general government exclusive jurisdiction, they will adjudge all laws made by the States in such cases void ab initio. Where the Constitution gives them concurrent jurisdiction, the laws of the United States must prevail, because they are the supreme law. In such cases, therefore, the law of the State legislatures must be repealed, restricted, or so construed as to give full effect to the laws of the Union on the same subject. From these remarks it is easy to see that in proportion as the general government acquires power and jurisdiction by the liberal construction which the judges may give to the Constitution, will those of the States lose its rights until they become so trifling and unimportant as not to be worth having. I am much mistaken if this system will not operate to effect this with as much celerity as those who have the administration of it will think prudent to suffer it. The remaining objections to the judicial power shall be considered in a future paper. Brutus. End of Anti-Federalist Papers, Section 32, Brutus, Letter 12. Anti-Federalist Papers, Section 33, Brutus, Letter 13. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by M.L. Cohen, Cleveland, Ohio, May 2007. 21 February 1788. Having in the two preceding numbers examined the nature and tendency of the judicial power as it respects the explanation of the Constitution, I now proceed to the consideration of the other matters of which it has cognizance. The next paragraph extends its authority to all cases in law and equity arising under the laws of the United States. This power, as I understand it, is a proper one. The proper province of the judicial power in any government is, as I conceive, to declare what is the law of the land, to explain and enforce those laws, which is the supreme power a legislature may pass, but not to declare what the powers of the legislature are. I suppose the cases in equity under the laws must be so construed as to give the Supreme Court not only a legal, but equitable jurisdiction of cases which may be brought before them, or in other words, so as to give them not only the powers which are now exercised by our courts of law, but those also which are now exercised by our court of chancery. If this be the meaning, I have no other objection to the power than what arises from the undue extension of the legislative power. For I conceive that the judicial powers should be commensurate with the legislative, or in other words, the Supreme Court should have authority to determine questions arising under the laws of the Union. The next paragraph, which gives the power to decide the law and equity on all cases arising under treaties, is unintelligible to me. I can readily comprehend what is meant by deciding a case under a treaty. For as treaties will be the law of the land, every person who has rights or privileges secured by treaty will have aids of courts of law in recovering them. But I do not understand what is meant by equity arising under a treaty. I presume every right which can be claimed under a treaty must be claimed by virtue of some article or clause contained in it, which gives the right in plain and obvious words, or at least I conceive that the rules for explaining treaties are so well ascertained that there is no need of having recourse to an equitable construction. If under this power the courts are to explain treaties according to what they conceive are their spirit, which is nothing less than a power given them whatever extension they may judge proper, it is a dangerous and improper power. The cases affecting ambassadors, public ministers, and consuls, of admiralty and maritime jurisdiction, controversies to which the United States are a party, and controversies between states, it is proper should be under the cognizance of the courts of the Union, because none but the general government can or ought to pass laws on their subject. But I conceive the clause which extends the power of the judicial to controversy arising between a state and the citizens of another state improper in itself, and will, in its exercise, prove most pernicious and destructive. It is improper because it subjects the state to answer in a court of law to the suit of an individual. This is humiliating and degrading to a government, and what I believe the supreme authority of no state ever submitted to. The states are now subject to no such actions. All contracts entered into by individuals with states were made upon the faith and credit of the states, and the individuals never had in contemplation any compulsory mode of obliging the government to fulfill its engagements. The evil consequences that will flow from the exercise of this power will best appear by tracing it in its operation. The Constitution does not direct the mode in which an individual shall commence a suit against a state or the manner in which the judgment of the court shall be carried into execution, but it gives the legislature full power to pass all laws which shall be proper and necessary for the purpose. And they certainly must make provision for these purposes, or otherwise the power of the judicial will be nugatory. For to what purpose will the power of the judicial be if they have no mode in which they can call the parties before them? Or of what use will it be to call the parties to answer, if after they have given judgment there is no authority to execute the judgment? We must therefore conclude that the legislature will pass laws which will be effectual in this head. An individual of one state will then have a legal remedy against the state for any demand he may have against the state to which he does not belong. Every state in the Union is largely indebted to individuals. For the payment of these debts they have been given notes payable to the bearer. At least this is the case in this state. Whenever a citizen of another state becomes possessed of one of these notes, he may commence an action in the Supreme Court of the general government, and I cannot see any way in which he can be prevented from recovering. It is easy to see that when this once happens, the notes of the state will pass rapidly from the hands of the citizens of the state to those of other states. And when the citizens of other states possess them, they may bring suits against the state for them, and by this means judgments and executions may be obtained against the state for the whole amount of the state debt. It is certain the state, with the utmost exertions it can make, will not be able to discharge the debt she owes under a considerable number of years. Perhaps with the best management it will require 20 or 30 years to discharge it. This new system will protract the time in which the ability of the state will enable them to pay off their debt, because all the funds of the state will be transferred to the general government, except those which arise from internal taxes. The situation of the states will be deplorable. By this system they will surrender to the general government all the means of raising money, and, at the same time, will subject themselves to suits at law for the recovery of the debts they have contracted in effecting the revolution. The debts of the individual states will amount to a sum exceeding the domestic debt of the United States. These will be left upon them, with power in the judicial of the general government to enforce their payment, while the general government will possess an exclusive command of the most productive funds from which the states can derive money, and a command of every other source of revenue paramount to the authority of any state. It may be said that the apprehension that the judicial power will operate in this manner is merely visionary, for that the legislature will never pass laws that will work these effects; or, if they were disposed to do it, they cannot provide for levying an execution on a state, for where will the officer find property whereon to levy? To this I would reply, if this is a power which will not or cannot be executed, it was useless and unwise to grant it to the judicial. For what purpose is a power given which it is imprudent or impossible to exercise? If it be improper for a government to exercise a power, it is improper that they should be vested with it, and it is unwise to authorize a government to do what they cannot effect. As to the idea that the legislature cannot provide for levying an execution on a state, I believe it is not well founded. I presume the last paragraph of the 8th section of Article 1 gives the Congress express power to pass any laws they may judge proper and necessary for carrying into execution the power vested in the judicial department. And they must exercise this power, or otherwise the courts of justice will not be able to carry into effect the authorities with which they are invested. For the Constitution does not direct the mode in which the courts are to proceed, to bring parties before them, to try causes, or to carry the judgment of the courts into execution. Unless they are pointed out by law, how are these to proceed in any of the cases of which they have cognizance? They have the same authority to establish regulations in respect to these matters, where a state is a party, as where an individual is a party. The only difficulty is, on whom shall process be served, when a state is a party, and how shall execution be levied? With regard to the first, the way is easy. Either the executive or legislative of the state may be notified, and upon proof being made of the services of the notice, the court may proceed to a hearing of the cause. Execution may be levied on any property of the state, either real or personal. The treasury may be seized by the officers of the general government, or any lands the property of the state may be made the subject and seizure and sale to satisfy any judgment against it. Whether the estate of any individual citizen may not be made answerable for the discharge of judgments against the state may be worth consideration. In some corporations this is the case. If the power of the judicial under this clause will extend to the cases above stated, it will, if executed, produce the utmost confusion, and in its progress will crush the states beneath its weight. And if it does not extend to these cases, I confess myself utterly at a loss to give it any meaning. For if the citizen of one state, possessed of a written obligation given in pursuance of a solemn act of the legislature, acknowledging a debt due to the bearer and promising to pay it, cannot recover in the Supreme Court, I can conceive of no case in which they can recover. And it appears to me ridiculous to provide for obtaining judgment against the state without giving the means of levying execution. Brutus. End Anti-Federalist Paper, Section 33. Anti-Federalist Papers, Section 34, Brutus, Letter 14. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Reading by M.L. Cohen, Cleveland, Ohio, June 2007. 28 February, 1788.
The second paragraph of Section 2D, Article 3 is in these words, quote, "In all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make." End quote. Although it is proper that the courts of the general government should have cognizance of all matters affecting ambassadors, foreign ministers, and councils, yet I question much the propriety of giving the Supreme Court original jurisdiction in all cases of this kind. Ambassadors and other public ministers claim and are entitled by the law of nations to certain privileges and exemptions both for their persons and their servants. The meanest servant of an ambassador is exempted by the law of nations from being sued for debt. Should a suit be brought against such an one by a citizen, though inadvertency or want of information, he will be subject to an action in the Supreme Court. All the officers concerned in issuing or executing a process will be liable to like actions. Thus may a citizen of a state be compelled, at great expense and inconveniency, to defend himself against the suit brought against him in the Supreme Court, for inadvertently commencing an action against the most menial servant of an ambassador for a just debt. The appellate jurisdiction granted to the Supreme Court in this paragraph has justly been considered as one of the most objectionable parts of the Constitution. Under this power, appeals may be had from the inferior courts to the Supreme in every case to which the judicial power extends, except in the few instances in which the Supreme Court will have original jurisdiction. By this article, appeals will lie to the Supreme Court in all criminal as well as civil causes. This, I know, has been disputed by some, but I presume the point will appear clear to anyone who will attend to the connection of this paragraph with the one that precedes it. In the former, all the cases to which the power of the judicial shall extend, whether civil or criminal, are enumerated. There is no criminal matter to which the judicial power of the United States will extend, but such as are included under some one of the cases specified in this section. For this section is intended to define all the cases of every description to which the power of the judicial shall reach. But in all these cases it is declared the Supreme Court shall have appellate jurisdiction, except in those which affect ambassadors, other public ministers and councils, and those in which the state shall be a party. If, then, this section extends the power of the judicial to criminal cases, it allows appeals in such cases. If the power of the judicial is not extended to criminal matters by this section, I ask, by what part of the system does it appear that they have any cognizance of them? I believe it is a new and unusual thing to allow appeals in criminal matters. It is contrary to the sense of our laws, and dangerous to the lives and liberties of the citizens. As our law now stands, a person charged with a crime has a right to a fair and impartial trial by jury of his country, and the verdict is final. If he is acquitted, no other court can call upon him to answer for the same crime. But by this system, a man may have had ever so fair a trial, have been acquitted by ever so respectable a jury of his country, and still the officer of the government who prosecutes may appeal to the Supreme Court. The whole matter may have a second hearing. By this means, persons who may have disobliged those who execute the general government may be subjected to intolerable oppression. They may be kept in long and ruinous confinement, and exposed to heavy and insupportable charges, to procure the attendance of witnesses and provide the means of their defense, at a great distance from their places of residence. I can scarcely believe that there can be a considerate citizen of the United States that will approve of this appellate jurisdiction as extending to criminal cases, if they will give themselves time for reflection. Whether the appellate jurisdiction as it respects civil matters will not prove injurious to the rights of citizens and destructive of those privileges which have ever been held sacred by Americans, and whether it will not render the administration of justice intolerably burdensome, intricate, and dilatory, will best appear when we have considered the nature and operation of this power. It has been the fate of this clause, as it has of most of those against which unanswerable objections have been offered, to be explained in different ways by the advocates and opponents of the Constitution. I confess I do not know what the advocates of the system would make it mean, for I have not been fortunate enough to see in any publication this clause taken up and considered. It is certain, however, they do not admit the explanation which those who oppose the Constitution give it, or otherwise they would not so frequently charge them with want of candor, for alleging that it takes away the trial by jury. Appeals from an inferior to a superior court, as practiced in the civil law courts, are well understood. In these courts, the judges determine both on the law and the fact, and appeals are allowed from the inferior to the superior courts on the whole merits. The superior tribunal will re-examine all the facts as well as the law, and frequently new facts will be introduced, so as many times to render the cause in the Court of Appeals very different from what it was in the court below. If the appellate jurisdiction of the Supreme Court be understood in the above sense, the term is perfectly intelligible. The meaning then is, that in all civil causes enumerated, the Supreme Court shall have authority to re-examine the whole merits of the case, both with respect to the facts and the law which may arise under it, without the intervention of a jury. That this is the sense of the part of the system appears to me clear from the express words of it, "In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, etc." Who are the Supreme Court? Does it not consist of the judges? And they are to have the same jurisdiction of the fact as they are to have of the law. They will therefore have the same authority to determine the fact as they will have to determine the law, and no room is left for a jury on appeals to the Supreme Court. If we understand the appellate jurisdiction in any other way, we should be left utterly at a loss to give it a meaning. The common law is a stranger to any such jurisdiction. No appeals can lie from any of our common law courts upon the merits of the case. The only way in which they can go up from an inferior to a superior tribunal is by habeas corpus before a hearing, or by certiorari or writ of error, or after they are determined in the subordinate courts. But in no case where they are carried up are the facts re-examined, but they are always taken as established in the inferior courts. Continued, 6 March, 1788. It may still be insisted that this clause does not take away the trial by jury on appeals, but that this may be provided for by the legislature, under that paragraph, which authorizes them to form regulations and restrictions for the court in the exercise of this power. The natural meaning of this paragraph seems to be no more than this, that Congress may declare that certain cases shall not be subject to the appellate jurisdiction, and they may point out the mode in which the court shall proceed in bringing up the causes before them, the manner of their taking evidence to establish the facts, and the methods of the court's proceeding. But I presume they cannot take from the court the right of deciding on the fact, any more than they can deprive them of the right of determining on the law, when a cause is once before them, for they have the same jurisdiction as the fact as they have as to law. But supposing the Congress may under this clause establish the trial by jury on appeals, it does not seem to me that it will render this article much less exceptionable. An appeal from one court and jury to another court and jury is a thing altogether unknown in the laws of our state and in most of the states in the Union. A practice of this kind prevails in the Eastern states. Actions are there commenced in the inferior courts, and an appeal lies from them on the whole merits to the superior courts. The consequence is well known. Very few actions are determined in the lower courts. It is rare that a case of any importance is not carried by appeal to the Supreme Court, and the jurisdiction of the inferior courts is merely nominal. This has proved so burdensome to the people in Massachusetts that it was one of the principal causes which excited the insurrection in that state in the year past. Very few sensible and moderate men in that state but what will admit that the inferior courts are almost entirely useless, and answer very little purpose save only to accumulate costs against the poor debtors who are already unable to pay their just debts. But the operation of the appellate power in the Supreme Judicial of the United States would work infinitely more mischief than any such power can do in a single state. The trouble and expense to the parties would be endless and intolerable. No man can say where the Supreme Court are to hold their sessions. The presumption is, however, that it must be at the seat of the general government. In this case, parties must travel many hundred miles, with their witnesses and lawyers, to prosecute or defend a suit. No man of middling fortune can sustain the expense of such a lawsuit, and therefore the poor and middling classes of citizens will be under the necessity of submitting to the demands of the rich and the lordly, in cases that will come under the cognizance of this court. If it be said that to prevent this oppression the Supreme Court will set in different parts of the Union, it may be replied that this would only make the oppression somewhat more tolerable, but by no means so much as to give a chance to do justice to the poor and middling classes. It is utterly impossible that the Supreme Court can move into so many different parts of the Union as to make it convenient or even tolerable to attend before them with witnesses to try causes from every part of the United States. If to avoid the expense and inconvenience of calling witnesses from great distance to give evidence before the Supreme Court, the expedient of taking the deposition of witnesses in writing should be adopted, it would not help the matter. It is of great importance in the distribution of justice that witnesses should be examined face to face, that the parties should have the fairest opportunity of cross-examining them in order to bring out the whole truth. There is something in the manner in which witness delivers his testimony which cannot be committed to paper, and which yet very frequently gives a complexion to his evidence, very different from what it would bear if committed to writing. Besides, the expense of taking written testimony would be enormous. Those who are acquainted with the costs that arise in the courts where all the evidence is taken in writing, well know that they exceed beyond all comparison those of the common law courts, where witnesses are examined viva voce. The costs accruing in courts generally advance with the greater the court. Thus the charges attending to a suit in our common pleas is much less than those in the Supreme Court, and these are much lower than those in the Court of Chancery. Indeed, the costs in the last mentioned court are in many cases so exorbitant and the proceedings so dilatory that the suitor has almost well given up his demand as to prosecute his suit. We have just reason to suppose that the costs in the Supreme General Court will exceed either of our courts. The officers of the General Court will be more dignified than those of the States, the lawyers of the most ability will practice in them, and the trouble and expense of attending them will be greater. From all these considerations it appears that the expense attending suits in the Supreme Court will be so great as to put it out of the power of the poor and middling classes of citizens to contest a suit in it. From these remarks it appears that the administration of justice under the powers of the judicial will be dilatory, that it will be attended with such a heavy expense as to amount to little short of a denial of justice to the poor and middling class of people who in every government stand most in need of the protection of the law, and that the trial by jury, which has so justly been the boast of our forefathers as well as ourselves, is taken away under them. These extraordinary powers in this court are the more objectionable because there does not appear the least necessity for them in order to secure a due and impartial distribution of justice. The want of ability or integrity, or a disposition to render justice to every suitor, has not been objected against the courts of the respective States. So far as I have been informed, the courts of justice in all the States have ever been found ready to administer justice with promptitude and impartiality according to the laws of the land. It is true in some of the States paper money has been made, and the debtor authorized to discharge his debts with it at a depreciated value. In others, tender laws have been passed, obliging the creditor to receive on execution other property than money in discharge of his demand, and in several of the stated laws have been made unfavorable to the creditor and tending to render property insecure. But these evils have not happened from any defect in the judicial departments of the States. The courts, indeed, are bound to take notice of these laws, and so will the courts of the general government be under obligation to observe the laws made by the general legislature, not repugnant to the Constitution, but so far have the judicial been from giving undue latitude of construction to the laws of this kind that they have invariably strongly inclined to the other side. All the acts of our legislature, which have been charged with being of this complexion, have uniformly received the strictest construction by the judges, and have been extended to no cases but to such as came within the first letter of the law. In this way have our courts, I will not say evaded the law, but so limited in its operation as to work the least possible injustice. The same thing has taken place in Rhode Island, which has just rendered herself infamous by her tenaciously adhering to her paper money system. The judges there gave a decision in opposition to the words of the statute on this principle, that a construction according to the words of it would contradict the fundamental maxim of their laws and constitution. No pretext, therefore, can be formed from the conduct of the judicial courts which will justify giving such powers to the Supreme General Court for their decisions have been such as to give just ground of confidence in them, that they will firmly adhere to the principles of rectitude, and there is no necessity of lodging these powers in the courts in order to guard against the evils justly complained of on the subject of security of property under this Constitution. For it has provided, that no state shall emit bills of credit or make anything but gold and silver coin a tender for payment of debts. It is also declared that no state shall pass any law impairing the obligation of contracts. These prohibitions give the most perfect security against those attacks upon property which I am sorry to say some of the states have but too wantonly made, by passing laws sanctioning fraud in the debtor against his creditor. For this Constitution will be the supreme law of the land, and the judges in every state will be bound thereby, anything in the Constitution and laws of any state to the contrary notwithstanding. The courts of the respective states might therefore have been securely trusted with deciding all cases between man and man, whether citizens of the same state or of different states, or between foreigners and citizens, and indeed for aught I see every case that can arise under the Constitution or laws of the United States ought in the first instance be tried in the court of the state, except those which might arise between states, such as respect ambassadors or other public ministers, and perhaps such as call in question the claim of land under grants from different states. The state courts would be under sufficient control if writs of error were allowed from the state courts to the Supreme Court of the Union, according to the practice of the courts in England and of this state, on all cases in which the laws of the Union are concerned, and perhaps all cases in which a foreigner is a party. This method would preserve the good old way of administering justice, would bring justice to every man's door, and preserve the inestimable right of trial by jury. It would be following, as near as the circumstances will admit, to the practice of the courts in England, which is almost the only thing I would wish to copy in their government. But as this system now stands, there is to be as many inferior courts as Congress may seem fit to appoint, who are to be authorized to originate and in the first instance to try all the cases falling under the description of this article. There is no security that a trial by jury shall be had in these courts, but the trial here will soon become, as it is in Massachusetts inferior courts, mere matter of form, for an appeal may be had to the Supreme Court on the whole merits. This court is to have power to determine in law and in equity, on the law and the fact, and this court is exalted above all other power in the government, subject to no control, and so fixed as not to be removable but upon impeachment, which I shall hereafter show is much the same thing as not to be removable at all. To obviate the objections made to the judicial power, it has been said that Congress, in forming the regulations and exceptions which they are authorized to make respecting the appellate jurisdiction, will make provision against all the evils which are apprehended from this article. On this I would remark, that this way of answering the objection made to that power implies an admission that the power is in itself improper without restraint, and if so, why not restrict it in the first instance? The just way of investigating any power given to a government is to examine its operation supposing it be put in exercise. If upon enquiry it appears the power if exercised would be prejudicial, it ought not to be given. For to answer objections made to a power given to a government by saying it will never be exercised is really admitting that the power ought not to be exercised and therefore ought not to be granted. Brutus. End Anti-Federalist Papers, Section 34, Brutus, Letter 14.
This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit librivox.org. The Anti-Federalist Papers, Section 35, Brutus Letter 15, read by M.L. Cohen, Cleveland, Ohio, May 2007. I said in my last number that the Supreme Court under this Constitution would be exalted above all other power in the government and subject to no control. The business of this paper
will be to illustrate this and to show the danger that will result from it. I question whether the world ever saw in any period of it a court of justice invested with such immense powers, and yet placed in a situation so little responsible. Certain it is that in England, and in the several states where we have been taught to believe, the courts of law are put upon the most prudent establishment, they are on a very different footing. The judges in England, it is true, hold their offices during their good behavior, but then their determinations are subject to correction by the House of Lords, and their power is by no means so extensive as that of the proposed Supreme Court of the Union. I believe they in no instance assume the authority to set aside an act of Parliament under the idea that it is inconsistent with their Constitution. They consider themselves bound to decide according to the existing laws of the land, and never undertake to control them by adjudging that they are inconsistent with the Constitution. Much less are they vested with the power of giving an equitable construction to the Constitution. The judges in England are under the control of the legislature, for they are bound to determine according to the laws passed by them. But the judges under this Constitution will control the legislature, for the Supreme Court are authorized in the last resort to determine what is the extent of the powers of the Congress. They are to give the Constitution an explanation, and there is no power above them to set aside their judgment. The framers of this Constitution appear to have followed that of the British in rendering the judges independent by granting them their offices during good behavior, without following the Constitution of England in instituting a tribunal in which their errors may be corrected, and without adverting to this, that the judicial under this system have a power which is above the legislative, and which indeed transcends any power before given to a judicial by any free government under heaven. I do not object to the judges holding their commissions during good behavior. I suppose it is a proper provision, provided they were made properly responsible. But I say, this system has followed the English government in this, while it has departed from almost every other principle of their jurisprudence, under the idea of rendering the judges independent, which in the British Constitution means no more than they hold their places during good behavior and have fixed salaries. They have made the judges independent in the fullest sense of the word. There is no power above them to control any of their decisions. There is no authority that can remove them, and they cannot be controlled by the laws of the legislature. In short, they are independent of the people, of the legislature, and of every power under heaven. Men placed in this situation will generally soon feel themselves independent of heaven itself. Before I proceed to illustrate the truth of these assertions, I beg liberty to make one remark. Though in my opinion the judges ought to hold their offices during good behavior, yet I think it is clear that the reasons in favor of this establishment of the judges of England do by no means apply to this country. The great reason assigned why the judges in Britain ought to be commissioned during good behavior is this, that they may be placed in a situation not to be influenced by the crown to give such decisions as would tend to increase its powers and prerogatives. While the judges held their place at the will and pleasure of the king, on whom they depended not only for their offices but also for their salaries, they were subject to every undue influence. If the crown wished to carry a favorite point to accomplish which the aid of the courts of law was necessary, the pleasure of the king would be signified to the judges, and it required the spirit of a martyr for the judges to determine contrary to the king's will. They were absolutely dependent upon him both for their offices and livings. The king, holding his office during life and transmitting it to his posterity as an inheritance, has much stronger inducements to increase the prerogatives of his office than those who hold their offices for stated periods, or even for life. Hence the English nation gained a great point in favor of liberty. When they obtained the appointment of judges during good behavior, they got from the crown a concession,
which deprived it of one of the most powerful engines with which it might enlarge the boundaries of the royal prerogative and encroach on the liberties of the people. But these reasons do not apply to this country. We have no hereditary monarch. Those who appoint the judges do not hold their offices for life, nor do they descend to their children. The same arguments, therefore, which will conclude in favor of the tenor of the judges' offices for good behavior, lose a considerable part of their weight when applied to the state and condition of America. But much less can it be shown that the nature of our government requires that the courts should be placed beyond all account more independent, so much so as to be above control. I have said that the judges under this system will be independent in the strict sense of the word. To prove this, I will show that there is no power above them that can control their decisions or correct their errors. There is no authority that can remove them from office for any errors or want of capacity, or lower their salaries, and in many cases, their power is superior to that of the legislature. First, there is no power above them that can correct their errors or control their decisions. The adjudications of this court are final and irreversible, for there is no court above them to which appeals can lie either in error or on the merits. In this respect, it differs from the courts in England, for there the House of Lords is the highest court, to whom appeals in error are carried from the highest of the courts of law. Second, they cannot be removed from office or suffer a diminution in their salaries for any error in judgment or want of capacity. It is expressly declared by the Constitution, quote, that they shall at stated times receive a compensation for their services, which shall not be diminished during their continuance in office. End quote. The only clause in the Constitution which provides for the removal of the judges from office is that which declares that, quote, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and convictions of treason, bribery, or other high crimes and misdemeanors. End quote. By this paragraph, civil officers, in which the judges are included, are removable only for crimes. Treason and bribery are named, and the rest are included under the general terms of high crimes and misdemeanors. Errors in judgment or want of capacity to discharge the duties of the office can never be supposed to be included in the words high crimes and misdemeanors. A man may mistake a case in giving judgment, or manifest that he is incompetent to the discharge of the duties of a judge, and yet give no evidence of corruption or want of integrity. To support the charge, it will be necessary to give in evidence some facts that will show that the judges committed the error from wicked and corrupt motives. Third, the power of this court is in many cases superior to that of the legislature. I have showed in a former paper that this court will be authorized to decide upon the meaning of the Constitution, and that not only according to the natural and obvious meaning of the words, but also according to the spirit and intention of it. In the exercise of this power, they will not be subordinate to, but above the legislature. For all the departments of this government will receive their powers, so far as they are expressed in the Constitution, from the people immediately, who are the source of power. The legislature can only exercise such powers as are given them by the Constitution. They cannot assume any of the rights annexed to the judicial, for this plain reason, that the same authority which vested the legislature with their powers vested the judicial with theirs. Both are derived from the same source. Both, therefore, are equally valid, and the judicial hold their powers independently of the legislature, as the legislature do of the judicial. The Supreme Court then have a right, independent of the legislature, to give a construction to the Constitution and every part of it, and there is no power provided in this system to correct their construction or do it away. If, therefore, the legislature pass any laws inconsistent with this sense the judges put upon the Constitution, they will declare it void, and therefore in this respect their power is superior to that of the legislature. In England, The judges are not only subject to have their decisions set aside by the House of Lords for error, but in cases where they give an explanation to the laws or constitution of the country, contrary to the sense of Parliament, though the Parliament will not set aside the judgment of the court, yet they have authority, by a new law, to explain a former one, and by this means to prevent a reception of such decisions. But no such power is in the legislature. The judges are supreme, and no law, explanatory of the Constitution, will be binding on them. From the preceding remarks which have been made on the judicial powers proposed in this system, the policy of it may be fully developed. I have, in the course of my observations on this Constitution, affirmed and endeavored to show that it was calculated to abolish entirely the state governments, and to melt down the states into one entire government, for every purpose, as well internal and local as external and national. In this opinion, the opposers of the system have generally agreed, and this has been uniformly denied by its advocates in public. Some individuals, indeed among them, will confess that it has this tendency, and scruple not to say it is what they wish. And I will venture to predict, without the spirit of prophecy, that if it is adopted without amendments, or some such precautions as will ensure amendments immediately after its adoption, that the same gentlemen who have employed their talents and ability with such success to influence the public mind to adopt this plan will employ the same to persuade the people that it will be for their good to abolish the state governments as useless and burdensome. Perhaps nothing could be better conceived to facilitate the abolition of the state governments than the constitution of the judicial. They will be able to extend the limits of the general government gradually and by insensible degrees, and to accommodate themselves to the temper of the people. Their decisions on the meaning of the Constitution will commonly take place in cases which arise between individuals with which the public will not be generally acquainted. One adjudication will form a precedent to the next, and this to a following one. These cases will immediately affect individuals only, so that a series of determinations will probably take place before even the people will be informed of them. In the meantime, all the art and address of those who wish for a change will be employed to make converts to their opinion. The people will be told that their state officers and state legislatures are a burden and expense without affording any solid advantage, for that all the laws passed by them might be equally well made by the general legislature. If to those who will be interested in the change be added those who will be under the influence, and such who will submit to almost any change of government, which they can be persuaded to believe will ease them of taxes, it is easy to see the party who will favor the abolition of the state governments would be far from being inconsiderable. In this situation, the general legislature might pass one law after another, extending the general and abridging the state jurisdictions, and to sanction their proceedings would have a course of decisions of the judicial, to whom the Constitution has committed the power of explaining the Constitution. If the states remonstrated, the constitutional mode of deciding upon the validity of the law is with the Supreme Court, and neither people, nor state legislatures, nor the general legislature can remove them or reverse their decrees. Had the construction of the Constitution been left with the legislature, they would have explained it at their peril. If they exceed their powers, or sought to find in the spirit of the Constitution more than was expressed in the letter, the people from whom they derived their power could remove them, and do themselves right. And indeed, I can see no other remedy that the people can have against their rulers for encroachments of this nature. A constitution is a compact of a people with their rulers. If the rulers break the compact, the people have a right and ought to remove them and do themselves justice. But in order to enable them to do this with the greater facility, those whom the people choose at stated periods should have the power in the last resort to determine the sense of the compact. If they determine contrary to the understanding of the people, an appeal will lie to the people at the period when the rulers are to be elected, and they will have it in their power to remedy the evil. But when this power is lodged in the hands of men independent of the people and of their representatives, and who are not constitutionally accountable for their opinions, no way is left to control them but with a high hand and an outstretched arm. Brutus. End of Anti-Federalist Papers, Section 35, Brutus, Letter 15. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit librivox.org. Anti-Federalist Papers, Section 36, Brutus, Letter 16. 10 April 1788. When great and extraordinary powers are vested in any man or body of men, which in their exercise may operate to the oppression of the people, it is of high importance that powerful checks should be formed to prevent the abuse of it. Perhaps no restraints are more forcible than such as arise from responsibility to some superior power. Hence it is that the true policy of a republican government is to frame it in such a manner that all persons who are concerned in the government are made accountable to some superior for their conduct in office. This responsibility should ultimately rest with the people. To have a government well administered in all its parts, it is requisite the different departments of it should be separated and lodged as much as they may be in different hands. The legislative power should be in one body, the executive in another, and judicial in one different from either. But still each of these bodies should be accountable for their conduct. Hence it is impracticable, perhaps, to maintain a perfect distinction between these several departments, for it is difficult, if not impossible, to call to account the several officers in government without in some degree mixing the legislative and judicial. The legislature in a free republic are chosen by the people at stated periods, and their responsibility consists in their being amenable to the people. When the term for which they are chosen shall expire, who will then have the opportunity to displace them if they disapprove of their conduct? But it would be improper that the judicial should be elective, because their business requires that they should possess a degree of law knowledge which is acquired only by a regular education, and besides it is fit that they should be placed, in a certain degree, in an independent situation, that they may maintain firmness and steadiness in their decisions. As the people therefore ought not to elect the judges, they cannot be amenable to them immediately. Some other mode of amenability should be devised for these, as well as for all other officers which do not spring from the immediate choice of the people. This is to be effected by making one court subordinate to another, and by giving them cognizance of the behavior of all officers. But on this plan we at last arrive at some supreme, over whom there is no power to control but the people themselves. This supreme controlling power should be in the choice of the people, or else you establish an authority independent and not amenable at all, which is repugnant to the principles of a free government. Agreeable to these principles, I suppose the supreme judicial ought to be liable to be called to account for any misconduct by some body of men who depend upon the people for their places, and so also should all other great officers of the state, who are not made amenable to some superior officers. This policy seems in some measure to have been in view of the framers of the new system, and to have given rise to the institution of a court of impeachments. How far this court will be properly qualified to execute the trust which will be reposed in them will be the business of a future paper to investigate. To prepare the way to do this, it shall be the business of this, to make some remarks upon the constitution and powers of the Senate, with whom the power of trying impeachments is lodged. The following things may be observed with respect to the constitution of the Senate. First, they are to be elected by the legislatures of the states and not by the people, and each state is to be represented by an equal number. Second, they are to serve for 6 years, except that 1/3 of those first chosen are to go out of office at the expiration of 2 years, 1/3 at the expiration of 4 years, and 1/3 at the expiration of 6 years, after which this rotation is to be preserved, but still every member will serve for the term of 6 years. Third, if vacancies happen by resignation or otherwise during the recess of the legislature of any state, The executive is authorized to make temporary appointments until the next meeting of the legislature. 4. No person can be a senator who has not arrived to the age of 30 years, been 9 years a citizen of the United States, and who is not at the time he is elected an inhabitant of the state for which he is elected. The appointment of members of Senate among the states is not according to numbers or importance of the states, but is equal. This, on the plan of a consolidated government, is unequal and improper, but is proper on the system of confederation. On this principle I approve of it. It is indeed the only feature of any importance in the constitution of a confederated government. It was obtained after a vigorous struggle of that part of the convention who were in favor of preserving the state governments. It is to be regretted that they were not able to have infused other principles into that plan, to have secured the government of the respective states, and to have marked with sufficient precision the line between them and the general government. The term for which the Senate are to be chosen is, in my judgment, too long, and no provision being made for a rotation will, I conceive, be of dangerous consequence. It is difficult to fix the precise period for which the Senate should be chosen. It is a matter of opinion, and our sentiments on the matter must be formed by attending to certain principles. Some of the duties which are to be performed by the Senate seem evidently to point out the propriety of their term of service being extended beyond the period of that of the Assembly. Besides, as they are designed to represent the aristocracy of the country, it seems fit that they should possess more stability, and so continue a longer period than that branch who represent the democracy. The business of making treaties and some other which it will be proper to commit by the Senate requires that they should have experience, and therefore that they should remain some time in office to acquire it. But still it is of equal importance that they should not be so long in office as to be likely to forget the hand that formed them, or be insensible of their interests. Men long in office are very apt to feel themselves independent, and to form and pursue interests separate from those who appointed them. And this is more likely to be the case with the Senate, as they will for the most part of the time be absent from the state they represent, and associate with such companies as will possess very little of the feelings of the middling class of people. For it is to be remembered that there is to be a federal city, and the inhabitants of it will be the great and the mighty of the earth. For these reasons, I would shorten the term of their service to 4 years. 6 years is a long period for a man to be absent from his home. It would have a tendency to wean him from his constituents. A rotation in the Senate will also, in my opinion, be of great use. It is probable that senators once chosen for a state will, as the system now stands, continue in office for life. The office will be honorable if not lucrative. The persons who occupy it will probably wish to continue in it, and therefore use all their influence and that of their friends to continue in office. Their friends will be numerous and powerful, for they will have it in their power to confer great favors. Besides, it will before long be considered as disgraceful not to be reelected. It will therefore be considered as a matter of delicacy to the character of the senator not to return him again. Everybody acquainted with public affairs knows how difficult it is to remove from office a person who has long been in it. It is seldom done, except in cases of gross misconduct. It is rare that want of competent ability procures it. To prevent this inconvenience, I conceive it would be wise to determine that a senator should not be eligible after he had served for the period assigned by the Constitution for a certain number of years. Perhaps 3 would be sufficient. A farther benefit would be derived from such an arrangement. It would give opportunity to bring forward a greater number of men to serve their country, and would return those who had served to their state, and afford them the advantage of becoming better acquainted with the condition and politics of their constituents. It farther appears to me proper that the legislature should retain the right which they now hold under the Confederation of recalling their members. It seems an evident dictate of reason that when a person authorizes another to do a piece of business for him, he should retain the power to displace him when he does not conduct according to his pleasure. The power in the state legislatures under Confederation has not been exercised to the injury of the government, nor do I see any danger of its being so exercised under the new system. It may operate much to the public benefit. These brief remarks are all I shall make on the organization of the Senate. The powers with which they are invested will require a more minute investigation. This body will possess a strange mixture of legislative, executive, and judicial powers, which in my opinion will in some cases clash with each other. 1. They are one branch of the legislature, and in this respect will possess equal powers in all cases with the House of Representatives. For I consider the clause which gives the House of Representatives the right of originating bills for raising a revenue as merely nominal, seeing the Senate be authorized to propose or concur with amendments. 2. They are a branch of the executive in the appointment of ambassadors and public ministers, and in the appointment of all other officers not otherwise provided for. Whether the forming of treaties in which they are joined with the President appertains to the legislature or the executive part of government, or to neither, is not material. 3. They are part of the judicial, for they form the court of impeachments. It has been a long established maxim that the legislative, executive, and judicial departments in government should be kept distinct. It is said, I know, that this cannot be done, and therefore that this maxim is not just, or at least that it should only extend to certain leading features in a government. I admit that this distinction cannot be perfectly preserved. In a due balanced government, it is perhaps absolutely necessary to give the executive qualified legislative powers, and the legislative or a branch of them judicial powers in the last resort. It may possibly also, in some special cases, be advisable to associate the legislature or a branch of it with the executive in the exercise of acts of great national importance. But still the maxim is a good one, and a separation of these powers should be sought as far as is practicable. I can scarcely imagine that any of the advocates of the system will pretend that it was necessary to accumulate all these powers in the Senate. There is a propriety in the Senate's possessing legislative powers. This is the principal end which should be held in view of their appointment. I need not here repeat what has so often and ably been advanced on the subject of a division of the legislative power into two branches. The arguments in favor of it I think conclusive. But I think it equally evident that a branch of the legislature should not be invested with the power of appointing officers. This power in the Senate is very improperly lodged for a number of reasons. These shall be detailed in a future number. Brutus. End Anti-Federalist Papers, Section 36, Brutus, Letter 16.
The Anti-Federalist Papers, Chapter 37. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. The Anti-Federalist Papers, John DeWitt, Letter 1. Massachusetts, October 22nd, 1787. To the free citizens of the Commonwealth of Massachusetts. Whoever attentively examines the history of America, and compares it with that of others, it will find its commencement, its growth, and its present situation without a precedent. It must ever prove a source of pleasure to the philosopher who ranges the explored parts of this inhabitable globe, and takes a comparative view as well of the rise and fall of those nations which have been and are gone, as of the growth and present existence of those which are now in being, to close his project with this western world. In proportion as he loves his fellow creatures, he must here admire and approve, for while they have severally laid their foundations in the blood and slaughter of 3, 4, and sometimes 10 successive generations, from their passions have experienced every misery to which human nature is subject, and at this day present striking features of usurped power, unequal justice, and despotic tyranny. America stands completely systematized without any of these misfortunes. On the contrary, from the first settlement of the country, the necessity of civil associations, founded upon equality, consent, and proportionate justice have ever been universally acknowledged, the means of education always attended to, and the foundations of science brought within the reach of poverty. Hitherto we have commenced society and advanced in all respects resembling a family, without partial affections or even a domestic bickering. And if we consider her as an individual instead of an undue proportion of violent passions and bad habits, we must set her down possessed of reason, genius, and virtue. I presume these few observations because there are too many among us of narrow minds who live in the balance of blasting the reputation of their own country. They hold it as a maxim that virtues cannot grow in their own soil. They will appreciate those of a man they know nothing about, because he is an exotic, while they are sure to depreciate those much more brilliant in their neighbours, because they are really acquainted with and know them. Our society is a blessing. It is here universally known as such. The education of every child in this country tends to promote it. There is scarcely a citizen in America who does not wish to bring it, consistent with our situation and circumstances, to its highest state of improvement. Nay, I may say further, that the people in general aim to effect this point in a peaceable, laudable, and rational way. These assertions are proved by stubborn facts, and I need only resort to that moment when, in contest with a powerful enemy, they paid such an unprecedented attention to civilization as to select from among themselves their different conventions, and form their several constitutions, which, for their beautiful theoretical structure, caught the admiration of our enemies, and secured to us the applause of the world. We at this day feel the effects of this disposition, and now live under a government of our own choice, constructed by ourselves upon unequivocal principles, and requires but to be well administered to make us happy under it, as generally falls to the lot of humanity. The disturbances in the course of the year past cannot be placed as an objection to this principle I advance. They took their true rise in idleness, extravagance, and misfortune, a want of knowledge of our several finances, a universal delusion at the close of the war, and in consequence thereof, a pressure of embarrassments, which checked, and in many cases destroyed, that disposition of forbearance which ought to be exercised toward each other. These were added to the accursed practice of letting money at usury, and some few real difficulties and grievances which our late situation unavoidably brought upon us. The issue of them, however, rather proves the position. For a very few inclamables excepted, we find even an anxiety to hearken to reason pervading all classes, industry and frugality increasing, and the advantages arising from good wholesome laws confessed by everyone. Let who will gainsay it, I am confident we are in a much better situation in all respects than we were at this period the same last year, and as fact as can be expected, consistent with the passions and habits of a free people, of men who will think for themselves, coalescing, as a correspondent observes in a late paper, under a firm, wise, and efficient government. The powers vested in Congress have hitherto been found inadequate. Who are those that have been against investing them? The people of this commonwealth have very generally supposed it expedient, and the farmer equally with the merchant have taken steps to effect it. A convention from the different states for that sole purpose hath been appointed of their most respectable citizens; respectable indeed, I may say, for their equity, for their literature, and for their love of their country. Their proceedings are now before us for our approbation. The eagerness with which they have been received by certain classes of our fellow citizens naturally forces upon us this question: are we to adopt this government without an examination? Some here are, who, literally speaking, are for pressing it upon us at all events. The name of the man who but lisps a sentiment in objection to it is to be handed to the printer, by the printer to the public, and by the public he is to be led to execution. They are themselves stabbing its reputation. For my part, I am a stranger to the necessity for all this haste. Is it not a subject of some small importance? Certainly it is. Are not your lives, your liberties, and properties intimately involved in it? Certainly they are. Is it a government for a moment, a day, or a year? By no means, but for ages. Altered it may possibly be, but it is easier to correct before it is adopted. Is it for a family, a state, or a small number of people? It is for a number no less respectable than 3,000,000. Are the enemy at our gates, and have we not time to consider it? Certainly we have. It is so simple in its form as to be comprehended instantly. Every letter, if I may be allowed the expression, is an idea. Does it consist of but few additions to our present confederation, and those which have been from time to time described among us, and known to be necessary? Far otherwise. It is a complete system of government, and armed with every power that a people in any circumstance ought to bestow it. It is a path newly struck out, and a new set of ideas are introduced that have never occurred or been digested. A government for national purposes, preserving our constitution entire, hath been the only plan hitherto agitated. I do not pretend to say, but it is in theory the most unexceptionable, and in practice will be the most conducive to our happiness of any possible to be adopted. But it ought to undergo a candid and strict examination. It is the duty of every one in the Commonwealth to communicate his sentiments to his neighbour, divested of passion, and equally so of prejudices. If they are honest, and he is a real friend to his country, he will do it and embrace every opportunity to do it. If thoroughly looked into before it is adopted, the people will be more apt to approve of it in practice, and every man is a traitor to himself and his posterity who shall ratify it with his signature without first endeavouring to understand it. We are but yet in infancy, and we had better proceed slow than too fast. It is much easier to dispense powers than recall them. The present generation will not be drawn into any system. They are too enlightened. They have not forfeited their right to share in a government, and they ought to enjoy it. Some are heard to say, when we consider the men who made it, we ought to take it for sterling and without hesitation, that they were the collected wisdom of the states, and had no object but the general good. I do not doubt all this, but facts ought not to be winked out of sight. They were delegated from different states, and nearly equally represented, though vastly disproportionate both in wealth and numbers. They had local prejudices to combat, and in many instances totally opposite interests to consult. Their situations, their habits, their extent, and their particular interest varied each from the other. The gentlemen themselves acknowledge that they have been less rigid upon some points, in consequence of those difficulties, than they otherwise should have been. Others again tell you that the convention is or will be dissolved, that we must take their proceedings in whole or reject them. But this surely cannot be a reason for their speedy adoption. It rather works the other way. If evils are acknowledged in the composition, we ought at least to see whose shoulders are to bear the most, to compare ours with those of other states, and take care that we are not saddled with more than our proportion. That the citizens of Philadelphia are running mad after it can be no argument for us to do the like. Their situation is almost contrasted with ours. They suppose themselves a central state. They expect the perpetual residence of Congress, which of itself alone will ensure their aggrandizement. We, on the contrary, are sure to be near one of the extremes. Neither the loaves nor fishes will be so plenty with us, or shall we be so handy to procure them. We are told by some people that upon the adoption of this new government we are to become everything in a moment. Our foreign and domestic debts will be as a feather. Our ports will be crowded with ships of all over the world, soliciting our commerce and our produce. Our manufactures will increase and multiply, and in short, if we stand still, our country, notwithstanding, will be like the blessed Canaan, a land flowing with milk and honey. Let us not deceive ourselves. The only excellency of any government is in exact proportion to the administration of it. Idleness and luxury will be as much a bane as ever. Our passions will be equally at war with us then as now. And if we have men among us trying with all their ability to undermine our present constitution, these very persons will direct their force to sap their vitals of the new one. Upon the whole, my fellow countrymen, I am as much a federal man as any person. In a federal union lies our political salvation. To preserve that union and make it respectable to foreign optics, the national government ought to be armed with all necessary powers. But the subject I conceive of infinite delicacy, and requires both ability and reflection. In discussing points of such moment, America has nothing to do with passions or hard words. Every citizen has an undoubted right to examine for himself. Neither ought he to be ill-treated and abused because he does not think at the same moment exactly as we do. It is true that many of us have but our liberties to lose, but they are dearly bought, and are not the least precious in estimation. In the meantime, is it not of infinite consequence that we pursue inflexibly that path, which I feel persuaded we are now approaching, wherein we shall discourage all foreign importations, shall see the necessity of greater economy and industry, shall smile upon the husbandman, and reward the industrious mechanic, shall promote the growth of our own country, and wear the produce of our own farms, and finally shall support measures in proportion to their honesty and wisdom without any respect to men. Nothing more is wanted to make us happy at home and respectable abroad. Signed, John DeWitt. End of chapter 37. Anti-Federalist Papers, chapter 38. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. The Anti-Federalist Papers, John DeWitt, Letter Number 2. Massachusetts, October 27, 1787. To the Free Citizens of the Commonwealth of Massachusetts. In my last address upon the proceedings of the Federal Convention, I endeavored to convince you of the importance of the subject, that it required a cool, dispassionate examination and a thorough investigation, previous to its adoption; that it was not a mere revision and amendment of our first Constitution, but a complete system for the future government of the United States. And I may now add, in preference to, and in exclusion of, all others hereto adopted, it is not temporary, but in its nature perpetual. It is not designed that you shall be annually called either to revise, correct, or renew it, but that your posterity shall grow up under and be governed by it as well as ourselves. It is not so capable of alterations as you would at the first reading suppose, and I venture to assert it never can be, unless by force of arms. The fifth article in the proceedings, it is true, expressly provides for an alteration under certain conditions, whenever it shall be ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by Congress. Notwithstanding which, such are the heterogeneous materials from which this system was formed, such is the difference of interest, different manners, and different local prejudices in the different parts of the United States, that to obtain the majority of 3/4 to any one single alteration essentially affecting this or any other state amounts to an absolute impossibility. The conduct of the delegates in dissolving the convention plainly speaks this language, and no other. Their sentiments in their letter to His Excellency the President of Congress are, that this Constitution was the result of a spirit of amity, that the parties came together disposed to concede as much as possible, each to the other, that mutual concessions and compromises did in fact take place, and all those which could, consistent with the peculiarity of their political situation. Their dissolution enforces the same sentiment by confining you to the alternative of taking or refusing their doings in the gross. In this view, who is there to be found among us who can seriously assert that this Constitution, after ratification and being practised upon, will be so easy of alteration? Where is the probability that a future convention in any day will be found possessed of a greater spirit of amity and mutual concession than the present? Where is the possibility that 3/4 of the states in that convention, or 3/4 of the legislatures of the different states, whose interests differ scarcely in nothing short of everything, will be so very ready or willing materially to change any part of this system, which shall be to the emolument of an individual state only? No, my fellow citizens, as you are now obliged to take it in the whole, you must hereafter administer it in the whole, without the prospect of change, unless by reverting to a state of nature which will be ever opposed with success by those who approve the government in being. That the Bill of Rights to accompany this proposed system is a solid objection to it, provided there is nothing exceptional in the system itself, I do not assert. If, however, there is at any time a propriety in having one, it would not have been amiss here. A people entering into society surrender such a part of their natural rights as shall be necessary for the existence of that society. They are so precious in themselves that they would never be parted with, did not the preservation of the remainder require it. They are entrusted in the hands of those who are very willing to receive them, who are naturally fond of exercising them, and whose passions are always striving to make a bad use of them. They are conveyed by a written compact, expressing those which are given up, and the mode in which those reserved shall be secured. Language is so easy of explanation, and so difficult is it by words to convey exact ideas, that the party to be governed cannot be too explicit. The line cannot be drawn with too much precision and accuracy. The necessity of this accuracy and this precision increases in proportion to the greatness of the sacrifice and the numbers who make it. That a Constitution for the United States does not require a Bill of Rights, when it is considered that a Constitution for an individual state would, I cannot conceive. The difference between them is only in the numbers of the parties concerned. They are both a compact between the governors and governed, the letter of which must be adhered to by discussing their powers. That which is not expressly granted is, of course, retained. The compact itself is a recital upon paper of that proportion of the subject's natural rights intended to be parted with, for the benefit of adverting to it in case of dispute. Miserable indeed would be the situation of those individual states who have not prefixed to their constitutions a Bill of Rights, if, as a very respectable learned gentleman at the Southward observes, the people, when they established the power of legislators under their separate governments, invested their representatives with every right and authority which they did not, in explicit terms, reserve, and therefore upon every question respecting the jurisdiction of the House of Assembly, if the frame of constitution is silent, the jurisdiction of the House of Assembly; if the frame of government is silent, the jurisdiction is efficient and complete. In other words, those powers which the people by their constitutions expressly give them, they enjoy by positive grant, and those remaining ones which they never meant to give them, and which the constitutions say nothing about, they enjoy by tacit implication, so that by one means and by the other they become possessed of the whole. The doctrine is but poorly calculated for the meridian of America, where the nature of compact, the mode of constructing them, and the principles upon which society is founded are so accurately known and universally diffused. the insatiable thirst for unconditional control over our fellow creatures, and the facility of sounds to convey essentially different ideas, produced the first Bill of Rights ever prefixed to a frame of government. The people, although fully sensible that they receive every title of power they did not expressly grant away, yet afraid that the words made use of to express those rights so granted might convey more than they originally intended, they chose at the same moment to express in different language those rights which the agreement did not include, and which they never designed to part with, endeavouring thereby to prevent any cause for future altercation, and the intrusion into society of that doctrine of tacit implication which has been the favourite theme of every tyrant from the origin of all governments to the present day. The proceedings of the convention are now handed to you by your legislature, and the second Wednesday in January is appointed for your final answer. To enable you to give that with propriety, that your future reflections may produce peace, however opposed the present issue of your present conduct may be to your present expectations, you must determine that, in order to support with dignity the Federal Union, it is proper and fit that the present Confederation shall be annihilated, that the future Congress of the United States shall be armed with the powers of legislation, judgment, and execution. The annual elections in this Congress shall not be known, and the most powerful body, the Senate, in which a due proportion of representation is not preserved, and in which the smallest state has equal weight with the largest, be the longest in duration. That it is not necessary for the public good that persons habituated to the exercise of power should ever be reminded from whence they derive it, by a return to the station of private citizens, but that they shall at times, at the expiration of their term for which they were elected to an office, be capable of immediate re-election to that same office. That you will hereafter risk the probability of having the chief executive branch chosen from among you, and that it is wholly indifferent, both to you and your children after you, whether this future government shall be administered within the territories of your own state, or at the distance of 4,000 miles from them. You must also determine that they shall have the exclusive power of imposts and the duties on imports and exports, the power of laying excises and other duties, and the additional power of laying internal taxes upon your lands, your goods, your chattels, as well as your persons, at their sovereign pleasure. That the produce of these several funds shall be appropriated to the use of the United States, and collected by their own officers, armed with a military force, if a civil aid should not prove sufficient. That the power of organizing, arming, and disciplining the militia shall be lodged in them, and this through fear that they shall not be sufficiently attentive to keeping so respectable a body of men as yeomanry of this commonwealth completely armed, organized, and disciplined. They shall have also the power of raising, supporting, and establishing a standing army in time of peace in your several towns, and I see not why in your several houses. That should an insurrection or an invasion, however small, take place in Georgia, the extremity of the continent, it is highly expedient they should have the power of suspending the writ of habeas corpus in Massachusetts, as long as they shall judge the public safety requires it. You must also say that your present supreme judicial court shall be an inferior court to a continental court, which is to be inferior to the Supreme Court of the United States. That from an undue bias which they are supposed to have for the citizens of their own states, they shall not be competent to determine title to your real estate, disputes which may arise upon the protested bill of exchange, a simple note of hand, or book debit, wherein your citizens shall be unfortunately involved with disputes of any other kind with citizens either of other states or foreign states. In all such cases they shall have a right to carry their causes to the Supreme Court of the United States, whether for delay only or vexation, however distant from the place of your abode, or inconsistent with your circumstances. that such appeals shall be extended to matters of fact as well as law, and a trial of the cause by jury you shall not have a right to insist upon. In short, my fellow citizens, previous to a capacity of giving complete answer to these proceedings, you must determine that the constitution of your commonwealth, which is instructive, beautiful, and consistent in practice, which has been justly admired in Europe as a model of perfection, and which the present convention have affected to imitate, a constitution which is especially calculated for your territory, and is made conformable to your genius, your habits, the mode of holding your estates, and your particular interests, shall be reduced in its powers to those of a city corporation. The skeleton of it may remain, but its vital principle shall be transferred to the new government. Nay, you must go still further, and agree to invest the new government with powers which you have yet thought proper to withhold from your own present government. All these, and more, are contained in the proceedings of the Federal Constitution, may be highly proper and necessary. It is this overturn of all individual governments in the new fashioned set of ideas, and in this total dereliction of those sentiments which animated us in 1775. The political salvation of the United States may be very deeply interested, but be cautious. Signed, John DeWitt. End of chapter 38. The Anti-Federalist Papers, Chapter 39. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. The Anti-Federalist Papers, John DeWitt, Letter Number 3. Massachusetts, November 5th, 1787. To the free citizens of the Commonwealth of Massachusetts. Civil liberty in all countries hath promoted by a free discussion of public measures and conduct of public men. The freedom of the press hath, in consequence thereof, been esteemed one of its safeguards. The freedom gives the right at all times to every citizen to lay his sentiments in a decent manner before the people, if he will take that trouble upon himself. Whether they are in point or not, his countrymen are obliged to him for so doing, for at least they lead to an examination of the subject upon which he writes. If any possible situation makes it a duty, it is our present important one, for in the course of 60 or 90 days you are to approve of or reject the present proceedings of your Constitution, which, if established, will certainly affect, in a greater or less degree, during the remainder of your lives, those privileges which you esteem dear to you, and not improbably those of your children for succeeding ages. Now therefore is unquestionably the proper time to examine it, and see if it really is what, upon paper, it appears to be. If with your eyes open you deliberately accept it, however different it may prove in practice from what it appears in theory, you will have nobody to blame but yourselves. And what is infinitely worse, as I have before endeavoured to observe to you, you will be wholly without remedy. It has many zealous advocates, and they have attempted, at least as far as their modesty would permit, to analyze our gazettes with their encomiums upon it. With the people they have to manage, I would hint to them, their zeal is not their best weapon. The exertions of such a kind, artful attempts to seize the moment, do seldom tend either to elucidate and explain principles or ensure successes. Such conduct ought to be an additional stimulus for those persons who are not its professed admirers, to speak their sentiments with freedom, however unpopular. Such conduct ought to inspire caution, for as a man is invariably known by his company, so is the tendency of principles known by their advocates. Nay, it ought to lead you to inquire who are its advocates, whether ambitious men throughout America, waiting with impatience to make it a stepping stone to posts of honor and emolument, are not of this class, whether men who openly profess to be tired of republican governments, and sick to the heart of republican measures, who daily ridicule a government of choice and pray ardently for one of force, are not of the same class; and whether there are not men among us who disapprove of it only because it is not an absolute monarchy, but who upon the whole are among its advocates. In such examinations as these, you cannot misspend a proportion of the 60 days. All contracts are to be construed according to the meaning of the parties at the time of making them, by which is meant that mutual communications shall take place, and each shall explain to the other their ideas of the contract before them. If any unfair practices are made use of, if its real tendency is concealed by either party, or any advantage taken in the execution of it, it is itself fraudulent and may be avoided. There is no difference in the constitution of government. Consent, it is allowed, is the spring. The form is the mode in which the people choose to direct their efforts, and the magistrates are but trustees to put that mode in force. It will not be denied that this people of any under heaven have a right of living under a government of their own choosing. That government, originally consented to, which is in practice what it purports to be in theory, is a government of choice. On the contrary, that which is essentially different in practice from its appearance in theory, however it may be in letter a government of choice, it never can be so in spirit. Of this latter kind appear to me to be the proceedings of the Federal Convention. They are presented as a frame of government purely republican, and perfectly consistent with the individual governments in the Union. It is declared to be constructed for national purposes only, and not calculated to interfere with domestic concerns. You are told that the rights of the people are very aptly secured, and when the wheels of it are put in motion, it will wear a milder aspect than its present one. Whereas the very contrary of all this doctrine appears to be true. Upon an attentive examination, you can pronounce it nothing less than a government which in a few years will degenerate to a complete aristocracy, armed with the powers unnecessary in any case to bestow, and which in its vortex swallow up every other government upon the continent. In short, my fellow citizens, it can be said to be nothing less than a hasty stride to universal empire in this western world, flattering, very flattering to young ambitious minds, but fatal to the liberties of the people. The cord is strained to the very utmost. There is every spice of the sic jubeo possible in the composition. Your consent is requested, because it is essential to the introduction of it. After having received confirmation, your complaints may increase the whistling of the wind, and they will be equally regarded. It cannot be doubted at this day by any means of common sense that there is a charm in politics, that persons who enter reluctantly into office become habituated, grow fond of it, and are loath to resign it. They feel themselves flattered and elevated, and are apt to forget their constituents until the time returns that they again feel the want of them. They unfortunately exercise all the powers granted to them, and 99 in 100 are for grasping at more. It is this passionate thirst for power which has produced different branches to exercise different departments and mutual checks upon those branches. The aristocratical hath ever been found to have the most influence, and the people in most countries have been particularly attentive in providing checks against it. Let us see if it is the case here. A president, a senate, and a house of representatives are proposed. The judicial department is at present out of the question, being separated excepting in impeachments. The legislature is divided between the people, who are the democratical, and the senate, who are the aristocratical part, and the executive between the same senate and the president, who represents the monarchical part. In the construction of this system, their interests are put in opposite scales. If they are exactly balanced, the government will remain perfect. If there is a preponderancy, it will firmly prevail. After the first 4 years, each senator will hold his seat for the term of 6 years. This length of time will be amply sufficient of itself to remove any checks that he may have upon his independency from the fear of a future election. He will consider that it is a serious portion of his life after the age of 30 that places in honour and trust are not generally obtained unsolicited. The same means that placed him there may be again made use of. His influence and his abilities arising from his opportunities will during this whole term increase those means. He will have a complete negative upon all laws that shall be general, or that shall favour individuals, and a voice in the appointment of all officers in the United States. Thus habituated to power, and living in the daily practice of granting favours and receiving solicitations, he may hold himself completely independent of the people, and at the same time ensure his election. If there remains even a risque, the blessed assistance of a little well-distributed money will remove it. With respect to the executive, the Senate, excepting in nomination, have a negative upon the President, and if we but a moment attend to their situation and to his, and to the power of persuasion over the human mind, especially when employed in behalf of friends and favourites, we cannot hesitate to say that he will be infinitely less apt to dislodge them than they to refuse him. It is far easier for 20 to gain over 1 than 1 20. Besides, in the one case we can ascertain where the denial comes from, and the other we cannot. It is also highly improbable but some of the members, perhaps a majority part, will hold their seats during their lives. We see this daily in our own government, and we see it in every government we are acquainted with, however many the cautions, and however frequent the elections. These considerations, added to their share above mentioned in the executive department, must give them a decided superiority over the House of Representatives. But that superiority is greatly enhanced when we consider the difference of time for which they are chosen. They will have become adepts in the mystery of administration, while the House of Representatives may be composed, perhaps 2/3, of members just entering into office, little used to the course of business, and totally unacquainted with the means made use of to accomplish it. Very possible also in a country where they are total strangers. But, my fellow citizens, the important question here arises: who are this House of Representatives? A representative assembly, says the celebrated Mr. Adams, in the sense of the people, and the perfection of the portrait consists in the likeness. Can this assembly be said to contain the sense of the people? Do they resemble the people in any one feature? Do you represent your wants, your grievances, your wishes in person? If that is impracticable, have you a right to send one of your townsmen for that purpose? Have you a right to send one from your country? Have you a right to send more than one for every 30,000 of you? Can he be presumed, knowing to your different peculiar situations, your abilities to pay public taxes when they ought to be abated and when increased? Or is there any possibility of giving him information? All these questions must be answered in the negative. But how are these men to be chosen? Is there any other way than by dividing the Senate into districts? May not you as well at once invest your annual assemblies with the power of choosing them? Where is the essential difference? The nature of the thing will admit of none. Nay, you may give them the power to prescribe the mode. They may invest it in themselves. If you choose them yourself, you must take them upon credit and elect those persons you know only by common frame. Even this privilege is denied you annually, through fear that you might withhold the shadow of control over them. In this view of the Senate, let me sincerely ask you, where is the people of this House of Representatives? Where is the boasted popular part of this much admired system? Are they not cousins, germane in every sense to the Senate? May they not with propriety be termed an assistant aristocratical branch, who will be infinitely more inclined to cooperate and compromise with each other, than to be the careful guardians of the rights of their constituents? Who is there among you would not start at being told that instead of your present House of Representatives, consisting of members chosen from every town, your future houses are to consist of but 10 in number, and these to be chosen by districts? What man among you should betray his country and approve of it? And yet how infinitely preferable to the plan proposed. In the one case, the elections would be annual. The persons elected would reside in the center of you, their interests would be yours, they would be subject to your immediate control, and nobody to consult in their deliberations. But in the other, they are chosen for double the time, during which, however well disposed, they become strangers to the very people choosing them. They reside at a distance from you. You have no control over them, you cannot observe their conduct, and they have to consult and finally be guided by 12 other states, whose interests are, in all material points, directly opposed to yours. Let me again ask you, what citizen is there in the Commonwealth of Massachusetts that would deliberately consent, laying aside the mode proposed, that the several senates of the several states should be the popular branch, and together from one national House of Representatives? And yet one moment's attention will advise to you that this blessed proposed representation of the people, this apparent faithful mirror, this striking likeness, is to be still further refined and more aristocratical 4 times told. Where now is the exact balance which has been so diligently attended to? Where lies the security of the people? What assurances have they that either their taxes will not be extracted but in the greatest emergencies, and then sparingly, or that standing armies will be raised and supported for the very plausible purpose only of cantoning them upon their frontiers? There is but one answer to these questions: they have none. Nor was it intended by the makers they should have, for, meaning to make a different use of the latter, they never will be at a loss for ways and means to expend the former. They do not design to beg a second time. Knowing the danger of frequent applications to the people, they ask for the whole at once, and are now by their conduct tearing and absolutely haunting of you into a compliance. If you choose all these things should take place, by all means gratify them. Go and establish this government, which is unanimously confessed imperfect, yet incapable of alteration. Entrust it to men subject to the same unbounded passions and infirmities as yourselves, possessed with an insatiable thirst for power, and many of them carrying in their vices, though tinselled and concealed, yet in themselves not less dangerous than those more naked and exposed. But in the meantime add the additional weight to the stone that now covers the remains of the great Warren and Montgomery. Prepare an apology for the blood and treasure profusely spent to obtain those rights which you now so timely part with. Conceal yourselves from the ridicule of your enemies, and bring your New England spirits to a level with the contempt of mankind. Henceforth you may sit yourselves down with propriety and say, Blessed are they that never expect, for they shall not be disappointed. Signed, John DeWitt.
End of chapter 39.
This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The Anti-Federalist Papers. Section 40. Cato, Letter 3. From the New York Journal, October 25, 1787. The recital or premises on which the new form of government is erected declares a consolidation or union of all the 13 parts or states into one great whole under the form of the United States, for all the various and important purposes therein set forth. But whoever seriously considers the immense extent of territory comprehended within the limits of the United States, together with the variety of its climates, productions, and commerce, the difference of extent and number of inhabitants in all, the dissimilitude of interest, morals, and politics in almost every one, will receive it as an intuitive truth that a consolidated republican form of government therein can never form a perfect union, establish justice, ensure domestic tranquillity, promote the general welfare, and secure the blessings of liberty to you and your posterity, for to these objects it must be directed. This unkindred legislature, therefore, composed of interests opposite and dissimilar in their nature, will in its exercise emphatically be like a house divided against itself. The governments of Europe have taken their limits and form from adventitious circumstances, and nothing can be argued on the motive of agreement from them. But these adventitious political principles have nevertheless produced effects that have attracted the attention of philosophy, which have established axioms in the science of politics therefrom, as irrefragable as any in Euclid. It is natural, says Montesquieu, to a republic to have only a small territory, otherwise it cannot long subsist. In a large one there are men of large fortunes, and consequently of less moderation. There are too great deposits to trust in the hands of a single subject. An ambitious person soon becomes sensible that he may be happy, great, and glorious by oppressing his fellow citizens, and that he might raise himself to grandeur on the ruins of his country. In large republics the public good is sacrificed to 1,000 views. In a small one the interest of the public is easily perceived, better understood, and more within the reach of every citizen. Abuses have a less extent, and of course are less protected. He also shows you that the duration of the Republic of Sparta was owing to its having continued with the same extent of territory after all its wars, and that the ambition of Athens and Lacedaemon to command and direct the Union lost them their liberties, and gave them a monarchy. From this picture what can you promise yourselves on the score of consolidation of the United States into one government? Impracticability in the just exercise of it, your freedom insecure, even this form of government limit in its continuance, the employments of your country disposed of to the opulent, to whose contumely you will continually be an object. You must risk much, by indispensably placing trusts of the greatest magnitude into the hands of individuals whose ambition for power and aggrandizement will oppress and grind you. Where, from the vast extent of your territory and the complication of interests, the science of government will become intricate and perplexed, and too mysterious for you to understand and observe, and by which you are to be conducted into a monarchy, either limited or despotic. The latter, Mr. Locke remarks, is a government derived from neither nature nor compact. Political liberty, the great Montesquieu again observes, consists in security, or at least in the opinion we have of security, and this security, therefore, or the opinion, is best obtained in moderate governments, where the mildness of the laws and the equality of the manners beget a confidence in the people, which produces this security, or the opinion. This moderation in governments depends in a great measure on their limits connected with their political distribution. The extent of many of the States of the Union is at this time almost too great for the superintendence of a republican form of government, and must one day or other revolve into more vigorous ones, or by separation be reduced into smaller and more useful, as well as moderate ones. You have already observed the feeble efforts of Massachusetts against their insurgents. With what difficulty did they quell that insurrection? And is not the province of Maine at this moment on the eve of separation from her? The reason of these things is, that for the security of the property of the community, in which expressive term Mr. Locke makes life, liberty, and estate, to consist the wheels of a republic are necessarily slow in their operation. Hence, in large free republics, the evil sometimes is not only begun, but almost complete, before they are in a situation to turn the current into a contrary progression. The extremes are also too remote from the usual seat of government, and the laws therefore too feeble to afford protection to all its parts, and ensure domestic tranquillity without the aid of another principle. If, therefore, this State and that of North Carolina had an army under their control, they never would have lost Vermont and Franklin, nor the State of Massachusetts suffered an insurrection or the dismemberment of her fairest district. But the exercise of a principle which would have prevented these things, if we may believe the experience of ages, would have ended in the destruction of their liberties. Will this consolidated republic, if established, in its exercise beget such confidence and compliance among the citizens of these States as to do without the aid of a standing army? I deny that it will. The malcontents in each State, who will not be a few, nor the least important, will be exciting factions against it. The fear of a dismemberment of some of its parts, and the necessity to enforce the execution of revenue laws, a fruitful source of oppression, on the extremes and in the other districts of the government, will incidentally and necessarily require a permanent force to be kept on foot. Will not political security, and even the opinion of it, be extinguished? Can mildness and moderation exist in a government where the primary incident in its exercise must be force? Will not violence destroy confidence, and can equality subsist where the extent, policy, and practice of it will naturally lead to make odious distinctions among citizens? The people who may compose this national legislature from the Southern States, in which, from the mildness of the climate, the fertility of the soil, and the value of its productions, wealth is rapidly acquired, and where the same causes naturally lead to luxury, dissipation, and a passion for aristocratic distinction, where slavery is encouraged, and liberty of course less respected and protected, who know not what it is to acquire property by their own toil, nor to economize with the savings of industry, will these men therefore be as tenacious of the liberty and interests of the more northern States, where freedom, independence, industry, equality, and frugality are natural to the climate and soil, as men who are your own citizens, legislating in your own State, under your inspection, and whose manners and fortunes bear a more equal resemblance to your own? It may be suggested in answer to this, that whoever is a citizen of one State is a citizen of each, and that therefore he will be as interested in the happiness and interest of all as the one he is delegated from. But the argument is fallacious, and whoever has attended to the history of mankind, and the principles which bind them together as parents, citizens, or men, will readily perceive it. These principles are in their exercise like a pebble cast on the calm surface of a river. The circles begin in the center, and are small, active, and forcible; but as they depart from that point, they lose their force, and vanish into calmness. The strongest principle of union resides within our domestic walls. The ties of the parent exceed that of any other. As we depart from home, the next general principle of union is amongst citizens of the same State, where acquaintance, habits, and fortunes nourish affection and attachment. Enlarge the circle still further, and as citizens of different States, though we acknowledge the same national denomination, we lose in the ties of acquaintance, habits, and fortunes, and thus by degrees we lessen in our attachments, till at length we no more than acknowledge a sameness of species. Is it, therefore, from certainty like this, reasonable to believe that inhabitants of Georgia or New Hampshire will have the same obligations toward you as your own, and preside over your lives, liberties, and property with the same care and attachment? Intuitive reason answers in the negative. End of section 40. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. The Anti-Federalist Papers. Section 41. Cato, Letter 4. From the New York Journal, November 8, 1787. I shall begin with observations on the executive branch of this new system, and though it is not the first in order, as arranged therein, yet being the chief, is perhaps entitled by the rules of rank to the first consideration. The executive power, as described in the second article, consists of a president and vice president, who are to hold their offices during the term of 4 years. The same article has marked the manner and time of their election, and established the qualifications of the president. It also provides against the removal, death, or inability of the president and vice president, regulates the salary of the president, delineates his duties and powers, and lastly declares the causes for which the president and vice president shall be removed from office. Notwithstanding the great learning and abilities of the gentlemen who composed the convention, it may be here remarked with defense that the construction of the first paragraph of the first section of the second article is vague and inexplicit, and leaves the mind in doubt as to the election of a president and vice president, after the expiration of the election for the first term of 4 years. In every other case the election of these great officers is expressly provided for, but there is no explicit provision for their election which is to set this political machine in motion, no certain and express terms as in your State Constitution, that statedly once in every 4 years, and as often as these offices shall become vacant, by expiration or otherwise, as is therein expressed, an election shall be held as follows, etc. This inexplicitness may perhaps lead to an establishment for life. It is remarked by Montesquieu in treating of republics that in all magistracies the greatness of the power must be compensated by the brevity of the duration, and that a longer time than a year would be dangerous. It is therefore obvious to the least intelligent mind to account why great power in the hands of a magistrate, and that power connected with considerable duration, may be dangerous to the liberties of a republic. The deposit of vast trusts in the hands of a single magistrate enables him in their exercise to create a numerous train of dependents. This tempts his ambition, which in a republican magistrate is also remarked to be pernicious, and the duration of his office for any considerable time favors his views, gives him the means and time to perfect and execute his designs. He therefore fancies that he may be great and glorious by oppressing his fellow citizens, and raising himself to permanent grandeur on the ruins of his country. And here it may be necessary to compare the vast and important powers of the President, together with his continuance in office, with the foregoing doctrine. His eminent magisterial situation will attach many adherents to him, and he will be surrounded by expectants and courtiers. His power of nomination and influence on all appointments, the strong posts in each state comprised within his superintendence, and garrisoned by troops under his direction, his control over the army, militia, and navy, the unrestrained power of granting pardons for treason, which may be used to screen from punishment those whom he had secretly instigated to commit the crime, and thereby prevent a discovery of his own guilt, his duration in office for 4 years, these and various other principles evidently prove the truth of the position, that if the President is possessed of ambition, he has the power and time sufficient to ruin his country. Though the President during the sitting of the legislature is assisted by the Senate, yet he is without a constitutional council in their recess. He will therefore be unsupported by proper information and advice, and will generally be directed by minions and favorites, or a council of state will grow out of the principal officers of the great departments, the most dangerous council in a free country. The language and the manners of this court will be what distinguishes them from the rest of the community, not what assimilates them to it, and in being remarked for a behavior that shows they are not meanly born, and in adulation to people of fortune and power. The establishment of a vice president is as unnecessary as it is dangerous. This officer, for want of other employment, is made president of the Senate, thereby blending the executive and legislative powers, besides always giving to some one state from which he is to come an unjust preeminence. It is a maxim in republics that the representative of the people should be of their immediate choice, but by the manner in which the President is chosen he arrives to this office at the 4th or 5th hand. Nor does the highest vote, in the way that he is elected, determine the choice, for it is only necessary that he should be taken from the highest 5, who may have a plurality of votes. And wherein does this President, invested with his powers and prerogatives, essentially differ from the King of Great Britain, save as to name, the creation of nobility, and some immaterial incidents, the offspring of absurdity and locality? The direct prerogatives of the President, as springing from his political character, are among the following. It is necessary, in order to distinguish him from the rest of the community, and enable him to keep and maintain his court, that the compensation for his services, or in other words, his revenue, should be such as to enable him to appear with the splendor of a prince. He has the power of receiving ambassadors from, and a great influence on their appointments to, foreign courts, as also to make treaties, leagues, and alliances with foreign states, assisted by the Senate, which when made becomes the supreme law of land. He is a constituent part of the legislative power, for every bill which shall pass the House of Representatives and Senate is to be presented to him for approbation. If he approves of it he is to sign it. If he disapproves, he is to return it with objections, which in many cases will amount to a complete negative, and in this view he will have a great share in the power of making peace, coining money, etc., and all the various objects of legislation expressed or implied in this Constitution. For though it may be asserted that the King of Great Britain has the express power of making peace or war, yet he never thinks it prudent to do so without the advice of his Parliament, from whom he is to derive his support, and therefore these powers in both President and King are substantially the same. He is the generalissimo of the nation, and of course has the command and control of the army, navy, and militia. He is the general conservator of the peace of the Union. He may pardon all offences except in cases of impeachment, and the principal fountain of all offices and employments. Will not the exercise of these powers, therefore, tend either to the establishment of a vile and arbitrary aristocracy or monarchy? The safety of the people in a republic depends on the share or proportion they have in the government. But experience ought to teach you that when a man is at the head of an elective government invested with great powers, and interested in his re-election, in what circle appointments will be made, by which means an imperfect aristocracy bordering on monarchy may be established. You must, however, my countrymen, be aware that the advocates of this new system do not deceive you by a fallacious resemblance between it and your own state government, which you so much prize. And if you examine, you will perceive that the chief magistrate of this state is your immediate choice, controlled and checked by a just and full representation of the people, divested of the prerogatives of influencing war and peace, making treaties, receiving and sending embassies, and commanding standing armies and navies, which belong to the power of the Confederation, and which will be convinced that this government is no more like a true picture of your own than an angel of darkness resembles an angel of light. End of section 41. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Anti-Federalist Papers, Section 42. Cato, Letter 5. The New York Journal, November 22, 1787. To the Citizens of the State of New York. In my last number I endeavored to prove that the language of the article relative to the establishment of the executive of this new government was vague and inexplicit, that the great powers of the President, connected with his duration in office, would lead to oppression and ruin, that he would be governed by favorites and flatterers, or that a dangerous council would be collected from the great officers of state, that the 10 miles square, if the remarks of one of the wisest men, drawn from the experience of mankind, may be credited, with the asylum of the base, idle, and avaricious and ambitious, and that the court would possess a language and manners different from yours, that a vice president is as unnecessary as he is dangerous in his influence, that the president cannot represent you because he is not of your own immediate choice, differs, that if you adopt this government, you will incline to an arbitrary and odious aristocracy or monarchy, that the President possessed of the power given him by this frame of government differs but very immaterially from the establishment of monarchy in Great Britain, and I warned you to beware of the fallacious resemblance that is held out to you by the advocates of this new system between it and your own state governments. And here I cannot help remarking that inexplicitness seems to pervade this whole political fabric. Certainly in political compacts, which Mr. Coke tells the mother and nurse of repose and quietness, the want of which induced men to engage in political society, has ever been held by a wise and free people as essential to their security, as on the one hand it fixes barriers which the ambitious and tyrannically disposed magistrate dare not overleap, and on the other becomes a wall of safety to the community. Otherwise, stipulations between the governors and governed are nugatory, and you might as well deposit the important powers of legislation and execution in one or a few, and permit them to govern according to their disposition and will. But the world is too full of examples which prove that to live by one man's will became the cause of all men's misery. Before the existence of express political compacts it was reasonably implied that the magistrate should govern with wisdom and justice, but mere implication was too feeble to restrain the unbridled ambition of a bad man, or to afford security against negligence, cruelty, or any other defect of mind. It is alleged that the opinions and manners of the people of America are capable to resist and prevent an extension of prerogative or oppression. But you must recollect that opinion and manners are mutable, and may not always be a permanent obstruction against the encroachments of government; that the progress of a commercial society begets luxury, the parent of inequality, the foe to virtue, and the enemy to restraint; and that ambition and voluptuousness, aided by flattery, will teach magistrates, where limits are not explicitly fixed, to have separate and distinct interests from the people. Besides, it will not be denied that government assimilates the manners and opinions of the community to it. Therefore, a general presumption that rulers will govern well is not a sufficient security. You are then under a sacred obligation to provide for the safety of your posterity, and would you now basely desert their interests, when by a small share of prudence you may transmit to them a beautiful political patrimony, that will prevent the necessity of their travelling through seas of blood to obtain that which your wisdom might have secured? It is a duty you owe likewise to your own reputation, for you have a great name to lose. You are characterized as cautious, prudent, and jealous in politics, whence it is, therefore, that you are about to precipitate yourselves into a sea of uncertainty, and adopt a system so vague, and which has discarded so many of your valuable rights. Is it because you do not believe that an American can be a tyrant? If this be the case, you rest on a weak basis. Americans are like other men in similar situations. When the manners and opinions of the community are changed by the causes I mentioned before, and your political compact inexplicit, your posterity will find that great power connected with ambition, luxury, and flattery will as readily produce a Caesar, Caligula, Nero, and Domitian in America, as the same causes did in the Roman Empire. But the next thing to be considered in conformity to my plan is the first article of this new government, which comprises the erection of the House of Representatives and Senate, and prescribes their various powers and objects of legislation. The most general objections to the first article are that biennial elections for representatives are a departure from the safe democratical principles of annual ones, that the number of representatives are too few, that the apportionment and principles of increase are unjust, that no attention has been paid to either the numbers or property in each State in forming the Senate, that the mode in which they are appointed and their duration will lead to the establishment of an aristocracy, that the Senate and President are improperly connected, both as to appointments and the making of treaties, which are to become the supreme law of the land, that the judicial, in some measure, to wit, as to the trial of impeachments, is placed in the Senate, a branch of the legislative, and sometimes a branch of the executive, that Congress have the improper power of making or altering the regulations prescribed by the different legislatures respecting the time, place, and manner of holding elections for representatives, and the time and manner of choosing senators, that standing armies may be established and appropriation of money made for their support for 2 years, that the militia of the most remote state may be marched into those states situated at the opposite extreme of this continent, that the slave trade is, to all intents and purposes, permanently established, and a slavish capitation or poll tax may at any time be levied. These are some of the many evils that will attend the adoption of this government. But with respect to the first objection, it may be remarked that a well-digested democracy has this advantage over all others, to wit, that it affords to many the opportunity to be advanced to the supreme command, and the honors they thereby enjoy fill them with the desire of rendering themselves worthy of them. Hence this desire becomes part of their education, is matured in manhood, and produces an ardent affection for their country; and it is the opinion of the great Sidney and Montesquieu that this is in a great measure produced by annual election of magistrates. If annual elections were to exist in this government, and learning and information to become more prevalent, you never will want men to execute whatever you could design. Sidney observes, quote, that a well-governed state is as fruitful to all good purposes as the 7-headed serpent is said to have been in evil. When one head is cut off, many rise up in the place of it. End quote. He remarks further that, quote, it was also thought that free cities by frequent elections of magistrates became nurseries of great and able men, every man endeavoring to excel others, that he might be advanced to the honor he had no other title to than what might arise from his merit or reputation. End quote. But the framers of this perfect government, as it is called, have departed from this democratical principle, and established biennial elections for the House of Representatives, who are to be chosen by the people, and sextennial for the Senate, who are to be chosen by the legislatures of the different states, and have given to the executive the unprecedented power of making temporary senators in case of vacancies, by resignation or otherwise, and so far forth establishing a precedent for virtual representation, though in fact their original appointment is virtual, thereby influencing the choice of legislatures; or if they should not be so complacent as to conform to his appointment, offense will be given to the executive, and the temporary members will appear ridiculous by rejection. This temporary member, during his time of appointment, will of course act by a power derived from the executive, and for and under his immediate influence. It is a very important objection to this government that the representation consists of so few, too few to resist the influence of corruption and the temptation to treachery, against which all governments ought to take precautions. How guarded you have been on this head in your own state constitution, and yet the number of senators and representatives proposed for this vast continent does not equal those of your own state. How great the disparity if you compare them with the aggregate numbers in the United States. The history of representation in England, from which we have taken our model of legislation, is briefly this. Before the institution of legislating by deputies, the whole free part of the community usually met for that purpose. When this became impossible by the increase of numbers, the community was divided into districts, from each of which was sent such a number of deputies as was a complete representation of the various numbers and orders of citizens within them. But can it be asserted with truth that 6 men can be a complete and full representation of the numbers and various orders of the people in this state? Another thing that may be suggested against the small number of representatives is, that but few of you will have the chance of sharing even in this branch of the legislature, and the choice will be confined to a very few. The more complete it is, the better will your interests be preserved, and the greater the opportunity you will have to participate in government, one of the principal securities of a free people. But this subject has been so ably and fully treated by a writer under the signature of Brutus, that I shall content myself with referring you to him thereon, reserving further observations on the other objections I have mentioned for my future numbers. Signed, Cato. End of Anti-Federalist Papers, Section 42. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. The Anti-Federalist Papers. Anti-Federalist Papers, Section 43. Cato, Letter 7. The New York Journal, January 3, 1788. To the Citizens of the State of New York. That the Senate and President are further improperly connected will appear if it is considered that their dependence on each other will prevent either from being a check upon the other. They must act in concert, and whether the power and influence of the one or the other is to prevail will depend on the character and abilities of the men who hold those offices at the time. The Senate is vested with such a proportion of the executive that it would be found necessary that they should be constantly sitting. This circumstance did not escape the convention, and they have provided for the event in the second article, which declares that the executive may, on extraordinary occasions, convene both houses or either of them. No occasion can exist for calling the assembly without the Senate. The words "or either of them" must have been intended to apply only to the Senate. Their wages are already provided for, and it will be therefore readily observed that the partition between a perpetuation of their sessions and a perpetuation of their offices in the progress of the government will be found to be but thin and feeble. Besides, the Senate, who will have sole power to try all impeachments in case of the impeachment of the President, are to determine, as judges, the propriety of the advice they gave him as senators. Can the Senate in this, therefore, be an impartial judicature? And will they not rather serve as a screen to great public defaulters? Among the many evils that are incorporated in this new system of government is that of Congress having the power of making or altering the regulations prescribed by the different legislatures respecting the time, place, and manner of holding elections for representatives, and the time and manner of choosing senators. If it is inquired in what manner this regulation may be exercised to your injury, the answer is easy. By the first article, the House of Representatives shall consist of members chosen every second year by the people of the several states, who are qualified to vote for members of their several state assemblies. It can therefore readily be believed that the different state legislatures, provided such exist after the adoption of this government, will continue those easy and convenient models for the election of representatives for the national legislature, that are in use for the election of members of assembly for their own states. But the Congress have, by the Constitution, a power to make other regulations, or alter those in practice prescribed by your own state legislature. Hence, instead of having the places of elections in the precincts and brought home almost to your own doors, Congress may establish a place or places at either the extremes, center, or outer parts of the states, at a time and season too when it may be very inconvenient to attend, and by these means destroy the rights of election, But in opposition to this reasoning, it is asserted that it is a necessary power because the states might omit making rules for the purpose, and thereby defeat the existence of that branch of the government. This is what logicians call argumentum absurdum, for the different states, if they will have any security at all in this government, will find it in the House of Representatives, and they therefore would not be very ready to eradicate a principle in which it dwells or involve their country in an instantaneous revolution. Besides, if this was the apprehension of the framers and the ground of that provision, why did they not extend this controlling power to the other duties of the several state legislatures? To exemplify this, the states are to appoint senators and electors for choosing of a president, but the time is to be under the direction of Congress. Now suppose they were to omit the appointment of senators and electors, though Congress was to appoint the time, which might as well be apprehended as the omission of regulations for the election of members of the House of Representatives, provided they had that power, or suppose they were not to meet at all. Of course, the government cannot proceed in its exercise. And from this motive, or apprehension, Congress ought to have taken these duties entirely in their own hands, and, by a decisive declaration, annihilated them, which they in fact have done by leaving them without the means of support, or at least resting on their bounty. To this the advocates for this system oppose the common, empty declamation that there is no danger that Congress will abuse this power, but such language, as relative to so important a subject, is mere vapor and sound without sense. Is it not in their power, however, to make such regulations as may be inconvenient to you? It must be admitted because the words are unlimited in their sense. It is a good rule in the construction of a contract to support that what may be done will be. Therefore, in considering this subject, you are to suppose that in the exercise of this government a regulation of Congress will be made for holding an election for the whole state at Poughkeepsie, at New York, or perhaps at Fort Stanwix. Who will then be the actual electors for the House of Representatives? Very few more than those people who may live in the vicinity of these places. Could any others afford the expense and time of attending? And would not the government by this means have in it their power to put whom they pleased in the House of Representatives? You ought certainly to have as much or more distrust with respect to the exercise of those duties which ought to be entrusted to the several states, because over them Congress can have a legislative controlling power. Hitherto we have tied up our rulers in the exercise of their duties by positive restrictions. If the cord has been drawn too tight, loosen it to the necessary extent, but do not entirely unbind them. I am no enemy to placing a reasonable confidence in them, but such an unbounded one as the advocates and framers of this new system advise you to would be dangerous to your liberties. It has been the ruin of other governments, and will be yours, if you adopt with all its latitudinal powers. Unlimited confidence in governors as well as individuals is frequently the parent of despotism. What facilitated the corrupt designs of Philip of Macedon, and caused the ruin of Athens, but the unbounded confidence in their statesmen and rulers? Such improper confidence Demosthenes was so well convinced had ruined his country, that in his second Philippic oration he remarks that, quote, "There is one common bulwark with which men of prudence are naturally provided, the guard and security of all people, particularly of free states, against the assaults of tyrants. What is this? Distrust. Of this be mindful, to this adhere. Preserve this carefully, and no calamity can affect you." End quote. Montesquieu observes that, quote, "The course of government is attended with an insensible descent to evil, and there is no reascending to good without very great efforts." End quote. The plain inference from this doctrine is, that rulers in all governments will erect an interest separate from the ruled, which will have a tendency to enslave them. There is therefore no other way of interrupting this insensible descent and warding off the evil as long as possible, than by establishing principles of distrust in your constituents, and cultivating the sentiment among yourselves. But let me inquire of you, my countrymen, whether the freedom and independence of election is a point of magnitude? If it is, what kind of a spirit of amity, deference, and concession is that which has put in the power of Congress at one stroke to prevent your interference in government and do away your liberties forever? Does either the situation or circumstances of things warrant it? Signed, Cato. End of Anti-Federalist Papers, Section 43. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. The Anti-Federalist Papers. Anti-Federalist number 44. Letters of Agrippa to the Massachusetts Gazette. Letter number 6. 14th of December, 1787. To the People. To prevent any mistakes or misapprehensions of the argument stated in my last paper, to prove that the proposed Constitution is an actual consolidation of the separate States into one extensive Commonwealth, the reader is desired to observe that in the course of the argument the new plan is considered as an entire system. It is not dependent on any other book for an explanation, and contains no references to any other book. All the defenses of it, therefore, so far as they are drawn from the State constitutions or from maxims of the common law, are foreign to the purpose. It is only by comparing the different parts of it together that the meaning of the whole is to be understood. For instance, we find in it that there is to be a legislative assembly with authority to constitute courts for the trial of all kinds of civil causes between citizens of different States. The right to appoint such courts necessarily involves it in the right of defining their powers, and determining the rules by which their judgment shall be regulated, and the grant of the former of those rights is nugatory without the latter. It is vain to tell us that a maxim of common law requires contracts to be determined by the law existing where the contract was made. For it is also a maxim that the legislature has a right to alter the common law. Such a power forms an essential part of legislation. Here, then, a Declaration of Rights is of inestimable value. It contains those principles which the government never can invade without an open violation of the compact between them and the citizens. Such a declaration ought to have come to the new Constitution in favor of the legislative rights of the several States, by which their sovereignty over their own citizens within the State should be secured. Without such an express declaration the States are annihilated in reality upon receiving this Constitution. The forms will be preserved only during the pleasure of Congress. The idea of consolidation is further kept up in the right given to regulate trade. Though this power under certain limitations would be a proper one for the Department of Congress, it is in this system carried much too far, and much farther than is necessary. This is, without exception, the most commercial State upon the continent. Our extensive coasts, cold climate, small estates, and equality of rights, with a variety of subordinate and concurring circumstances, place us in this respect at the head of the Union. We must, therefore, be indulged if a point which so nearly relates to our welfare be rigidly examined. The new Constitution not only prohibits vessels bound from one State to another from paying any duties, but even from entering and clearing. The only use of such a regulation is, to keep each State in complete ignorance of its own resources. It certainly is no hardship to enter and clear at the custom house, and the expense is too small to be an object. The unlimited right to regulate trade includes the right of granting exclusive charters. This, in all old countries, is considered as one principal branch of prerogative. We find hardly a country in Europe which has not felt the ill effects of such a power. Holland has carried the exercise of it farther than any other State, and the reason why that country has felt less evil from it is, that the territory is very small, and they have drawn large revenues from their colonies in the East and West Indies. In this respect the whole country is to be considered as a trading company, having exclusive privileges. The colonies are large in proportion to the parent State, so that upon the whole the latter may gain by such a system. We are also to take into consideration the industry which the genius of a free government inspires. But in the British Islands all these circumstances together have not prevented them from being injured by the monopolies created there. Individuals have been enriched, but the country at large has been hurt. Some valuable branches of trade being granted to companies who transact their business in London, that city is, perhaps, the place of the greatest trade in the world. But Ireland, under such influence, suffers exceedingly and is impoverished, and Scotland is a mere byword. Bristol, the second city in England, ranks not much above this town in population. These things must be accounted for by the incorporation of trading companies, and if they are felt so severely in countries of small extent, they will operate with tenfold severity upon us who inhabit an immense tract, and living towards one extreme of an extensive empire, shall feel the evil without retaining that influence in government which may enable us to procure redress. There ought then to have been inserted a restraining clause which might prevent the Congress from making any such grant, because they consequentially defeat the trade of the outports, and are also injurious to the general commerce, by enhancing prices and destroying that rivalship which is the great stimulus to industry. Signed, Agrippa. End of Anti-Federalist Paper No. 44. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. The Anti-Federalist Papers. Anti-Federalist No. 45. Letters of Agrippa to the Massachusetts Gazette. Letter No. 7. 18th December, 1787. To the People. There cannot be a doubt that while the trade of this continent remains free, the activity of our countrymen will secure their full share. All the estimates for the present year, let them be made by what party they may, suppose the balance of trade to be largely in our favor. The credit of our merchants is, therefore, fully established in foreign countries. This is a sufficient proof that when business is unshackled it will find out that channel which is most friendly to its course. We ought, therefore, to be exceedingly cautious about diverting or restraining it. Every day produces fresh proofs that people, under the immediate pressure of difficulties, do not at first glance discover the proper relief. The last year, a desire to get rid of embarrassments induced many honest people to agree to a tender act, and many others of a different description to obstruct the courts of justice. Both these methods only increased the evil they were intended to cure. Experience has since shown that instead of trying to lessen an evil by altering the present course of things, every endeavor should have been applied to facilitate the course of law, and thus to encourage a mutual confidence among the citizens, which increases the resources of them all, and renders the easy payment of debts. By this means one does not grow rich at the expense of another, but all are benefited. The case is the same with the States. Pennsylvania, with one port and a large territory, is less favorably situated for trade than Massachusetts, which has an extensive coast in proportion to its limits of jurisdiction. Accordingly, a much larger proportion of our people are engaged in maritime affairs. We ought therefore to be particularly attentive to securing so great an interest. It is vain to tell us that we ought to overlook local interests. It is only by protecting local concerns that the interest of the whole is preserved. No man, when he enters into society, does it from a view to promote the good of others, but he does it for his own good. All men having the same view are bound equally to promote the welfare of the whole. To recur then to such a principle as that local interest must be disregarded is requiring of one man to do more than another, and is subverting the foundations of a free government. The Philadelphians would be shocked with the proposition to place the seat of general government and the unlimited right to regulate trade in Massachusetts. There can be no greater reason for our surrendering the preference to them. Such sacrifices, however we may delude ourselves with the form of words, always originate in folly and not in generosity. Let me now request your attention a little while to the actual state of public credit, that we may see whether it has not been as much represented as the state of our trade. At the beginning of the present year the whole continental debt was about 12 millions of pounds in our money. About 1/4 part of this sum was due to our foreign creditors. Of these, France was the principal, and called for the arrears of interests. A new loan of £120,000 was negotiated in Holland at 5% to pay the arrears due to France. At first sight this has the appearance of bad economy, and has been used for the villainous purpose of disaffecting the people. But in the course of this same year Congress have negotiated the sale of as much of their western lands on the Ohio and Mississippi as amount nearly to the whole sum of the foreign debt, and instead of a dead loss by borrowing money at 5% to the amount of £120,000 in one sum, they make a savings of the interest at 6% on 3 millions of their domestic debt, which is an annual saving of £180,000. It is easy to see how such an immense fund as the Western Territory may be applied to the payment of the foreign debt. Purchasers of the land would as willingly procure any kind of the produce of the United States as they would buy loan office certificates to pay for the land. The produce thus procured would easily be negotiated for the benefit of our foreign creditors. I do not mean to insinuate that no other provision should be made for our creditors, but only to show that our credit is not so bad in other countries as has been represented, and that our resources are fully equal to the pressure. The perfection of government depends on the equality of its operation, as far as human affairs will admit, upon all parts of the empire and upon all the citizens. Some inequalities indeed will necessarily take place. One man will be obliged to travel a few miles further than another man to procure justice. But when he has travelled, the poor man ought to have the same measure of justice as the rich one. Small inequalities may be easily compensated. There ought, however, to be no inequality in the law itself, and the government ought to have the same authority in one place as in another. Evident as this truth is, the most plausible argument in favor of the new plan is drawn from the inequality of its operation in different states. In Connecticut they have been told that the bulk of the revenue will be raised by impost and excise, and therefore they need not be afraid to trust Congress with the power of levying a dry tax at pleasure. New York and Massachusetts are both more commercial states than Connecticut. The latter therefore hopes that the other two will pay the bulk of the continental expense. The argument is in itself delusive. If the trade is not overtaxed, the consumer pays it. If the trade is overtaxed, it languishes, and by the ruin of the trade the farmer loses his market. The farmer has, in truth, no other advantage from imposts than that they save him the trouble of collecting money for the government. He neither gets or loses money by changing the mode of taxation. The government indeed finds it the easiest way to raise the revenue, and the reason is that the tax is by this means collected where the money circulates most freely. But if the argument was not delusive, it ought to conclude against the plan, because it would prove the unequal operation of it; and if any saving is to be made by the mode of taxation, the saving should be applied towards our own debt, and not to the payment of the part of a continental burden which Connecticut ought to discharge. It would be impossible to refute in writing all the delusions made use of to force this system through. Those respecting the public debt and the benefit of imposts are the most important, and these I have taken pains to explain. In one instance, indeed, the impost does raise money at the direct expense of the seaports. This is when goods are imported subject to a duty, and re-exported without a drawback. Whatever benefit is derived from this source surely should not be transferred to another state, at least till our own debts are cleared. Another instance of unequal operation is, that it establishes different degrees of authority in different states, and thus creates different interests. The lands in New Hampshire having been formerly granted by this state, and afterwards by that state, to private persons, the whole authority of trying titles becomes vested in a continental court, and that state loses a branch of authority, which the others retain, over their own citizens. I have now gone through two parts of my argument, and have proved the efficiency of the state governments for internal regulation, and the disadvantages of the new system, at least some of the principal. The argument has been much longer than I at first apprehended, or possibly I should have been deterred from it. The importance of the question has, however, prevented me from relinquishing it. Signed, Agrippa. End of Anti-Federalist Paper No. 45. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. The Anti-Federalist Papers, Number 46. Letters of Agrippa to the Massachusetts Gazette, Letter Number 7. 25th December, 1787. To the People. It has been proved by indisputable evidence that power is not the grand principle of union among the parts of a very extensive empire, and that when this principle is pushed beyond the degree necessary for rendering justice between man and man, it debases the character of individuals, and renders them less secure in their persons and property. Civil liberty consists in the consciousness of that security, and is best guarded by political liberty, which is the share that every citizen has in the government. Accordingly, all our accounts agree that in those empires which are commonly called despotic, and which comprehend by far the greatest part of the world, the government is most fluctuating and properly least secure. In those countries insults are borne by the sovereign, which, if offered to one of our governors, would fill us with horror, and we should think the government dissolving. The common conclusion from this reasoning is an exceedingly unfair one, that we must then separate and form distinct confederacies. This would be true if there was no principle to substitute in the room of power. Fortunately there is one. This is commerce. All the states have local advantages, and in a considerable degree separate interests. They are, therefore, in a situation to supply each other's wants. Carolina, for instance, is inhabited by planters, while the Massachusetts is more engaged in commerce and manufactures. Congress has the power of deciding their differences. The most friendly intercourse may therefore be established between them. A diversity of produce, wants, and interests produces commerce, and commerce, where there is a common, equal, and moderate authority to preside, produces friendship. The same principles apply to the connection with the new settlers in the West. Many supplies they want, for which they must look to the older settlements, and the greatness of their crops enables them to make payments. Here, then, we have a bond of union which applies to all parts of the empire, and would continue to operate if the empire comprehended all America. We are, in the strictest sense of the term, a federal republic. Each part has within its own limits the sovereignty over its citizens, while some of the general concerns are committed to Congress. The complaints of the deficiency of the congressional powers are confined to 2 articles. They are not able to raise a revenue by taxation, and they have not a complete regulation of the intercourse between us and foreigners. For each of these complaints there is some foundation, but not enough to justify the clamor which has been raised. Congress, it is true, owes a debt which ought to be paid. A considerable part of it has been paid. Our share of what remains would annually amount to about 60 or 70,000 pounds. If, therefore, Congress were to put in possession of such branches of the impost as would raise this sum in our state, we should fairly be considered as having done our part towards their debt, and our remaining resources, whether arising from impost, excise, or dry tax, might be applied to the reduction of our own debt. The principal of this last amounts to about 1,300,000 pounds, and the interest to between 70 or 80,000. This is surely too much property to be sacrificed, and it is as reasonable that it should be paid as the continental debt. But if the new system should be adopted, the whole impost, with an unlimited claim to excise and dry tax, will be given to Congress. There will remain no adequate funds for the state debt, and the state will still be subject to be sued on their notes. This is, then, an article which ought to be limited. We can without difficulty pay as much annually as shall clear the interest of our state debt, and our share of the interest on the continental one. But if we surrender the impost, we shall still by this new Constitution be held to pay our full proportion of the remaining debt, as if nothing had been done. The impost will not be considered as being paid by the state, but by the continent. The Federalists indeed tell us that the state debts will all be incorporated with the continental debt, and all paid out of one fund. In this, as in all other instances, they endeavor to support their scheme of consolidation by delusion. Not one word is said in the book in favor of such a scheme, and there is no reason to think it true. Assurances of that sort are easily given, and as easily forgotten. There is an interest in forgetting what is false. No man can expect town debts to be united with that of the State, and there will be as little reason to expect that the State and continental debts will be united together. Signed, Agrippa. End of Anti-Federalist Paper No. 46. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. The Anti-Federalist Papers. Anti-Federalist No. 47. Letters of Agrippa to the Massachusetts Gazette. Letter No. 9. 28th of December, 1787. To the People. We come now to the second and last article of complaint against the present Confederation, which is, that Congress has not the sole power to regulate the intercourse between us and foreigners. Such a power extends not only to war and peace, but to trade and naturalization. This last article ought never to be given them, for though most of the States may be willing for certain reasons to receive foreigners as citizens, yet reasons of equal weight may induce other States, differently circumstanced, to keep their blood pure. Pennsylvania has chosen to receive all that would come there. Let any indifferent person judge whether that State in point of morals, education, energy, is equal to any of the Eastern States, the small State of Rhode Island only excepted. Pennsylvania in the course of a century has acquired her present extent and population at the expense of religion and good morals. The Eastern States have, by keeping separate from the foreign mixtures, acquired their present greatness in the course of a century and a half, and have preserved their religion and morals. They have also preserved that manly virtue which is equally fitted for rendering them respectable in war and industrious in peace. The remaining power for peace and trade might perhaps be safely enough lodged with Congress under some limitations. Three restrictions appear to me to be essentially necessary to preserve the equality of rights to the States, which it is the object of the State governments to secure each citizen. First, it ought not to be in the power of Congress either by treaty or otherwise to alienate part of any State without the consent of the legislature. Second, they ought not to be able by treaty or other law to give any legal preference to one part above another. Third, they ought to be restrained from creating any monopolies. Perhaps others may propose different regulations and restrictions. One of these is to be found in the old Confederation, and another in the newly proposed plan. The third seems to be equally necessary. After all that has been said and written on this subject, and on the difficulty of amending our old Constitution so as to render it adequate to national purposes, it does not appear that anything was more necessary to be done than framing two new articles. By one a limited revenue would be given to Congress with a right to collect it, and by the other a limited right to regulate our intercourse with foreign nations. By such an addition we should have preserved to each State its power to defend the rights of the citizens, and the whole empire would be capable of expanding and receiving additions without altering its former constitution. Congress at the same time, by the extent of their jurisdiction and the number of their officers, would have acquired more respectability at home and a sufficient influence abroad. If any State was in such a case to avoid the rights of the Union, the other States would join in defense of those rights, and it would be in the power of Congress to direct the national force to that object. But it is certain that the powers of Congress over citizens should be small in proportion as the empire is extended, that in order to preserve the balance, each State may supply by energy what is wanting in numbers. Congress would be able, by such a system as we have proposed, to regulate trade with foreigners by such duties as should effectually give the preference to the produce and manufactures of our own country. We should then have a friendly intercourse established between the States, upon the principles of mutual interest. A moderate duty upon foreign vessels would give an advantage to our own people, while it would avoid all the disadvantages arising from a prohibition, and the consequent deficiency of vessels to transport the produce of the Southern States. Our country is at present, upon an average, 1,000 miles long from north to south, and 800 miles broad from the Mississippi to the ocean. we have at least 6,000,000 of white inhabitants, and the annual increase is about 250,000 souls, exclusive of immigrants from Europe. The greater part of our increase is employed in settling the new lands, while the older settlements are entering largely into manufactures of various kinds. It is probable that the extraordinary exertions of this State in the way of industry for the present year only exceed in value £500,000. The new settlements, if all made in the same tract of country, would form a large State annually, and the time seems to be literally accomplished when a nation shall be born in a day. Such an immense country is not only capable of yielding all the produce of Europe, but actually does produce by far the greater part of the raw materials. The restrictions on our trade in Europe necessarily oblige us to make use of those materials, and the high price of labor operates as an encouragement to mechanical improvements. In this way we daily make rapid advancements towards independence in resources as well as in empire. If we adopt the new system of government, we shall by one rash vote lose the fruit of the toil and expense of 13 years, at the time when the benefits of that toil and expense are rapidly increasing. Though the imposts of Congress on foreign trade may tend to encourage manufactures, the excise and dry tax will destroy all the beneficial effects of the impost, at the same time that they diminish our capital. Be careful then to give only a limited revenue and the limited power of managing foreign concerns. Once surrender the rights of internal legislation and taxation, and instead of being respected abroad, foreigners will laugh at us, and posterity will lament our folly. Signed, Agrippa. End of Anti-Federalist Paper No. 47.
This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by Robert Scott. The Anti-Federalist Papers, Section Number 48, Pen Minority. The address and reasons of dissent of the minority of the Convention of Pennsylvania to their constituents. Pennsylvania Packet and Daily Advertiser, 18 December 1787. It was not until after the termination of the late glorious contest which made the people of the United States an independent nation that any defect was discovered in the present Confederation. It was formed by some of the ablest patriots in America. It carried us successfully through the war, and the virtue and patriotism of the people, with their disposition to promote the common cause, supplied the want of power in Congress. The requisition of Congress for the 5% impost was made before the peace, so early as the 1st of February, 1781, but was prevented taking effect by the refusal of one state. Yet it is probable every state in the Union would have agreed to this measure at that period, had it not been for the extravagant terms in which it was demanded. The requisition was new molded in the year 1783, and accompanied with an additional demand of certain supplementary funds for 25 years. Peace had now taken place, and the United States found themselves laboring under a considerable foreign and domestic debt incurred during the war. The requisition of 1783 was commensurate with the interest of the debt, as it was then calculated, but it has been more accurately ascertained since that time. The domestic debt has been found to fall several millions of dollars short of the calculation, and it has lately been considerably diminished by large sales of the Western lands. The states have been called on by Congress annually for supplies until the general system of finance proposed in 1783 should take place. It was at this time that the want of an efficient federal government was first complained of, and that the powers vested in Congress were found to be inadequate to the procuring of the benefits that should result from the Union. The impost was granted by most of the states, but many refused the supplementary funds. The annual requisitions were set at naught by some of the states, while others complied with them by legislative acts, but were tardy in their payments, and Congress found themselves incapable of complying with their engagements and supporting the federal government. It was found that our national character was sinking in the opinion of foreign nations. The Congress could make treaties of commerce, but could not enforce the observance of them. We were suffering from the restrictions of foreign nations, who had shackled our commerce while we were unable to retaliate, and all now agreed that it would be advantageous to the Union to enlarge the powers of Congress, that they should be enabled in the amplest manner to regulate commerce and to lay and collect duties on the imports throughout the United States. With this view, a convention was first proposed in Virginia, and finally recommended by Congress for the different states to appoint deputies to meet in convention, for the purpose of revising and amending the present Articles of Confederation so as to make them adequate to the exigencies of the Union. This recommendation the legislature of 12 states complied with so hastily as not to consult their constituents on the subject, and though the different legislatures had no authority from their constituents for the purpose, they probably apprehended the necessity would justify the measure, and none of them extended their ideas at that time further than revising and amending the present Articles of Confederation. Pennsylvania, by the act appointing deputies, expressly confined their powers to this subject, and though it is probable that some of the members of the Assembly of the state had at that time in contemplation to annihilate the present Confederation as well as the Constitution of Pennsylvania, yet the plan was not sufficiently matured to communicate to the public. The majority of the legislature of this Commonwealth were at that time under the influence of the members from the city of Philadelphia. They agreed that the deputies sent by them to convention should have no compensation for their services, which determination was calculated to prevent the election of any member who resided at a distance from the city. It was in vain for the minority to attempt electing delegates to the convention who understood the circumstances and the feelings of the people and had a common interest with them. They found a disposition in the leaders of the majority of the House to choose themselves and some of their dependents. The minority attempted to prevent this by agreeing to vote for some of the leading members who they knew had influence enough to be appointed at any rate, in hopes of carrying with them some respectable citizens of Philadelphia, in whose principles and integrity they could have more confidence. But even in this they were disappointed, except in one member. The 8th member was added at a subsequent session of the Assembly. The Continental Convention met in the city of Philadelphia at the time appointed. It was composed of some men of excellent characters, of others who were more remarkable for their ambition and cunning than their patriotism, and some who had been opponents to the independence of the United States. The delegates from Pennsylvania were, 6 of them, uniform and decided opponents to the Constitution of this Commonwealth. The convention sat upwards of 4 months. The doors were kept shut, and the members brought under the most solemn engagements of secrecy. Footnote number 1. Some of those who opposed their going so far beyond their powers retired hopeless from the convention. Others had the firmness to refuse signing the plan altogether, and many who did sign it did it not as a system they wholly approved, but as the best that could then be obtained. And notwithstanding the time spent on this subject, it is agreed on all hands to be a work of haste and accommodation. Whilst the gilded chains were forging in the secret conclave, the meaner instruments of despotism without were busily employed in alarming the fears of the people with dangers which did not exist, and exciting their hopes of greater advantages from the expected plan than even the best government on earth could produce. The proposed plan had not many hours issued forth from the womb of suspicious secrecy, until such as were prepared for the purpose were carrying about petitions for people to sign, signifying their approbation of the system, and requesting the legislature to call a convention, while every measure was taken to intimidate the people against opposing it. The public papers teemed with the most violent threats against those who should dare to think for themselves, and tar and feathers were liberally promised to all those who would not immediately join in supporting the proposed government, be it what it would. Under such circumstances, petitions in favor of calling a convention were signed by great numbers in and about the city, before they had leisure to read and examine the system, many of whom, now they are better acquainted with it, and have had time to investigate its principles, are heartily opposed to it. The petitions were speedily handed into the legislature. Affairs were in this situation when on the 28th of September last a resolution was proposed to the Assembly by a member of the House who had been also a member of the Federal Convention, for calling a state convention to be elected within 10 days for the purpose of examining and adopting the proposed Constitution of the United States, though at this time the House had not received it from Congress. This attempt was opposed by a minority who, after offering every argument in their power to prevent the precipitate measure, without effect, absented themselves from the House as the only alternative left them, to prevent the measure taking place previous to their constituents being acquainted with the business. That violence and outrage which had been so often threatened was now practiced. Some of the members were seized the next day by a mob collected for the purpose, and forcibly dragged into the House, and there detained by force, whilst the quorum of the legislature, so formed, completed their resolution. We shall dwell no longer on this subject. The people of Pennsylvania have been already acquainted therewith. We would only further observe that every member of the legislature, previously to taking his seat, by solemn oath or affirmation, declares that he will not do or consent to any act or thing whatever that shall have a tendency to lessen or abridge their rights and privileges, as declared in the Constitution of this state, and that Constitution which they are so solemnly sworn to support cannot legally be altered by a recommendation of a council of censors, who alone are authorized to propose alterations and amendments, and even these must be published at least 6 months for the consideration of the people. The proposed system of government for the United States, if adopted, will alter and may annihilate the Constitution of Pennsylvania, and therefore the legislature had no authority whatever to recommend the calling a convention for that purpose. This proceeding could not be considered as binding on the people of this commonwealth. The House was formed by violence. Some of the members composing it were detained by force, which alone would have vitiated any proceedings to which they were otherwise competent. But had the legislature been legally formed, this business was absolutely without their power. In this situation of affairs were the subscribers, elected members of the Convention of Pennsylvania, a convention called by a legislature in direct violation of their duty, and composed in part of members who were compelled to attend for that purpose, to consider of a constitution proposed by a convention of the United States, who were not appointed for the purpose of framing a new form of government, but whose powers were expressly confined to altering and amending the present Articles of Confederation. Therefore, the members of the Continental Convention, in proposing the plan, acted as individuals and not as deputies from Pennsylvania. Footnote number 2. The Assembly, who called the State Convention, acted as individuals and not as the legislature of Pennsylvania, nor could they, or the convention chosen on their recommendation, have authority to do any act or thing that can alter or annihilate the Constitution of Pennsylvania, both of which will be done by the new Constitution, nor are their proceedings, in our opinion, at all binding on the people. The election for members of the convention was held at so early a period, and the want of information was so great, that some of us did not know of it until after it was over, and we have reason to believe the great numbers of the people of Pennsylvania have not yet had opportunity of sufficiently examining the proposed Constitution. We apprehend that no change can take place that will affect the internal government or constitution of this Commonwealth, unless a majority of the people should evidence a wish for such a change. But, on examining the number of votes given for members of the present state convention, we find that upwards of 70,000 free men who are entitled to vote in Pennsylvania, the whole convention has been elected by about 13,000 voters. And, though 2/3 of the members of the convention have thought proper to ratify the proposed Constitution, yet those 2/3 were elected by the votes of only 6,800 freemen. In the city of Philadelphia and some of the eastern countries, the junto that took the lead in the business agreed to vote for none but such as would solemnly promise to adopt the system in toto, without exercising their judgment. In many of the counties, the people did not attend the elections, as they had not an opportunity of judging of the plan. Otherwise, did not consider themselves bound by the call of a set of men who assembled at the State House in Philadelphia and assumed the name of the legislature of Pennsylvania, and some were prevented from voting by violence of the party who were determined, at all events, to force down the measure. To such lengths did the tools of despotism carry their outrage, that in the night of the election for members of convention in the city of Philadelphia, several of the subscribers, being then in the city to transact your business, were grossly abused, ill-treated, and insulted while they were quiet in their lodgings, though they did not interfere nor had anything to do with the said election, but as they apprehend, because they were supposed to be adverse to the proposed Constitution, and would not tamely surrender those sacred rights which you had committed to their charge. The convention met, and the same disposition was soon manifested in considering the proposed Constitution that had been exhibited in every other stage of the business. We were prohibited by an express vote of the convention from taking any question on the separate articles of the plan, and reduced to the necessity of adopting or rejecting in toto. 'Tis true, the majority permitted us to debate on each article, but restrained us from proposing amendments. They also determined not to permit us to enter on the minutes or reasons of dissent against any of the articles, nor even on the final question our reason of dissent against the whole. Thus situated, we entered on the examination of the proposed system of government, and found it to be such as we could not adopt, without, as we conceived, surrendering up our dearest rights. We offered our objections to the convention, and opposed those parts of the plan which, in our opinion, would be injurious to you, in the best manner we were able, and closed our arguments by offering the following propositions to the convention. 1. The right of conscience shall be held inviolable, and neither the legislature, executive, nor judicial power of the United States shall have authority to alter, abrogate, or infringe any part of the Constitution of the several States which provide for the preservation of liberty in matters of religion. 2. That in controversies respecting property, and in suits between man and man, trial by jury shall remain as heretofore, as well in the federal courts as in those of several States. 3. That in all capital and criminal prosecutions a man has a right to demand the cause and nature of his accusation, as well in the federal courts as in those of several States, to be heard by himself and his counsel, to be confronted with the accusers and witnesses, to call for evidence in his favor, and a speedy trial by an impartial jury of his vicinage, without whose unanimous consent he cannot be found guilty, nor can he be compelled to give evidence against himself, and that no man be deprived of his liberty except by the law of the land or the judgment of his peers. 4. That excessive bail ought not be required, nor excessive fines imposed, nor cruel nor unusual punishments inflicted. 5. That warrants unsupported by evidence, whereby any officer or messenger may be commanded or required to search suspected places, or to seize any person or persons, his or their property, not particularly described, are grievous and oppressive, and shall not be granted either by the magistrates of the federal government or others. 6. That the people have a right to the freedom of speech, of writing and publishing their sentiments. Therefore, the freedom of the press shall not be restrained by any law of the United States. 7. That the people have a right to bear arms for the defense of themselves and their own state, or the United States, or for the purpose of killing game, and no law shall be passed for disarming the people, or any of them, unless for crimes committed, or real danger of public injury from individuals, and, as standing armies in the time of peace are dangerous to liberty, they ought not to be kept up, and that the military should be kept under strict subordination to, and be governed by, the civil powers. 8. The inhabitants of the several States shall have liberty to fowl and hunt in seasonable times, on the lands they hold, and on all other lands in the United States not enclosed, and in like manner to fish in all navigable waters, and others not private property, without being restrained therein by any laws to be passed by the legislature of the United States. 9. That no law shall be passed to restrain the legislatures of the several states from enacting laws for imposing taxes, except imposts and duties on goods imported or exported, and that no taxes, except imposts and duties upon goods imported and exported, and postage on letters shall be levied by the authority of Congress. 10. That the House of Representatives be properly increased in number, that elections shall remain free, that the several states shall have power to regulate the elections for senators and representatives without being controlled either directly or indirectly by any interference on the part of the Congress, and that elections of representatives be annual. 11. That the power of organizing, arming, and disciplining the militia, the manner of disciplining the militia to be prescribed by Congress, remain with the individual states, and that Congress shall not have authority to call or march any of the militia out of their own state without the consent of such state, and for such length of time only as such state shall agree. That the sovereign freedom and independency of the several states shall be retained, and every power, jurisdiction, and right which is not by this Constitution expressly delegated to the United States in Congress assembled. 12. That the legislative, executive, and judicial powers be kept separate, and to this end that a constitutional council be appointed to advise and assist the President, who shall be responsible for the advice they give. Hereby the senators would be relieved from almost constant attendance, and also that the judges be made completely independent. 13. That no treaty which shall be directly opposed to the existing laws of the United States in Congress assembled shall be valid until such law shall be repealed or made conformable to such treaty. Neither shall any treaties be valid which are in contradiction to the Constitution of the United States, or the constitutions of the several states. 14. That the judiciary power of the United States shall be confined to cases affecting ambassadors, other public ministers, and consuls, to cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of different states, between citizens claiming lands under grants of different states, and between a state or the citizen thereof and foreign states, and, in criminal cases, to such only as are expressly enumerated in the Constitution, and that the United States in Congress assembled shall not have power to enact laws which shall alter the laws of descents and distribution of the effects of deceased persons, the titles of lands or goods, or the regulation of contracts in the individual states. After reading these propositions, we declared our willingness to agree to the plan, provided it was so amended as to meet these propositions, or something similar to them, and finally moved the convention to adjourn, to give the people of Pennsylvania time to consider the subject and determine for themselves. But these were all rejected, and the final vote was taken, when our duty to you induced us to vote against the proposed plan, and to decline signing the ratification of the same. During the discussion, we met with many insults and some personal abuse. We were not even treated with decency. During the sitting of the convention by the persons in the gallery of the House, however, we flattered ourselves that in contending for the preservation of those invaluable rights you have thought proper to commit to our charge, we acted with a spirit becoming freemen, and being desirous that you might know the principles which actuated our conduct, and being prohibited from inserting our reasons of dissent on the minutes of the convention, we have subjoined them for your consideration, as to you alone we are accountable. It remains with you whether you think those inestimable privileges which you have so ably contended for should be sacrificed at the shrine of despotism, or whether you mean to contend for them with the same spirit that has so often baffled the attempts of an aristocratic faction to rivet the shackles of slavery on you and your unborn posterity. Our objections are comprised under three general heads of dissent, viz. We dissent, first, because it is the opinion of the most celebrated writers on government, and confirmed by uniform experience, that a very extensive territory cannot be governed on the principles of freedom otherwise than by a confederation of republics, possessing all the powers of internal government, but united in the management of their general and foreign concerns. If any doubt could have been entertained of the truth of the foregoing principle, it has been fully removed by the concession of Mr. Wilson, one of the majority on this question, and who was one of the deputies in the late General Convention. In justice to him, we will give his own words. They are as follows, viz., quote, "The extent of country for which the new Constitution was required produced another difficulty in the business of the Federal Convention. It is the opinion of some celebrated writers that to a small territory, the democratical, to a middling territory, as Montesquieu has termed it, the monarchical, and to an extensive territory, the despotic form of government is best adapted. Regarding, then, the wide and almost unbounded jurisdiction of the United States, at first view, the hand of despotism seemed necessary to control, connect, and protect it, and hence the chief embarrassment rose. For we know that, although our constituents would cheerfully submit to the legislative restraints of a free government, they would spurn at every attempt to shackle them with despotic power." And, again, in another part of his speech, he continues, quote, "Is it probable that the dissolution of the state governments and the establishment of one consolidated empire would be eligible in its nature and satisfactory to the people in its administration? I think not, as I have given reason to shew that so extensive a territory could not be governed, connected, and preserved by the supremacy of despotic power. All the exertions of the most potent emperors of Rome were not capable of keeping that empire together, which in extent was far inferior to the domain of America." End quote. We dissent, secondly, because the powers vested in Congress by this Constitution must necessarily annihilate and absorb the legislative, executive, and judicial powers of the several states, and produce from their ruins one consolidated government, which from the nature of things will be iron-handed despotism, as nothing short of the supremacy of despotic sway could connect and govern these United States under one government. As the truth of this position is of such decisive importance, it ought to be fully investigated, and if it is founded to be clearly ascertained, for should it be demonstrated that the powers vested by this Constitution in Congress will have such an effect as necessarily to produce one consolidated government, the question then will be reduced to this short issue, viz., whether satiated with the blessings of liberty, whether repenting of the folly of so recently asserting their unalienable rights against foreign despots at the expense of so much blood and treasure, and such painful, arduous struggles, the people of America are now willing to resign every privilege of freedom and submit to the domain of an absolute government that will embrace all America in one chain of despotism, or whether they will, with virtuous indignation, spurn at the shackles prepared for them and confirm their liberties by a conduct becoming freemen. That the new government will not be a confederacy of states as it ought, but one consolidated government founded upon the destruction of the several governments of the states, we shall now shew. The powers of Congress under the new Constitution are complete and unlimited over the purse and the sword, and are perfectly independent of and supreme over the state governments, whose intervention in these great points is entirely destroyed. By virtue of their power of taxation, Congress may command the whole or any part of the property of the people. They may impose what imposts upon commerce. They may impose what land taxes, poll taxes, excise, duties on all written instruments, and duties on every other article that they may judge proper. In short, every species of taxation, whether of an external or internal nature, is comprised in section the 8th of article the 1st, viz., quote, the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States. End quote. As there is no one article of taxation reserved to the state governments, the Congress may monopolize every source of revenue and thus indirectly demolish the state governments, for without funds they could not exist. The taxes, duties, and excises imposed by Congress may be so high as to render it impracticable to levy further sums on the same articles. But whether this should be the case or not, if the state governments should presume to impose taxes, duties, or excises on the same articles with Congress, the latter may abrogate and repeal the laws whereby they are imposed upon the allegation that they interfere with the due collection of their taxes, duties, or excises, by virtue of the following clause, part of section 8th, article 1st, viz., quote, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or office thereof. End quote. The Congress might gloss over this conduct by construing every purpose for which the state legislatures now lay taxes to be for the general welfare, and therefore as of their jurisdiction. And the supremacy of the laws of the United States is established by Article 6th, viz., quote, that this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. End quote. It has been alleged that the words, quote, pursuant to the Constitution, end quote, are a restriction upon the authority of Congress, but when it is considered that by other sections they are invested with every efficient power of government, and which may be exercised to the absolute destruction of the state governments, without any violation of even the forms of the Constitution, this seeming restriction, as well as every other restriction in it, appears to us to be nugatory and delusive, and only introduced as a blind upon the real nature of the government. In our opinion, quote, pursuant to the Constitution, end quote, will be coextensive with the will and pleasure of Congress, which indeed will be the only limitation of their true powers. We apprehend that two coordinate sovereignties will be a solecism in politics, that therefore, as there is no line of distinction drawn between the general and state governments, as the sphere of their jurisdiction is undefined, it would be contrary to the nature of things, that both should exist together, or the one would necessarily triumph in fullness of domain. However, the contest could not be of long continuance, as the state governments are divested of every means of defense, and will be obliged by, quote, the supreme law of the land, end quote, to yield at discretion. It has been objected to this total destruction of state governments, that the existence of their legislatures is made essential to the organization of Congress, that they must assemble for the appointment of the senators and the President General of the United States. True, the state legislatures may be continued for some years as boards of appointment merely, after they are divested of every other function, but the framers of the Constitution, foreseeing that the people will soon be disgusted with the solemn mockery of a government without power and usefulness, have made a provision for relieving them from the imposition in section 4th of article 1st, viz., quote, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time, by law, make or alter such regulations, except as to the place of choosing senators. End quote. As Congress have the control over the time of the appointment of the President General and the senators of the representatives of the United States, they may prolong their existence in office for life by postponing the time of their election and appointment from period to period under various pretenses, such as an apprehension of invasion, the factious disposition of the people, or any other plausible pretense that the occasion may suggest, and, having thus obtained life estates in the government, they may fill up the vacancies themselves by the control over the mode of appointment, with this exception in regard to the senators, that as the place of appointment for them must, by the Constitution, be in the particular state, they may depute some body in the respective states to fill up the vacancies in the Senate occasioned by death, until they can venture to assume it themselves. In this manner may the only restriction in the clause be evaded. By virtue of the foregoing section, when the spirit of the people shall be gradually broken, when the general government shall be firmly established, and when a numerous standing army shall render opposition vain, the Congress may complete the system of despotism in renouncing all dependence on the people by continuing themselves and children in the government. The celebrated Montesquieu, in his Spirit of Laws, Volume 1, page 12, says, quote, that in a democracy there can be no exercise of sovereignty, but by the suffrages of the people, which are their will. Now the sovereign's will is the sovereign himself. The laws thereof, which establish the right of suffrage, are fundamental to this government. In fact, it is as important to regulate in a republic in what manner, by whom, and concerning what suffrages are to be given, as it is in a monarchy to know who is the prince, and after what manner he ought to govern. End quote. The time, mode, and place of the election of representatives, senators, and President General of the United States ought not to be under the control of Congress, but fundamentally ascertained and established. The new Constitution, consistently with the plan of consolidation, contains no reservation of the rights and privileges of the state governments, which was made in the Confederation of the year 1778 by Article the 2nd, viz., quote, that each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this Confederation expressly delegated to the United States in Congress assembled. The legislative power vested in Congress by the foregoing recited sections is so unlimited in its nature, may be so comprehensive and boundless in its exercise, that this alone would be amply sufficient to annihilate the state governments and swallow them up in the grand vortex of general empire. The judicial powers vested in Congress are also so various and extensive that by legal ingenuity they may be extended in every case, and thus absorb the state judiciaries. And when we consider the decisive influence that a general judiciary would have over the civil polity of several states, we do not hesitate to pronounce that this power, unaided by the legislative, would effect a consolidation of the states under one government. The powers of a court of equity vested by this Constitution in the tribunals of Congress, powers which do not exist in Pennsylvania, unless so far as they can be incorporated with jury trial, would, in this state, greatly contribute to this event. The rich and wealthy suitors would eagerly lay hold of infinite mazes, perplexities, and delays, which a court of chancery, with the appellate powers of the Supreme Court, in fact as well as law, would furnish him with, and thus the poor man, being plunged in the bottomless pit of legal discussion, would drop his demand in despair. In short, consolidation pervades the whole Constitution. It begins with an enunciation that such was the intention. The main pillars of the fabric correspond with it, and the concluding paragraph is a confirmation of it. The preamble begins with the words, quote, "We the people of the United States," end quote, which is the style of a compact between individuals entering into a state of society, and not that of a confederation of states. The other features of consolidation we have before noticed. Thus, we have fully established the proposition that the powers vested by this Constitution in Congress will effect a consolidation of the states under one government, which even the advocates of this Constitution admit could not be done without the sacrifice of liberty. 3. We dissent thirdly, because if it were practicable to govern so extensive a territory as these United States includes on the plan of a consolidated government, consistent with the principles of liberty and the happiness of the people, yet the construction of this Constitution is not calculated to obtain the object. For independent of the nature of the case, it would of itself necessarily produce a despotism, and that not by the usual gradations, but with the celerity that has hitherto only attended revolutions effected by the sword. To establish the truth of this position, a cursory investigation of the principles and form of this Constitution will suffice. The first consideration that this review suggests is the omission of a Bill of Rights ascertaining and fundamentally establishing those unalienable and personal rights of men, without the full, free, and secure enjoyment of which there can be no liberty, and over which it is not necessary for a good government to have the control. The principal of which are the rights of conscience, personal liberty, by the clear and unequivocal establishment of the writ of habeas corpus, jury trial in criminal and civil cases by an impartial jury of the vicinage or county, with the common law proceedings for the safety of the accused in criminal prosecutions, and the liberty of the press, that scourge of tyrants and the grand bulwark of every other liberty and privilege. The stipulations heretofore made in favor of them in the state constitutions are entirely superseded by this Constitution. The legislature of a free country should be so formed as to have competent knowledge of its constituents and enjoy their confidence. To produce these essential requisites, the representation ought to be fair, equal, and sufficiently numerous to possess the same interests, feelings, opinions, and views which the people themselves would possess were they all assembled, and so numerous as to prevent bribery and undue influence, and so responsible to the people by frequent and fair elections, as to prevent their neglecting or sacrificing the views and interests of their constituents to their own pursuits. We will now bring the legislature under this Constitution to the test of the foregoing principles, which will demonstrate that it is deficient in every essential quality of a just and safe representation. The House of Representatives is to consist of 65 members. This is one for about every 50,000 inhabitants, to be chosen every 2 years. 33 members will form a quorum for doing business, and 17 of these, being the majority, determine the sense of the House. The Senate, the other constituent branch of the legislature, consists of 26 members, being 2 from each state, appointed by their legislatures every 6 years. 14 senators make a quorum, the majority of whom, 8, determines the sense of that body. except in judging on impeachments or in making treaties or in expelling a member, when 2/3 of the senators present must concur. The President is to have the control over the enacting of laws, so far as to make the concurrence of 2/3 of the representatives and senators present necessary, if he should object to the laws. Thus it appears that the liberties, happiness, interests, and great concerns of the whole United States may be dependent upon the integrity, virtue, wisdom, and knowledge of 25 or 26 men. How inadequate and unsafe a representation! Inadequate because the sense and views of 3 or 4 millions of people diffused over so extensive a territory, comprising such various climates, products, habits, interests, and opinions, cannot be collected in so small a body, and besides, it is not a fair and equal representation of the people, even in proportion to its number, for the smallest state has as much weight in the Senate as the largest. And from the smallness of the number to be chosen for both branches of legislature, and from the mode of election and appointment, which is under the control of Congress, and from the nature of the thing, men of the most elevated rank in life will alone be chosen. The other orders in society, such as fanners, traders, and mechanics, who all ought to have competent number of their best informed men in legislature, will be totally unrepresented. The representation is unsafe, because in the exercise of such great powers and trusts it is so exposed to corruption and undue influence, by the gift of numerous places of honor and emoluments at the disposal of the executive, by the arts and addresses of the great and designing, and by direct bribery. The representation is moreover inadequate and unsafe because of the long terms for which it is appointed, and the mode of its appointment, by which Congress may not only control the choice of the people, but may so manage as to divest the people of this fundamental right and become self-elected. The number of members in the House of Representatives may be increased to 1 for every 30,000 inhabitants. But when we consider that this cannot be done without the consent of the Senate, who from their share in the legislative, in the executive, and judicial departments, and permanency of appointment, will be the great efficient body in this government, and whose weight and predominancy would be abridged by an increase of the representatives, we are persuaded that this is a circumstance that cannot be expected. On the contrary, the number of representatives will probably be continued at 65, although the population of the country may swell to treble what it now is, unless a revolution should effect a change. We have before noticed the judicial power as it would affect the consolidation of the states into one government. We will now examine it as it would affect the liberties and welfare of the people, supposing such a government were practicable and proper. The judicial power under the proposed Constitution is founded on the well-known principles of the civil law, by which the judge determines both on law and fact, and appeals are allowed from the inferior tribunals to the superior upon the whole question, so that facts as well as law would be re-examined, and even new facts brought forward in the Court of Appeals. And to use the words of a very eminent civilian, quote, the cause is many times another thing before the Court of Appeals than what it was at the time of the first sentence. End quote. That this mode of proceeding is the one which must be adopted under this Constitution is evident from the following circumstances. First, that the trial by jury, which is the grand characteristic of the common law, is secured by the Constitution only in criminal cases. Second, that the appeal from both law and fact is expressly established, which is utterly inconsistent with the principles of the common law and trials by jury. The only mode in which an appeal from law and fact can be established is by adopting the principles and practice of the civil law, unless the United States should be drawn into the absurdity of calling and swearing juries merely for the purpose of contradicting their verdicts, which would render juries contemptible and worse than useless. Third, that the courts to be established would decide on all cases of law and equity, which is a well-known characteristic of civil law, and these courts would have cognizance not only of the laws of the United States and of treaties, and of cases affecting ambassadors, but of all cases of admiralty and maritime jurisdiction, which last are matters belonging exclusively to the civil law in every nation in Christendom. Not to enlarge upon the loss of the individual right of trial by an unbiased jury, so dear to every friend of liberty, the monstrous expense and inconveniences of the mode of proceedings to be adopted are such as will prove intolerable to the people of this country. The lengthy proceedings of the civil law courts in the Chancery of England and in the courts of Scotland and France are such that few men of moderate fortune can endure the expense of it. The poor man must therefore submit to the wealthy. Length of purse will too often prevail against right and justice. For instance, we are told by the learned Judge Blackstone that a question only on the property of an ox, of the value of 3 guineas, originating under the civil law proceedings in Scotland, after many interlocutory orders and sentences below, was carried at length from the Court of Sessions, the highest court in that part of Great Britain, by way of an appeal to the House of Lords, where the question of law and fact was finally determined. He adds that no pick or spirit could in the Court of King's Bench or Common Pleas at Westminster have given continuance to such a cause for a 10th part of the time, nor have cost a 20th part of the expense. Yet the costs in the courts of King's Bench and Common Pleas in England are infinitely greater than those which the people of this country have ever experienced. We abhor the idea of losing the transcendent privilege of trial by jury, with the loss of which it is remarked by the same learned author that in Sweden the liberties of the commons were extinguished by an aristocratic senate, and that trial by jury and the liberty of the people went out together. At the same time, we regret the intolerable delay, the enormous expense, and infinite vexation to which the people of this country will be exposed from the voluminous proceedings of the courts of civil law, and especially from the appellate jurisdiction, by means of which a man may be drawn from the utmost boundaries of this extensive country to the seat of the Supreme Court of the nation to contend, perhaps, with a wealthy and powerful adversary. The consequence of this establishment will be an absolute confirmation of the power of aristocratical influence in the courts of justice, for the common people will not be able to contend or struggle against it. Trial by jury in criminal cases may also be excluded by declaring that the libeller, for instance, shall be liable to an action of debt for a specific sum, thus evading the common law prosecution by indictment and trial by jury, and the common course of proceeding against a ship for breach of revenue laws by information, which will be classed among civil cases, will at the civil law be within the resort of a court where no jury intervenes. Besides the benefit of jury trial, in cases of a criminal nature, which cannot be evaded, will be rendered of little value by calling the accused to answer far from home, there being no provision that the trial be by a jury of the neighborhood or country. Thus, an inhabitant of Pittsburgh, on a charge of crime committed on the banks of the Ohio, may be obliged to defend himself at the side of the Delaware, or so vice versa. To conclude this head, we observe that the judges of the courts of Congress would not be independent, as they are not debarred from holding other offices during the pleasure of the President and Senate, and as they may derive their support in part from fees alterable by the legislature. The next consideration that the Constitution presents is the undue and dangerous mixture of powers of government. The same body possessing legislative, executive, and judicial powers. The Senate is a constituent branch of the legislature. It has judicial power in judging on impeachments, and in this case unites in some measure the characters of judge and party, as all the principal officers are appointed by the President General, with the concurrence of the Senate, and therefore they derive their offices in part from the Senate. This may bias the judgments of the senators and tend to screen great delinquents from punishment. And the Senate has, moreover, various and great executive powers, viz., in concurrence with the President General, they form treaties with foreign nations that may control and abrogate the constitutions and laws of the several states. Indeed, there is no power, privilege, or liberty of the state governments, or of the people, but what may be effected by virtue of this power. For all treaties made by them are to be the supreme law of the land, anything in the Constitution or laws of any state to the contrary notwithstanding. And this great power may be exercised by the President and 10 senators, being 2/3 of 14, which is a quorum of that body. What an inducement would this offer to the ministers of foreign powers to compass by bribery such concessions as could not otherwise be obtained! It is the unvaried usage of all free states, whenever treaties interfere with the positive laws of the land, to make the intervention of the legislature necessary to give them operation. This became necessary and was afforded by the Parliament of Great Britain, in consequence of the late commercial treaty between that kingdom and France. As the Senate judges on impeachments, who is to try the members of the Senate for the abuse of this power? And none of the great appointments to office can be made without the consent of the Senate. Such various, extensive, and important powers combined in one body of men are inconsistent with all freedom, the celebrated Montesquieu tells us. When the legislative and executive powers are united in the same person, or in the same body of magistrates, there can be no liberty, because apprehensions may arise, lest the same monarch or senate should enact tyrannical laws to execute them in a tyrannical manner. Again, there is no liberty if the power of judging be not separated from the legislative and executive powers. Were it joined with the legislative, the life and liberty of the subject would be exposed to arbitrary control, for the judge would then be legislator. Were it joined to the executive power, the judge might behave with all the violence of an oppressor. There would be an end of everything. Were the same man, or the same body of nobles, or of the people, to exercise these three powers, that of enacting laws, that of executing the public resolutions, and that of judging the crimes or differences of individuals. The President General is dangerously connected with the Senate. His coincidence with the views of the ruling junto in that body is made essential to his weight and importance in the government, which will destroy all independency and purity in the executive department, and having the power of pardoning without the concurrence of a council, he may screen from punishment the most treasonable attempts that may be made on the liberties of the people when instigated by his coadjutors in the Senate. Instead of this dangerous and improper mixture of the executive with the legislative and judicial, the supreme executive powers ought to have been placed in the President, with a small independent council made personally responsible for every appointment to office or other act, by having their opinions recorded, and that without the concurrence of majority of the quorum of this council, the President should not be capable of taking any step. We have before considered internal taxation, as it would effect the destruction of the state governments, and produced one consolidated government. We will now consider that subject as it affects the personal concerns of the people. The power of direct taxation applies to every individual, as Congress under this government is expressly vested with the authority of laying a capitation or poll tax upon every person to any amount. This is a tax that, however oppressive in its nature and unequal in its operation, is certain as to produce and simple in its collection. It cannot be evaded like the objects of imposts or excise, and will be paid, because all that a man hath he will give for his head. This tax is so congenial to the nature of despotism that it has ever been a favorite under such governments. Some of those who were in the late General Convention from this state have long labored to introduce a poll tax amongst us. The power of direct taxation will further apply to every individual, as Congress may tax land, cattle, trades, occupations, etc., in any amount, and every object of internal taxation is of that nature, that however oppressive, the people will have but this alternative, except to pay the tax or let their property be taken, for all resistance will be in vain. The standing army and select militia would enforce the collection. For the moderate exercise of this power, there is no control left in the state governments, whose intervention is destroyed. No relief or redress of grievances can be extended as heretofore by them. There is not even a declaration of rights to which the people may appeal for the vindication of their wrongs in the court of justice. They must therefore implicitly obey the most arbitrary laws, as the worst of them will be pursuant to the principles and form of the Constitution, and that strongest of all checks upon the conduct of administration, responsibility to the people, will not exist in this government. The permanency of the appointments of senators and representatives, and the control the Congress have over their election, will place them independent of the sentiments and resentment of the people, and the administration having a greater interest in the government than in the community, there will be no consideration to restrain them from oppression and tyranny. In the government of this state, under the old Confederation, the members of the legislature are taken from among the people, and their interests and welfare are so inseparably connected with those of their constituents that they can derive no advantage from oppressive laws and taxes, for they would suffer in common with their fellow citizens, would participate in the burdens they impose on the community, as they must return to the common level after a short period. And notwithstanding every exertion of influence, every means of corruption, a necessary rotation excludes them from permanency in the legislature. The large state is to have but 10 members in that Congress, which is to have the liberty, property, and dearest concerns of every individual in this vast country, and absolute command. And even these 10 persons, who are to be our only guardians, who are to supersede the legislature of Pennsylvania, will not be of the choice of the people, nor amenable to them. For the mode of their election and appointment, they will consist of the lordly and high-minded, of men who will have no congenial feelings with the people, but a perfect indifference for and contempt of them. They will consist of those harpies of power that prey upon the very vitals, that riot on the miseries of the community. But we will suppose, although in all probability it may never be realized in fact, that our deputies in Congress have the welfare of their constituents at heart and will exert themselves in their behalf. What security could even this afford? What relief could they extend to their oppressed constituents? To attain this, the majority of the deputies of the 12 other states in Congress must be alike well disposed, must alike forego the sweets of power and relinquish the pursuits of ambition, which from the nature of things is not to be expected. If the people part with a responsible representation in the legislature, founded upon fair, certain, and frequent elections, they have nothing left they can call their own. Miserable is the lot of that people, whose every concern depends on the will and pleasure of their rules. Our soldiers will become Janissaries, and our officers of government bashaws. In short, the system of despotism will soon be completed. From the foregoing investigation, it appears that the Congress under this Constitution will not possess the confidence of the people, which is an essential requisite in a good government. For unless the laws command the confidence and respect of the great body of people, so as to induce them to support them, when called on by civil magistrate, they must be executed by the aid of a numerous standing army, which would be inconsistent with every idea of liberty. For the same force that may be employed to compel obedience to good laws might, and probably would, be used to wrest from the people their constitutional liberties. The framers of the Constitution appear to have been aware of this great deficiency, to have been sensible that no dependence could be placed on the people for their support, but on the contrary, that the government must be executed by force. They have therefore made a provision for this purpose in a permanent standing army and a militia, that may be subjected to as strict discipline and government. A standing army in the hands of government, placed so independent of the people, may be made a fatal instrument to overturn the public liberties. It may be employed to enforce the collection of most oppressive taxes, and to carry into execution the most arbitrary measures. An ambitious man, who may have the army at his own devotion, may step up into the throne and seize upon absolute power. The absolute unqualified command that Congress have over the militia may be made instrumental to the destruction of all liberty, both public and private, whether of a personal, civil, or religious nature. First, the personal liberty of every man, probably from 16 to 60 years of age, may be destroyed by the power Congress have in organizing and governing of the militia. As militia, they may be subjected to fines to any amount. Levied in a military manner, they may be subject to a corporal punishment of the most disgraceful and humiliating kind, and to death itself, by the sentence of a court-martial. To this our young men will be more immediately subjected, as a select militia, composed of them, will best answer the purpose of government. Secondly, the rights of conscience may be violated, as there is no exemption of those persons who are conscientiously scrupulous of bearing arms. These compose a respectable portion of the community in the state. This is more remarkable, because even when the distresses of the late war and the evident disaffection of many citizens of that description inflamed our passions, and when every person who was obliged to risk his own life must have been exasperated against such as on any account kept back from the common danger, yet even then, when outrage and violence might have been expected, the rights of conscience were held sacred. At this momentous crisis, the framers of our state constitution made the most express and decided declaration and stipulations in favor of the rights of conscience. But now, when no necessity exists, those dearest rights of men are left insecure. Thirdly, the absolute command of Congress over the militia may be destructive of public liberty, for under the guidance of an arbitrary government they may be made the unwilling instruments of tyranny. The militia of Pennsylvania may be marched to New England or Virginia to quell an insurrection occasioned by the most galling oppression, and aided by the standing army, they will, no doubt, be successful in subduing their liberty and independence, but in doing so, although the magnanimity of their minds will be extinguished, yet the meaner passions of resentment and revenge will be increased, and these in turn will be the ready and obedient instruments of despotism to enslave the others, and that with an irritated vengeance. Thus may the militia be made the instruments of crushing the last efforts of expiring liberty. of riveting the chains of despotism on their fellow citizens and on one another. This power can be exercised not only without violating the Constitution, but in strict conformity with it. It is calculated for the express purpose and will doubtless be executed accordingly. As this government will not enjoy the confidence of the people, but be executed by force, it will be a very expensive and burdensome government. The standing army must be numerous, and as a farther support, it will be the policy of this government to multiply officers in every department. Judges, collectors, tax gatherers, excisemen, and the whole host of revenue officers will swarm over the land, devouring the hard earnings of the industrious like the locusts of old, impoverishing and desolating all before them. We have not noticed the smaller nor many of the considerable blemishes, but have confined our objections to the great and essential defects, the main pillars of the Constitution, which we have shewn to be inconsistent with the liberty and happiness of the people, as its establishment will annihilate the state governments and produce one consolidated government that will eventually and speedily issue in the supremacy of despotism. In this investigation, we have not confined our views to the interests or welfare of the state in preference to others. We have overlooked all local circumstances. We have considered this subject on the broad scale of the general good. We have asserted the cause of the present and future ages, the cause of liberty and mankind. Nathaniel Bredding, John Smiley, Richard Baird, Adam Orth, John A. Hanna, John Whitehill, John Harris, Robert Whitehill, John Reynolds, Jonathan Hoag, Nicholas Lutz, William Todd, James Edgar, John Baird, William Findley, James Martin, Joseph Powell, Joseph Heister, John Bishop, Abraham Lincoln, John Ludwig. The yeas and nays upon the final vote were as follows, viz. Yeas: George Latimer, James Wilson, John Hunn, Benjamin Rush, Thomas McKeon, George Gray, Hilary Baker, William McPherson, Samuel Ashmead, Enoch Edwards, Sebastian Graff, William Wilson, Henry Wynkoop, John Hubley, John Boyd, John Barclay, Jasper Yates, Thomas Scott, Thomas Yardley, Henry Slagle, John Neville, Abraham Stout, Thomas Campbell, John Allison, Thomas Bull, Thomas Hartley, Jonathan Roberts, Anthony Wayne, David Greer, John Richards, William Gibbons, John Black, F.A. Muhlenberg, Richard Downing, Benjamin Padan, James Morris, Thomas Cheney, John Amt, Timothy Pickering, John Hannum, Stephen Balliet, Benjamin Elliott, Stephen Chambers, John Horsfield, Robert Coleman, David Deschler. 46 yeas. The nays: John Whitehill, John Bishop, James Edgar, John Harris, Joseph Heister, Nathaniel Bredding, John Reynolds, James Martin, John Smiley, Robert Whitehill, Joseph Powell, Richard Baird, Jonathan Hoag, William Findley, William Brown, Nicholas Lutz, John Baird, Adam Orth, John Ludwig, William Todd, John Andrew Hanna, Abraham Lincoln, James Marshall. Nays, 23. Philadelphia, December 12, 1787. Footnote 1. The journals of the conclave are still concealed. Footnote 2. The Continental Convention, in direct violation of the 13th article of the Confederation, have declared, quote, that the ratification of 9 states shall be sufficient for the establishment of this Constitution, between the states so ratifying the same, end quote. Thus has the plighted faith of the states been sported with. They had solemnly engaged that the Confederation now subsisting should be inviolably preserved by each of them, and the Union thereby formed should be perpetual, unless the same should be altered by mutual consent. End of section 48. Recorded by Robert Scott, June the 19th, 2007. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by Robert Scott. The Anti-Federalist Papers, Section 49. The Impartial Examiner, Letter 1. The Impartial Examiner, Virginia Independent Chronicle, Letter 1, 20 February, 1788. To the Free People of Virginia, countrymen and fellow citizens, that the subject which has given rise to the following observations is of the highest consequence to this country, requires not the aid of logical proof, that it merits the most serious attention of every member of this community, is a fact not to be controverted. Will not a bare mention of the new federal Constitution justify this remark? To foreigners or such whose local connections form no permanent interest in America, this may be totally indifferent, and to them it may afford mere matter of speculation and private amusement. When such advert to the high and distinguished characters who have drawn up and proposed a set of articles to the people of an extensive continent as a form of their future government, an emotion of curiosity may induce them to examine the contents of those articles, and they may, perhaps, from having contemplated on a former situation of those people, that they had struggled against a potent enemy, that they had, by their virtuous and patriotic exertions, rescued themselves from impending danger, that they had used like endeavors to establish for themselves a system of government upon free and liberal principles, that they had in pursuance of those endeavors chosen a system as conducive to the great ends of human happiness, the preservation of their natural rights and liberties, that this system has prevailed but few years, and now already a change, a fundamental change therein, is meditated. Strangers, I say, having contemplated on these circumstances, may be led to consider this nation as a restless and dissatisfied people, whose fickle, inconsistent minds suffer them not to abide long in the same situation, whose perpetually seeking after new things throw away one blessing in pursuit of another, and while they are thus indulging their caprice, lose all, ere any can ripen into maturity. If the unconcerned part of those among us entertain themselves in this manner, can any good American be content to deserve such reflections? Will not all rather feel an honest indignation if they once perceive their country stamped with a character like this? And yet, may we not justify such conceptions, if we thus precipitate ourselves into a new government before we have sufficiently tried the virtues of the old. So incident is error to the human mind, that it is not to be wondered at indeed if our present Constitution is incomplete. The best regulated governments have their defects, and might perhaps admit of improvement, but the great difficulty consists in clearly discovering the most exceptionable parts, and judiciously applying the amendments. A wise nation will therefore attempt innovations of this kind with much circumspection. They will view the political fabric, which they have once reared, as the sacred palladium of their happiness. They will touch it, as a man of tender sensibility toucheth the apple of his own eye. They will touch it with light, with a trembling, with a curious hand, lest they injure the whole structure in endeavoring to reform any of its parts. In small and trivial points alterations may be attempted with less danger, but where the very nature, the essence of the thing is to be changed, when the foundation itself is to be transformed, and the whole plan entirely new modeled, should you not hesitate, O Americans? Should you not pause and reflect a while on the important step you are about to take? Does it not behoove you to examine well into the nature and tendency of the Constitution now proposed for your adoption, and by comparing it with your present mode of government, endeavor to distinguish which of the two is most eligible, whether this or that is best calculated for promoting your happiness, for obtaining and securing those benefits which are the great object of civil society? Will it be consistent with the duty which you owe to yourselves as a nation, or with the affection which you ought to bear for your posterity, if you rashly or inconsiderately adopt a measure which is to influence the fate of this country for ages yet to come? How will it accord with your dignity and reputation as an independent people, if either through an overweening fondness for novelty you are suddenly transported on the wings of imagination, and too hastily make up your thoughts on this great subject, or by sinking into a listless inactivity of mind, view it as an indifferent matter unworthy of any deliberate consideration? Will any respect, will any honor, will any veneration be due to the memory of yourselves as ancestors, if millions of beings who have not yet received their birth, when you are all moldered into dust, should find themselves fixed in a miserable condition by one injudicious determination of yours at this period? If you see no impropriety in these questions, the suggestions contained in them will not appear altogether unworthy of attention. One moment's reflection, it is humbly presumed, will render it obvious that on this occasion they are not impertinently propounded. In pursuing this address, I beg leave to premise that the only true point of distinction between arbitrary and free governments seems to be, that in the former the governments are invested with powers of acting according to their own wills, without any other limits than what they themselves may understand to be necessary for the general good, whereas in the latter they are entrusted with no such unlimited authority, but are restrained in their operations to conform to certain fundamental principles, the preservation whereof is expressly stipulated for in the civil compact, and whatever is not so stipulated for is virtually and impliedly given up. Societies so constituted invest their supreme governors with ample powers of exerting themselves according to their own judgment in everything not inconsistent with or derogatory to those principles, and so long as they adhere to such restrictions, their deeds ought not to be rescinded or controlled by any other power whatsoever. Those principles are certain inherent rights pertaining to all mankind in a state of natural liberty, which through the weakness, imperfection, and depravity of human nature cannot be secured in that state. Men therefore agree to enter into society, that by the united force of many the rights of each individual may be protected and secured. These are in all just governments laid down as foundation to the civil compact, which contains a covenant between each and all, that they shall enter into one society to be governed by the same powers, establishes for that purpose the frame of government, and consequently creates a convention between every member, binding those who shall at any time be entrusted with power to a faithful administration of their trusting according to the form of the civil policy which they have so constituted, and obliging all to due obedience therein. There can be no other just origin of civil power but such mutual contract of all the people. And although their great object in forming society is an intention to secure their natural rights, yet the relations arising from this political union create certain duties and obligations to the state, which require a sacrifice of some portion of those rights and of that exuberance of liberty which obtains in a state of nature. This, however, being compensated by certain other adventitious rights and principles which are acquired by the social connection, it follows that the advantages derived from a government are to be estimated by the strength of the security which is attained at once with the least sacrifice and the greatest acquired benefits. That government, therefore, which is best adapted for promoting these three great ends must certainly be the best constituted scheme of civil policy. Here, then, it may not be improper to remark that persons forming a social community cannot take too much precaution when they are about to establish the plan of their government. They ought to construct it in such a manner as to procure the best possible security for their rights. In doing this, they ought to give up no greater share than what is understood to be absolutely necessary, and they should endeavor so to organize, arrange, and connect its several branches, that when duly exercised, it may tend to promote the common good of all, and contribute as many advantages as the civil institution is capable of. It has been before observed that the only just origin of civil power is a contract entered into by all the people for that purpose. If this proposition be true, and I dare presume it is not controverted, at least in this country, right reason will always suggest the expediency of adhering to the essential requisites in forming that contract upon true principles. A cautious people will consider all the inducements to enter into the social state, from the most important object down to the minutest prospect of advantage. Every motive with them will have its due weight. They will not pay a curious attention to trifles, and overlook matters of great consequence. And in pursuing these steps, they will provide for the attainment of each point in view with a care, with an earnestness proportionate to its dignity, and according as it involves a greater or lesser interest. It is evident, therefore, that they should attend most diligently to those sacred rights which they have received with their birth, and which can neither be retained to themselves nor transmitted to their posterity unless they are expressly reserved. For it is a maxim, I dare say, universally acknowledged, that when men establish a system of government, in granting the powers therein, they are always understood to surrender whatever they do not expressly reserve. This is obvious from the very design of the civil institution, which is adopted in lieu of the state of natural liberty, wherein each individual, being equally entitled to the enjoyment of all natural rights, and having equally a just authority to exercise full powers of acting, with relation to other individuals, in any manner not injurious to their rights, must, when he enters into society, be presumed to give up all those powers into the hands of the state by submitting this whole conduct to the direction thereof. This being done by every member, it follows, as a regular conclusion, that all such powers whereof the whole were possessed, so far as they related to each other individually, are of course given up by the mere act of union. If this surrender be made without any reservation, the conclusion is equally plain and regular, that each and all have given up, not only those powers which relate to the others, but likewise every claim which pertain to themselves as individuals, for the universality of the grant in this case must necessarily include every power of acting and every claim of possessing or obtaining anything, except according to the regulations of the state. Now a right being properly defined, a power or claim established by law, to act or to possess or to obtain something from others. For every natural right is such a power or claim established by the law of nature. Thus it is manifest, and in a society constituted after this manner, every right whatsoever will be under the power and control of the civil jurisdiction. This is the leading characteristic of an arbitrary government, and whenever any people establish a system like this, they subject themselves to one which has not a single property of a free constitution. Hence results the necessity of an express stipulation for all such rights as are intended to be exempted from the civil authority. Permit me now, my countrymen, to make a few observations on the proposed Federal Constitution. In this attempt, the subject, as it is arduous and difficult, naturally impresses the modest mind with diffidence. Yet being of the last importance, as involving in it the highest interest that free men can have, all that is dear and valuable to the citizens of the United States, a consciousness of the strong claim which this subject has to a free and general discussion, has prevailed over that discouraging idea so far as to produce the present address to you. This is done with a reliance on that benevolence and liberality of sentiment with which you have hitherto been actuated. From these benign qualities it is hoped the most favorable indulgence will be granted, and that the zeal with which this is written will be allowed in some measure as excuse for its defects. However imperfect, therefore, this may be, however inadequate to your own ideas or to the wishes of him who offers it to your consideration, you are hereby entreated to let the perusal with which you may think proper to favor it be serious, candid, dispassionate, as it relates to a common cause in which we are all concerned. Suffer me then in the first place to advert to a point of the 6th article in this Constitution. It may perhaps appear somewhat irregular to begin with this article, since it is almost the last proposed. Yet if it be considered that this at once defines the extent of congressional authority and indisputably fixes its supremacy, every idea of impropriety on this head will probably vanish. The cause alluded to contains the following words: "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all the treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every State shall be bound thereby. Anything in the Constitution or laws of any State to the contrary, notwithstanding." If this Constitution should be adopted here, the sovereignty of America is ascertained and fixed in the federal body at the same time that it abolishes the present independent sovereignty of each State. Because this government, being general and not confined to any particular part of the continent, but pervading every State and establishing its authority equally in all, its superiority will consequently be recognized in each, and all other powers can operate only in a secondary subordinate degree. For the idea of two sovereignties existing within the same community is a perfect solecism. If they be supposed equal, their operation must be commensurate and like two mechanical powers of equal momenta counteracting each other. There the force of the one will be destroyed by the force of the other, and so there will be no efficiency in either. If one be greater than the other, they will be similar to two unequal bodies in motion with a given degree of velocity, and impining each other from opposite points. The motion of the lesser in this case will necessarily be destroyed by that of the greater, and so there will be efficiency only in the greater. But what need is there for a mathematical deduction to shew the impropriety of two such distinct coexisting sovereignties? The natural understanding of all mankind perceives the apparent absurdity arising from such a supposition, since if the word means anything at all, it must mean that supreme power which must reside somewhere in State, or, in other terms, it is the united powers of each individual member of the State collected and consolidated into one body. This collection, this union, this supremacy of power can, therefore, exist only in one body. This is obvious to every man, and it has been very properly suggested that under the proposed Constitution each State will dwindle into "the insignificance of a town corporate." This certainly will be their utmost consequence, and as such they will have no authority to make laws, even for their own private government, any further than the permissive indulgence of Congress may grant them leave. This, Virginians, will be your mighty, your enviable situation after all your struggles for independence. And if you take the trouble to examine, you will find that the great, the supereminent authority with which this instrument of union proposes to invest the federal body is to be created without a single check, without a single article of convention for the preservation of those inestimable rights which have in all ages been the glory of freemen. It is true, "The United States shall guarantee to every State in this Union a republican form of government." End quote. Yet they do not guarantee to the different states their present forms of government, or the Bill of Rights thereto annexed, or any of them, and the expressions are too vague, too indefinite, to create such a compact by implication. It is possible that a "republican form" of government may be built upon as absolute principles of despotism as any Oriental monarchy ever yet proposed. I presume that the liberty of a nation depends not on planning the frame of government, which consists merely in fixing and delineating the powers thereof, but on prescribing due limits to those powers and establishing them upon just principles. It has been held in a Northern State by a zealous advocate for this Constitution that there is no necessity for "a Bill of Rights" in the federal government, although at the same time he acknowledges such necessity to have existed when the constitutions of the separate governments were established. He confesses that in these instances the people "invested their representatives with every power and authority which they did not in explicit terms reserve," but "in delegating federal powers," says he, "everything which is not given is reserved." Here is a distinction, I humbly conceive, without a difference, at least in the present enquiry. How far such a discrimination might prevail with respect to the present system of union, it is immaterial to examine; and had the observation been restrained to that alone, perhaps it might be acknowledged to contain some degree of propriety. For under the Confederation it is well known that the authority of Congress cannot extend so far as to interfere with, or exercise any kind of coercion on, the powers of legislation in the different States; but the internal police of each is left free, sovereign, and independent, so that the liberties of the people, being secured as well as the nature of their constitution will admit, and the Declaration of Rights which they have laid down as the basis of government having their full force and energy, any further stipulation on the head might be unnecessary. But surely, when this doctrine comes to be applied to the proposed federal constitution, which is framed with such large and extensive powers as to transfer the individual sovereignty from each State to the aggregate body, a constitution which delegates to Congress an authority to interfere with and restrain the legislatures of every State, invests them with supreme powers of legislation throughout all States, annihilates the separate independency of each, and, in short, swallows up and involves in the plenitude of its jurisdiction all other powers whatsoever. I shall not be taxed with arrogance in declaring such an argument to be fallacious, and insisting on the necessity of a positive, unequivocal declaration in favor of the rights of free men in this case even more strongly than in the case of their separate governments; for it seems to me that when any civil establishment is formed, the more general its influence, the more extensive the powers with which it is invested, the greater reason there is to take the necessary precaution from securing a due administration and guarding against unwarrantable abuses. Section 49. The Impartial Examiner, Letter 1. Recording by Robert Scott, June the 20th, 2007. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by Robert Scott, The Anti-Federalist Papers, Section 50, Impartial Examiner, Letter 2. Impartial Examiner, Letter 2, 27 February 1788, continued from our last. Section 8th of the first article gives the Congress a power to, quote, lay and collect taxes, duties, imposts, and excises, end quote. If it be a true maxim that those who are entrusted with the exercise of the higher powers of government ought to observe two essential rules. First, in having no other view than the general good of all without any regard to private interest. And secondly, to take equal care of the whole body of the community, so as not to favor one part more than the other. It is apparent that under the proposed Constitution, this general Confederate society, made up of 13 different states, will have very little security for obtaining an observance either of the one or of the other rule. For being different societies, though blended together in legislation and having as different interests, no uniform rule for the whole seems to be practicable, and hence it is to be feared that the general good may be lost in a mutual attention to private views. From the same causes we may lament the probability of losing the advantage of the second rule, for it may be expected in like manner that the general care of the whole will be lost by separate endeavors of different legislators to favor their own states. So long as mankind continues to be influenced by interest, the surest means of effecting a union of councils in any assembly is by a union of interests. Now, if it be considered that it is this concert, that it is this union in promoting the general good, which alone can preserve concord in this great republic, and secure its success and glory, unhappy will be the situation of America if she once precludes the beneficial effects of such a good understanding. Yet I apprehend that these evils may result in a great measure from an exercise of that branch of legislative authority which respects internal direct taxation. For in this it is scarcely probable that the interest, ease, or convenience of the several states can be so well consulted in the federal assembly as in their own respective legislatures. So different are many species of property, so various the productions, so unequal the profits arising even from the same species of property in different states, that no general mode of contribution can well be adopted in such a manner as at once to affect all in an equitable degree. Hence may arise disagreeable objects of contention. A diversity of interests will produce a diversity of schemes. Thus, each state, as it is natural, will endeavor to raise a revenue by such means as may appear least injurious to its own interest. A source of dissension manifestly detrimental to the harmony which is necessary to support the Confederation. I cannot conceive it impracticable to reform the federal system in such a manner as to ensure a compliance with the necessary requisitions of Congress from the different state legislatures. Then all the several states being left to raise their own share of the revenue, and being the only proper judges of the mode most convenient to themselves, it is highly probable that this important branch of government would be carried on more generally to the satisfaction of each state, and would tend to promote a spirit of concord between all the parts of this great community, because each being thus accommodated and participating the advantages of the Union, none subjected to any inconvenience thereby, all would consequently concur in nourishing an affection for the government which so cemented them. I believe it is acknowledged that the establishment of excise has been one of the greatest grievances under which the English nation has labored for almost a century and a half. Although this may seem an economical tax arising out of manufactures, from which the industrious may derive advantages, and whereof the wealthy, by consuming the greatest share, will of course contribute the largest proportion of the tax, yet the nature of it being such as requires severe laws for its execution, it has justly become an object of general detestation. This has induced Judge Blackstone to declare that, "the rigor and arbitrary proceedings of excise laws seems hardly compatible with the temper of a free nation." While therefore you are free men, while you are unused to feel any other power, by such as can be exercised within the bounds of moderation and decency, it doubtless behooves you to consider whether it is an eligible step to subject yourselves to a new species of authority, which may warrant the most flagrant violations of the sacred rights of habitation. If this branch of revenue takes place, all the consequent rigor of excise law will necessarily be introduced in order to enforce a due collection. On any charges or offense in this instance, you see yourselves deprived of your boasted trial by jury. The much admired common law process will give way to some quick and summary mode, by which the unhappy defendant will find himself reduced, perhaps to ruin, in less time than a charge could be exhibited against him in the usual course. It has ever been held that standing armies in times of peace are dangerous to a free country, and no observation seems to contain more reason in it. Besides being useless, as having no object of employment, they are inconvenient and expensive. The soldiery, who are generally composed of the dregs of the people, when disbanded or unfit for military service, being equally unfit for any other employment, become extremely burdensome, as they are a body of men exempt from the common occupations of social life, having an interest different from the rest of the community. They wanton in the lapse of ease and indolence, without feeling the duties which arise from the political connection, though drawing their subsistence from the bosom of the state. The severity of discipline necessary to be observed reduces them to a degree of slavery. The unconditional submission to the commands of their superiors, in which they are bound, renders them the fit instruments of tyranny and oppression. Hence they have in all ages afforded striking examples of contributing more or less to enslave mankind, and whoever will take the trouble to examine will find that by far the greater part of the different nations who have fallen from the glorious state of liberty owe their ruin to standing armies. It has been urged that they are necessary to provide against sudden attacks. Would not a well-regulated militia, duly trained, to discipline afford ample security? Such I conceive to be the best, the surest means of protection which a free people can have when not actually engaged in war. This kind of defense is attended with two advantages superior to any other. First, when it is necessary to embody an army, they at once form a band of soldiers, whose interests are uniformly the same with those of the whole community, and in whose safety they see involved everything that is dear to themselves. Secondly, if one army is cut off, another may be immediately raised, already trained for military service. By a policy somewhat similar to this, the Roman Empire rose to the highest pitch of grandeur and magnificence. The Supreme Court is another branch of federal authority, which wears the aspect of imperial jurisdiction, clad in a dread array, and spreading its wide domain into all parts of the continent. This is to be coextensive with the legislature, and like that is to swallow up all other courts of judicature. For what is that judicial power which, shall extend to all cases in law and equity, in some having, original, in all others, appellate jurisdiction, but an established universal in its operation? And what is that, appellate jurisdiction, both as to law and fact, but an establishment which may in effect operate as original jurisdiction? Or what is an appeal to inquire into facts after a solemn adjudication in any court below, but a trial de novo? And do not such trials clearly imply an incompetency in the inferior courts to exercise any kind of judicial authority with rectitude? Hence, will not this eventually annihilate their whole jurisdiction? Here is a system of jurisprudence to be erected, no less surprising than it is new and unusual. Here is an innovation which bears no kind of analogy to anything that Englishmen or Americans, the descendants of Englishmen, have ever yet experienced. Add to all that this high prerogative court establishes no fundamental rule of proceeding except that the trial by jury is allowed in some criminal cases. All other cases are left open and subject, to such regulations as the Congress shall make. Under these circumstances, I beseech you all, as citizens of Virginia, to consider seriously whether you will not endanger your solemn trial by jury, which you have long revered as a sacred barrier against injustice, which has been established by your ancestors many centuries ago, and transmitted to you as one of the greatest bulwarks of civil liberty, which you have to this day maintained inviolate. I beseech you, I say, as member of this commonwealth, to consider whether you will not be in danger of losing this inestimable mode of trial in all those cases wherein the Constitution does not provide for its security. Nay, does not that very provision, which is made by being confined to a few particular cases, almost imply a total exclusion of the rest? Let it then be a reflection deeply impressed on your minds, that if this noble privilege, by which long experience has been found the most exquisite method of determining controversies according to the scale of equal liberty, should once be taken away, it is unknown what new species of trial may be substituted in its room. Perhaps you may be surprised with some strange piece of judicial polity, some arbitrary method, perhaps confining all trials to the entire decision of the magistrate, and totally excluding the great body of the people from any share in the administration of public justice. To be continued. End of section 50. Recorded by Robert Scott, June the 22nd, 2007. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by Robert Scott. The Anti-Federalist Papers, section number 51, Impartial Examiner, letter 3. Impartial Examiner, letter 3, 5th of March, 1788. Concluded from our last. After the most deliberate reflections on this important matter, permit me, my dear countrymen, to declare to you in the most unfeigned manner that, not perceiving anything in the proposed plan of government which seems calculated to ensure the happiness of America, I could not, as a fellow citizen, resist the inclination to impart these sentiments to you, unmoved by party, rage, unassailed by passion, uninfluenced by any other interest but the genuine effusal of zeal for this, our common country. I confess to you in the language of sincerity and candor that after the first reading of this new code, I could not behold it but with an eye of disapprobation. Unwilling, however, to reject at first sight an object of such high moment, I resolved to distrust the propriety of a construction passed on so early a period. This led me to pursue it with the utmost diligence I was capable of, and believe me, the foregoing observations have risen from the fullest conviction that the system involves in it the most dangerous principles, and so far from exalting the standard of American liberty, I fear that, should it be adopted, this glorious work, which already has cost the lives of many worthy patriots, will ere long be leveled with the dust. Let it not be conjectured from hence that any illiberal conceptions are formed by the writer hereof respecting the intentions of those gentlemen who have offered this plan of federal government. He knows no circumstance inducing him to suppose they had any other object in view but the good of their country. When we contemplate the great, the magnanimous hero, who has conducted our armies through all the trying vicissitudes of danger and difficulty, there is no man so disingenuous, there is no man so ungrateful, as to impute any transactions of his to sinister motives. Every true American is well assured that steadiness of virtue, that benignity of soul, have the chief rule in all his actions. Yet every American and every other person are satisfied also that there is no infallibility in human nature. To be man is to be subject to error. The best, the greatest, the wisest are liable to commit mistakes. Let it be remembered, then, that this code of government is solemnly proposed to every free man in America. For what? For the purpose of binding them without their approbation? No. For an implicit acceptance? No. For their adoption merely in compliment to the General Convention? No. What then? Every man's duty to his country points out to him the end of this proposition. Every man knows that it is for a free, a candid, and impartial discussion and determination thereon, whether they will approve and adopt it, or whether they will disapprove and reject it. Can any citizen, therefore, be so weak? Can any be so timid, so pusillanimous as to acknowledge that he has no right to exercise his own judgment with regard to this matter? If there should be any haughty spirits among us who think that this subject ought to be handled by none but a few persons of eminent character, let such recollect that the dignity, the importance of their country should inspire sentiments more exalted than the highest characters, sentiments that should correspond with the worth of America, not with the consequence of any mere individuals. Will you then, Virginians, arrogate too much by boldly asserting the privilege to judge for yourselves in what so nearly concerns the cause of liberty? No, no, my countrymen, you will not arrogate too much. You will not. I avow it by the souls of those brave patriots who fought for the same cause in the late war. You will in this affair act as becomes you. The rank you hold amongst the nations of the earth requires this of you, and you will forfeit that rank. You will forfeit the character of free men, and shew that you deserve to be enslaved if you decline that privilege. The happiness of a multitude of people is certainly the highest advantage, and if you will contribute a full share of duty to effect this, so shall you obtain a due share of glory. No pomp of character, no sound of names, no distinction of birth, no preeminence of any kind should dispose you to hoodwink your own understandings, and in that state suffer yourselves to be led at the will of any other men whatsoever. The part you have acted heretofore, the brave, the noble efforts you have made, are proof enough of your fortitude, and totally exclude every idea of pusillanimity. Herein you have evinced the highest sense of public virtue. Herein you have manifested to the whole world that the cause of liberty has hitherto had the prevailing influence over your hearts. And shall men, possessed of these sentiments, shall those valiant defenders of their country, who have not feared to encounter toil and danger in 1,000 shapes, who have not startled even at the prospect of death itself, shall you, O Virginians, shall you, I say, after exhibiting such bright examples of true patriotic heroism, suddenly become inconsistent with yourselves, and will fail to maintain a privilege so incontestably your due? No, my countrymen, by no means can I conceive that the laudable vigor which flamed so high in every breast can have so far evaporated in the space of 5 years. I doubt not, but you will in this trying instance acquit yourselves in a manner worthy of your former conduct. It is not to be feared that you need the force of persuasion to exercise a proper freedom of enquiry in the merits of this proposed plan of government, or that you will not pay a due attention to the welfare of that country for which you have already so bravely exerted yourselves. Of this I am well assured, and do not wonder when imagination presents to my view the idea of a numerous and respectable body of men reasoning on the principles of this federal constitution. If herein I conceive that you are alarmed at the exceedingly high and extensive authority which it is intended to establish, I cannot but see the strongest reasons for such apprehensions, for a system which is to supersede the present different governments of the States, by ordaining that, laws made in pursuance thereof shall be supreme, and shall bind the judges in every State. Anything in the Constitution or laws of any State to the contrary notwithstanding," must be alarming indeed. What cannot this omnipotence of power effect? How will your Bill of Rights avail you anything? By this authority the Congress can make laws which shall bind all, repugnant to your present Constitution, repugnant to every article of your rights, for they are a part of your Constitution, they are the basis of it, so that if you pass this new Constitution, you will have a naked plan of government, unlimited in its jurisdiction, which not only expunges your Bill of Rights by rendering ineffectual all the State governments, but is proposed without any kind of stipulation for any of those natural rights, the security whereof ought to be the end of all governments. Such a stipulation is so necessary that it is an absurdity to suppose any civil liberty can exist without it, because it cannot be alleged in any case whatsoever that a breach has been committed, that a right has been violated, as there will be no standard to resort to, no criterion to ascertain the breach, or even to find whether there has been any violation at all. Hence it is evident that the most flagrant acts of oppression may be inflicted, yet still there will be no apparent object injured. There will be no unconstitutional infringement. For instance, if Congress should pass a law that persons charged with capital crimes shall not have a right to demand the cause or nature of the accusation, shall not be confronted with the accuser or witnesses, or call for evidence in their own favor, and a question should arise respecting their authority therein, can it be said that they have exceeded the limits of their jurisdiction, when that has no limits, when no provision has been made for such a right, when no responsibility on the part of Congress has been required by the Constitution? The same observation may be made on any arbitrary or capricious imprisonments contrary to the law of the land. The same may be made if excessive bail should be required, if excessive fines should be imposed, if cruel and unusual punishment should be inflicted, if the liberty of the press should be restrained. In a word, if laws should be made totally derogatory to the whole catalogue of rights which are now secured under your present form of government. You will doubtless consider whether the inconveniences may not be very disagreeable, and perhaps injurious, to which this country may be subjected by excise laws, by direct taxation of every kind, by the establishment of feudal courts. You will advert to the dangerous and oppressive consequences that may ensue from the introduction of standing armies in times of peace, those baneful energies of ambition, against which free nations have always guarded with the greatest degree of caution. You will determine likewise as to the propriety of being excluded from keeping ships of war without the consent of Congress. This situation of these States renders a naval force extremely desirable, being bounded on one side by the sea. Their coasts are accessible to every lawless adventurer, and without ships to guard them, they are subject to continual depredations. The expediency of this species of defense is manifest. The great advantages to be derived from it, the strength, the consequence which it adds to a nation, are such that every well-wisher to this country would rejoice to see a large navy established, as the circumstances of the state can at any time admit of. This, therefore, seems to be a very improper restraint upon the States, a restraint which may perhaps eventually prove very injurious. Upon the whole, my fellow citizens, if you judge this proposed Constitution to be eligible or ineligible, you will accordingly instruct your delegates when they are about to meet in convention. The wisdom of the legislature has judged it advisable to fix the time for deciding on this momentous business at the distance of several months, that you may become thoroughly acquainted with a subject which so nearly concerns your greatest interests. I know it is a favorite topic with the advocates for the new government, that it will advance the dignity of Congress, and that the energy which is now wanting in the federal system will be hereby rendered efficient. Nobody doubts but the government of the Union is susceptible of amendment. But can anyone think that there is no medium between want of power and the possession of it in an unlimited degree? Between the imbecility of mere recommendatory propositions and the sweeping jurisdiction of exercising every branch of government over the United States to the greatest extent? Between the present feeble texture of the Confederation and the proposed nervous ligaments? Is it not possible to strengthen the hands of Congress so far as to enable them to comply with all the exigencies of the Union, to regulate the great commercial concerns of the continent, to superintend all affairs which relate to the United States in their aggregate capacity, without devolving on that body the supreme powers of government in all its branches? The original institution of congressional business, the nature, the end of that institution, evince the practicability of such reform, and shew that it is more honorable, more glorious, and will be more happy for each American state to retain its independent sovereignty. For what can be more truly great in any country than a number of different states in the full enjoyment of liberty, exercising distinct powers of government, yet associated by one general head, and under the influence of a mild, just, and well organized confederation duly held in equilibria, whilst all derive those external advantages which are the greatest purpose of the Union? This separate independency existing in each, this harmony pervading the whole, this due degree of energy in the federal department, all together will form a beautiful species of natural grandeur. These will add luster to every member, and spread a glory all around. These will command the admiration of mankind. These will exhibit a bright specimen of real dignity, far superior to that immense devolution of power under which the sovereignty of each state shall shrink to nothing. It requires no great degree of knowledge in history to learn what dangerous consequences generally result from large and extensive powers. Every man has a natural propensity to power, and when one degree of it is obtained, that seldom fails to excite a thirst for more. A higher point being gained, still the soul is impelled to a further pursuit. Thus, step by step, in regular progression, she proceeds onward until the lust of domination becomes the ruling passion and absorbs all other desires. When any man puts himself under the influence of such a passion, it is natural for him to seek after every opportunity, and to employ every means within reach for obtaining his purpose. There is something so exceedingly bewitching in the possession of power that hardly a man can enjoy it, and not be affected after an unusual manner. The pomp of superiority carries with it charms which operate strongly on the imagination. Nay, it is a melancholy reflection that too often the very disposition itself is transformed, and for the gratification of ambitious views, the mild, the gentle, humane, the virtuous becomes cruel and violent, losing all sense of honor, probity, humanity, and gratitude. Hence, should it not be a maxim, never to be forgotten, that a free people ought to entrust no set of men with powers that may be abused without control, or afford opportunities to designing men to carry dangerous measures into execution, without being responsible for their conduct. And as no human foresight can penetrate so far into future events as to guard always against the effects of vice, as the securest governments are seldom secure enough, is it not the greatest imprudence to adopt a system which has an apparent tendency to furnish ambitious men with the means of exerting themselves, perhaps to the destruction of American liberty? It is next to impossible to enslave a people immediately after a firm struggle against oppression, while the sense of past injury is recent and strong. But after some time this impression naturally wears off, the ardent glow of freedom gradually evaporates, the charms of popular equality, which arose from the republican plan, insensibly decline, the pleasures, the advantages derived from the new kind of government grow stale through use. Such declension in all these vigorous springs of action necessarily produces a supineness. The altar of liberty is no longer watched with such attentive assiduity. A new train of passions succeeds to the empire of the mind. Different objects of desire take place, and if the nation happens to enjoy a series of prosperity, voluptuousness, excessive fondness for riches, and luxury gain admission and establish themselves, these produce venality and corruption of every kind, which open a fatal avenue to bribery. Hence it follows that in the midst of this general contagion a few men, or one, more powerful than all others, industriously endeavor to obtain all authority, and by means of great wealth or embezzling the public money, perhaps totally subvert the government, and erect a system of aristocratical or monarchic tyranny in its room. What ready means for this work of evil are numerous standing armies and the disposition of the great revenue of the United States. Money can purchase soldiers, soldiers can produce money, and both together can do anything. It is this depravation of manners, this wicked propensity, my dear countrymen, against which you ought to provide with the utmost degree of prudence and circumspection. All nations pass this paroxysm of vice, at some period or another, and if at that dangerous juncture your government is not secure upon a solid foundation, and well guarded against the machinations of evil men, these liberties of this country will be lost perhaps forever. Let us establish a strong federal government which shall render our Congress a great and eminent body, says one. By all means, replies another, and then they will command the attention of all Europe. Who, pray, what will it avail you in the hour of distress, in the midst of calamity, though all Europe should pay attention to the Congress? What advantage will it be to the citizens of America should they elevate Congress to the highest degree of grandeur, should the sound of that grandeur be wafted across the Atlantic and echo through every town in Europe? What will the pomp, the splendor of that dignified body profit you, I say, if you place yourselves in a situation which may terminate in wretchedness? Of what consequence will that state of congressional preeminence be to you, or to your posterity, if either the one or the other should thereby be reduced to a mere herd of, O great God, avert that dreadful catastrophe. Let not the day be permitted to dawn which shall discover to the world that America remains no longer a free nation. O let not this sacred asylum of persecuted liberty cease to afford a resting place for that fair goddess. Reanimate each spirit that languishes in the glorious cause. Shine in upon us and illuminate all our counsels. Suffer thy bright ministers of grace to come down and direct us. And hovering for a while on the wings of affection, breathe into our souls true sentiments of wisdom, that in this awful, this important moment, we may be conducted safely through the maze of error, that a firm basis of national happiness may be established and flourish in undiminished glory through all the succeeding ages. End of section 51. Recorded by Robert Scott, June the 23rd, 2007. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by Robert Scott. The Anti-Federalist Papers, section number 52, letter number 4, a farmer. A farmer. Baltimore, Maryland Gazette, letter 4, March 18, 1788. The opposite qualities of the first Confederation were rather caused by than the cause of two parties, which from its first existence began and have continued their operations, I believe, unknown to their country and almost unknown to themselves. As really but few men have the capacity or resolution to develop the secret causes which influence their daily conduct. The old Congress was a national government and a union of states, both brought into one political body. As these opposite powers, I do not mean parties, were so exactly blended and very nearly balanced, like every artificial operative machine where action is equal to reaction. It stood perfectly still. It would not move at all. Those who were merely confederal in their views were for dividing the public debt. Those who were for national government were for increasing of it. Those who thought any national government would be destructive to the liberties of America assisted those who thought it our only safety to put everything as wrong as possible. Requisitions were made which everybody knew it was impossible to comply with. Either in 82 or 83, 10 millions of hard dollars, if not 13, were called into the Continental Treasury, when there could not be half that sum in the whole tract of territory between Nova Scotia and Florida. The states neglected them in despair. The public honor was tarnished, and our governments abused by their servants and best friend. In fine, it became a cant word, things are not yet bad enough to mend. However, as a great part of the important objects of society were entrusted to this mongrel species of general government, the sentiment of pushing it forward became general throughout America, and the late convention met at Philadelphia under the uniform impression that such was the desire of their constituents. But even then, the advantages and disadvantages of national government operated so strongly, although silently, on each individual that the conflict was nearly equal. A third or middle opinion, which always arises in such cases, broke off and took the lead. The national party, thus assisted, pursued steadily their object. The federal party dropped off one by one, and finally, when the middle party came to view, the offspring which they had given birth to, and in a great measure reared, several of them immediately disowned the child. Such has been hitherto the progress of party, or rather of the human mind, dispassionately contemplating our separate and relative situation, and aiming at that perfect completion of social happiness and grandeur, which perhaps can be combined only in ideas. Every description of men entertain the same wishes, except perhaps a very few bad men of each. They forever will differ about the mode of accomplishment, and some must be permitted to doubt them practicably. As our citizens are now apprised of the progress of parties or political opinions on the continent, it is fit they should also be informed of the present state, force, and designs of each, in order that they may form their decisions with safety to the public and themselves. This shall be given with all the precision and impartiality that the author is capable of. America is at present divided into three classes or descriptions of men, and in a few years there will be but two. First, the first class comprehends all those men of fortune and reputation who stepped forward in the late Revolution from opposition to the administration rather than the government of Great Britain, all those aristocrats whose pride disdains equal law, many men of very large fortune who entertain real or imaginary fears for the security of property, those young men who have sacrificed their time and their talents to public service without any prospects of an adequate pecuniary or honorary reward, all your people of fashion and pleasure who are corrupted by the dissipation of the French, English, and American armies, and a love of European manners and luxury, the public creditors of the continent, whose interest has been heretofore sacrificed by their friends in order to retain their services on this occasion. A large majority of the mercantile people, which is at present a very unformed and consequently dangerous interest. Our old native merchants have been almost universally ruined by the receipt of their debts in paper during the war, and the payment in hard money of what they owed their British correspondents since peace. Those who are not bankrupts have generally retired and given place to a set of young men, who, conducting themselves as ravishingly as ignorantly, have embarrassed their affairs and lay the blame on the government, and who are really unacquainted with the true mercantile interest of the country, which is perplexed from circumstances rather temporary than permanent. The foreign merchants are generally not to be trusted with influence in our government. They are, most of them, birds of passage. Some perhaps British emissaries, increasing and rejoicing in our political mistakes, and even those who have settled among us with an intention to fix themselves and their posterity in our soil, have brought with them more foreign prejudices than wealth. Time must elapse before the mercantile interest will be so organized as to govern themselves, much less others, with propriety. And lastly, to this class, I suppose we may ultimately add the Tory interest, with the exception of very many respectable characters, who reflect, with a gratification mixed with disdain, that those principles are now become fashionable for which they have been persecuted and hunted down, which, although by no means so formidable as is generally imagined, is still considerable. They are at present wavering. They are generally, though with very many exceptions, openly for the proposed, but secretly against any American government. A burnt child dreads the fire. But should they see any fair prospect of confusion arise, these gentry will be off at any moment for these 25 years to come. Ultimately, should the administration promise stability to the new government, they may be counted on as the Janissaries of power, ready to efface all suspicion by the violence of their zeal. In general, all these various people would prefer a government as nearly copied after that of Great Britain as our circumstances will permit. Some would strain these circumstances. Others still retain a deep-rooted jealousy of the executive branch and strong Republican prejudices, as they are called. Finally, this class contains more aggregate wisdom and more virtue than both the other two together. It commands nearly 2/3 of the property and almost 1/2 of the numbers of America, and has at present become almost irresistible from the name of the truly great and amiable man who, it has been said, is disposed to patronize it, and from the influence which it has over the second class. The first class is nearly at the height of their power. They must decline or moderate, or another revolution will ensue, for the opinion of America is becoming daily more unfavorable to those radical changes which high-toned government requires. A conflict would terminate in the destruction of this class, or the liberties of their country. May the guardian angel of America prevent both. Second, the second class is composed of those descriptions of men who are certainly more numerous with us than in any other part of the globe. First, those men who are so wise as to discover that their ancestors, and indeed all the rest of mankind, were and are fools. We have a vast over-proportion of these great men, who, when you tell them that from the earliest period at which mankind devoted their attention to social happinesses, it has been their uniform judgment that a government over governments cannot exist. This is two governments operating on the same individual. Assume the smile of confidence, and tell you of two people traveling the same road, of a perfect and precise division of the duties of the individual. Still, however, the political apothegm is as old as the proverb, that no man can serve two masters, and whoever will run their noodles against old proverbs will be sure to break them, however hard they may be. And if they broke only their own, all would be right. But it is very horrible to reflect that all our numbskulls must be cracked in concert. Second, the trimmers, who from sympathetic indecision are always united with, and when not regularly employed, always fight under the banners of these great men. These people are forever at market, and when parties are nearly equally divided, they get very well paid for their services. Thirdly, the indolent, that is almost every second man of independent fortune you meet in America. These are quite easy, and can live under any government, if men can be said to live, who scarcely breathe, and if breathing was attended with any bodily exertion, would give up their small portion of life in despair. These men do not swim with the stream as the trimmers do, but are dragged like mud at the bottom. As they have no other weight than their tat flesh, they are hardly worth mentioning when we speak of the sentiments and opinions of America. As the second class never can include any of the yeomanry of the Union, who never affect superior wisdom, and can have no interest but the public good, it can only be said to exist as the birth of government. And as soon as the first and third classes become more decided in their views, this will divide with each and dissipate like a mist, or sink down into what are called moderate men, and become the tools and instruments of others. These people are prevented by a cloud from having any view, and if they are not virtuous, they at least preserve the appearance, which in this world amounts to the same thing. Third, at the head of the third class appear the old rigid republicans, who, although few in number, are still formidable. Reverence will follow these men in spite of detraction, as long as wisdom and virtue are esteemed among mankind. They are joined by the true democrats, who are in general fanatics and enthusiasts, and some few sensible, charming madmen. A decided majority of the yeomanry of America will, for length of years, be ready to support these two descriptions of men. But as this last class is forced to act as a residuary legate, and receive all the trash and filth, it is, in some measure, disgraced, and its influence weakened. Thirdly, the freebooters and plunderers, who infest all countries, and ours perhaps as little as any other whatever. These men have that natural antipathy to any kind or sort of government that a rogue has to a halter. In number they are few indeed. Such characters are the offspring of dissipation and want, and there is not that country in the world where so much real property is shared so equally among so few citizens. For where property is easily acquired by fair means, very few indeed will resort to foul. Lastly, by the poor mob, in Felix Pacus, the property of whoever will feed them and take care of them. Let them be spared. Let the burden of taxation sit lightly on their shoulders. But alas, this is not their fate. It is here that government forever falls with all its weight. It is here that the proposed government will press where it should scarcely be felt. In this third class may be counted men of the greatest mental powers and of as sublime virtue as any in America. They at present command nearly 1/3 of the property and above half the numbers of the United States, and in either event they must continue to increase in influence by great desertions from both the other classes. If the proposed government is not adopted, theirs will be the prevalent opinion. The object of this class either is or will be purely federal, a union of independent states, not a government of individuals. And should the proposed federal plan fail, from the obstinacy of those who will listen to no conditional amendments, although such as they cannot disapprove, or should it ultimately in its execution upon a fair trial disappoint the wishes and expectations of our country, then a union purely federal is what the reasonable and dispassionate patriots of America must bend their views to. My countrymen, preserve your jealousy, reject suspicion. It is the fiend that destroys public and private happiness. I know some weak, but very few, if any, wicked men in public confidence. And learn this most difficult and necessary lesson, that on the preservation of parties, public liberty depends. Whenever men are unanimous on great public questions, whenever there is but one party, freedom ceases and despotism commences. The object of a free and wise people should be so to balance parties, that from the weakness of all you may be governed by the moderation of the combined judgments of the whole, not tyrannized over by the blind passions of few individuals. A farmer. End of letter number 4, section number 52, Recorded by Robert Scott, June the 18th, 2007. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Recording by Robert Scott. The Anti-Federalist Papers, Section 53, Letter Number 5. A Farmer, Letter Number 5, the 25th of March, 1788. I have been long since firmly persuaded that there are no hidden sources of moral agency beyond the reach of investigation. The all-wise and all-bountiful author of nature could never have created human reason unequal to the happy regulation of human conduct. The errors and misfortunes of mankind spring from obvious sources. Religious and political prejudices, formed by education, strengthened by habit, maintained by interest, and consecrated by fear, are forever arming the passions against the judgment. The celebrated Blaise Pascal, the powers of whose understanding were rather miraculous than surprising, closed his painful researches after religious truth with this dogma, as pernicious as untrue, that a religion purely spiritual was never intended for mankind. There can be no judgment more unbiased, for there was no mind so strong, no heart more pure, but bred in the bosom of the Church. Even her idolatry impressed him with veneration and awe. Notwithstanding his conclusion, the doctrines of Calvin maintain their ground in their primitive simplicity, divested of the aid of ceremony and form. The thunders of the Vatican, which for ages deluged Europe with blood, have dissipated their force, and reason has resumed her spiritual empire. Would to God that the history of temporal despotism had terminated as favorably for the happiness of mankind. In the political world, the chains of civil power, upheld by the numerous links of private interest, have proved more equal and permanent in their effects. They have, and I fear forever must, shackle the human understanding, and it is much to be questioned whether the full and free political opinion of any one great luminary of science has been fairly disclosed to the world. Even when the great and amiable Montesquieu had hazarded a panegyric on the English Constitution, he shrinks back with terror into this degrading apostrophe. Quote, "Think not that I mean to undervalue other governments. I, who think an excess of liberty, an excess of all things, even of reason itself, a misfortune, and that the happiness of mankind is only to be found in a medium between two extremes." End quote. The author of the Persian Letters at that moment recollected the afflicting pressure he had felt from the hand of Gallic government, and his pen trembled as he wrote. Is it then possible that governments of simplicity and equal right can have been fairly dealt by in theory or practice? The votaries of tyranny and usurpation stand not alone in bitter opposition. Every man of enterprise, of superior talents and fortune, is interested to debase them. Their banners have ever been deserted because they never can pay their troops. The most amiable and sensible of mankind seem to have made a stand in favor of a mixed government founded on the permanent orders and objects of men. Thither, I suspect, the American government is now tending. If it must be so, Let it go gently then, with slow and equal steps. Let each gradation and experiment have a full and fair trial. Let there be no effect without a good, apparent, and well-considered cause. Let us live all the days of our lives, and as happily as circumstance will permit. Finally, let moderation be our guide, and the influence of manners will conduct us, I hope without injury, to some permanent, fixed establishment, where we may repose a while, unagitated by alteration or revolution. For in sudden and violent changes, how many of the most worthy of our fellow citizens must get their bones crushed? I cannot think that any able and virtuous citizen would, in his cool and dispassionate moments, wish to blend or risk the fundamental rights of men with any organization of society that the Americans can or will make for 50 years to come. Let us keep these rights of individuals, these unalienable blessings, reserved and separate from every constitution and form. If they are unmingled, the attentive eyes of every citizen wilt be kept fixed upon them. We shall watch them as a sacred deposit, and we may carry them uninjured and unimpaired through every vicissitude and change, from the government we have left into some other that may be established on the fixed and solid principles of reason. Nor can there be, I imagine, any prudent man who would trust the whimsical inventions of the day with that dangerous weapon, a standing army, in our present unsettled circumstances, striving to substantiate inefficient and unnatural forms. It would wield us into despotism in a moment, and we have surely had throat-cutting enough in our day. Throughout the world, government by representation seems only to have been established to disgrace itself and be abolished. Its very principle is change, and it sets all systems at defiance. It perishes by speedy corruption. The few representatives can always corrupt themselves by legislative speculations from the pockets of their numerous constituents. Quick rotation, like a succession of terms tenants on a farm, only increases the evil by rendering them more rapacious. If the executive is changeable, he can never oppose large decided majorities of influential individuals, or enforce on those powerful men who may render his next election the rigor of equal law, which is the grand and only object of human society. If the executive is to be rendered ineligible for a certain period, he will either not do his duty, or he will retire into the unprotected situation of a private individual, with all the sworn animosities of a powerful majority, aristocracy, junto, the cry of the populace, or perhaps the whole combined to pursue him to the grave, or a public execution. The considerate and good who adorn private life, and such only can be safely trusted in high public station, will never commit themselves to a situation where a conscientious discharge of duty may embitter the evening of life, if not draw down ruin and infamy on themselves and families. There was never but one man who stepped from the top to the bottom without breaking his neck, and that was Sylla. And although it is true that whilst he was up, he broke the hearts of the Romans, yet his dying, undisturbed in private life, is one of those miracles that must remain forever unexplained. If the aristocracy, or representation of wealth, the principle of which order is to keep all things as they are, for by confusion they may lose more than they gain, is also changeable, there then is nothing fixed and permanent in government. legislative tyranny commences, and exhibits a perpetual scene of plunder and confusion, fearlessly practiced under the sanction of authority and law. It is true that the influence of manners may and will resist for a time, yet that must give way to a general and prevalent corruption. Those who are respectable at home and have permanent in life, and such only can give stability to government, will not suffer themselves to be mounted upon the wheel of fortune, to be let down again as it turns, the mockery of children and fools. Where representation has been admitted as a component part of government, it has always proved defective, if not destructive. What, then, must be the consequence where the whole government is founded on representation? Every American can now answer. It will be at best but representation of government. With us, the influence of manners has been great. It is indeed declining fast, but, aided by the solidity of the judiciary establishments and the wisest code of civil laws that ever mankind was blessed with, it has hitherto supported the forms of society. But the people are now weary of their representatives and their governments. We may trace the progress. One candidate to recommend his pretensions discloses and descants on the errors of the preceding administration. The people believe him and are deceived. They change men, but measures are still the same, or injured by the sudden and violent alteration of the system. At least the next candidate asserts it is so, is again believed, and his constituents again deceived. A general disgust and sudden silence ensues. Elections are deserted. Government is first despised and then cordially hated. There can be no fixed and permanent government that does not rest on the fixed and permanent orders and objects of mankind. Government on paper may amuse, but we pay dear for the amusement. The only fixed and permanent order with us at present are the yeomanry, and they have no power whatever, unless the right of changing masters at a certain period, and devolving on their changeable representatives their whole political existence, may be called power. The order of gentry with us is not a fixed and permanent order at all, and if they attempt to erect themselves into one at present, it is usurpation, and they will be pulled down. And yet, in my opinion, such an order is essential to a perfect government founded on representation. Every other mode of introducing wealth into power has proved vicious and abominable. With us, delegates become, by selection, themselves a species of subaltern aristocracy. They intrigue with the senates, who by a refined mode of election are a misbegotten, side-blow representation of wealth, and they both form an imperfect aristocracy on the worst principles on which that order can be admitted into government. And the democratic influence, which is thus amalgamated and not divided, but unformed, becomes vicious from its impotence. These defects spring from our attempting to erect republican fabrics on the ruined and imperfect pillars of an old corrupt monarchy, not less absurd than to expect the limbs to perform the functions of life after cutting off the head. The opposition which brought Charles I to the block was composed of some of the ablest and most virtuous characters that ever adorned any age or clime: Hampden, Pym, Selden, Sir Harry Vane, Sidney, Marvell, and many others. They pursued their old model, attempted to form a government by representation, which was at first steadied and restrained by the best Senate in the world, the English House of Lords. The two houses soon disagreed, and there being no third power to interpose, the representatives voted the House of Lords useless, new modeled the government into a single branch, and then began to plunder most unmercifully. At last Cromwell kicked them all out of doors, and after his tyrannical usurpation and death, the nation were very happy to take shelter again under the regal government, and even restored an unworthy family which they had irritated beyond forgiveness to the throne. A farmer. To be continued. 28 March 1788. Continued from our last. After every consideration I can give this subject, I am satisfied that government founded on representation indispensably requires at least an executive for life, whose person must be sacred from impeachment, and only his ostensible ministers responsible. A Senate for life, the vacancies to be filled up, and the number occasionally increased, but under a limitation, by the executive. The hand that holds the balance must have the power of adding weight and influence to the lightest scale, and of frequently removing turbulent men into a higher and inoffensive situation. I am inclined to think that an important portion of American opinion leans that way at this moment. My fear is that our general government may ultimate in a hereditary authority, if not despotism. To avoid the former, great attention should be paid to the important office of vice president, at present but little understood. A vice president, to succeed on a vacancy, prevents those evils which have ruined Poland and all the northern kingdoms. Thus, we see the King of the Romans has secured Germany from every evil of elective monarchy, and had the Golden Bull prevented one of the family or kindred of the reigning emperor from filling the office of the King of the Romans, this part of the Germanic constitution would have been perfect, and the House of Austria would never have been enabled to usurp the imperial crown as a patrimony and desolate Europe with her ambitious views. She would have continued in that beggarly condition from which Randolph of Hapsburg raised it. The American Constitution is much better guarded, but not by any means completely so. If this is the best we can hope for, if this is the best reward we can expect for the sons of America slain, and the distresses we shall long continue to feel, is it not incumbent on us to examine minutely all its consequences? Let us view government by representation in its favorite form, the Constitution of England. Its uncommon success and length of duration there has drawn on it very unmerited encomiums from the enlightened Genevan de Lome, the only great political writer who does not seem to hold representation in contempt. Indeed, the viewing it through this favorable medium has always animated our hopes, and led many sensible Americans to imagine this old and universal experiment to be peculiar to that isle. In pursuing my inquiry into the principles and effects of the British government, I shall first grant that it is a rational system founded on solid, safe principles, and one of the best governments for the higher ranks of mankind in the world. But then I must insist that it was hardly a government at all until it became simplified by the introduction and regular formation of the effective administration of responsible ministers on its present system, which we cannot date higher up than the appointment of Lord Stafford and others by Charles I. Moreover, I do not know how far the system of bribery introduced by Sir Robert Walpole and the influence of the numerous body of public creditors are not now absolutely necessary to its present stability. And, after all, I am not satisfied how such a simplification as would produce a responsibility can be effected in a government complicated by so many subordinate and powerful corporations as the American states will be. And yet, responsibility must be attained, and an easy and certain mode adopted of changing measures and men without commotion, or liberty will be lost in the attempt. I am confused and bewildered when I arrive at this point of reflection, and despotism meets me at every turn. There are but two modes of governing mankind: by just and equal law, enforced impartially on all ranks of society, or by the sword. If such laws cannot be obtained, or the attainment is attended with too much difficulty, the sword will supply their place. Et inter arma leges silent. When arms command, the laws are disobeyed. Shall we have patience with the disorders of our complicated machine? As Alexander dissolved the Gordian knot with the sword, so I fear a standing army will simplify the governments of America. I have said that the government of England afforded firm protection of property. It certainly does so, comparatively speaking. Yet the history of its frequent revolutions will discover that even property is insecure there. During the civil wars in which the Stuarts involved this nation, 2/3 of the property of the kingdom changed masters, and in those between Lancaster and York, and before the firm establishment of the line of Tudor, almost all the old families perished, and their property became dissipated. And yet, its protection of property is its favorable side. Turn your eyes to the lower order of citizens, and they are pressed into the earth by taxation and imposition. Very rarely will industry enable the husbandman to rear a family. Where the sons of agriculture are so poorly rewarded, government must be ulcerated to the heart. The miserable poor, who pursue the dictates of nature and religion, in that connection which is destined to sweeten the bitter draught of life, are commonly handed from constable to constable, until their unfortunate birth compels some parish to own them. The people of England have always and forever will emigrate. The people of England never repair to arms to repel foreign invasion, and they never will unless compelled. To conquer England, it would only seem necessary from past example to escape their floating defenses and land on the island, passing by former invasions and conquests. As late as the year 1745, Prince Charles Edward, at the head of an undisciplined rabble belonging to some Highland clans attached to his family, marched undisturbed through the most populous counties in the heart of the kingdom, and the capital, containing 200,000 fighting men, trembled for its safety at the approach of an unexperienced boy, followed by 4,000 or 5,000 half-armed peasants. Scarcely a man in the kingdom shouldered a musket until the danger disappeared, and government owed its safety to the protection of foreign mercenaries, or rather the weakness and irresolution of the assailant. The fact is, the people will never fight if they can help it, for representatives, taxes, and rags. Let us now contrast this scene with one where the people personally exercise the powers of government. The three small democratic cantons of Uri, Schwitz, and Underwald broke the chains of their former servitude and laid the foundation of the Swiss Confederacy. They effected the revolution, and in conjunction with other democratic cantons and their democratic allies, the Orisons, have supported the grand fabric of Hellevic liberty to this day. Every Swiss farmer is by birth a legislator, and he becomes a voluntary soldier to defend his power and his property. Their fathers have been so before them for nearly 500 years, without revolution and almost without commotion. They have been the secure spectators of the constant and universal destruction of the human species, which the usurpations of the few have ever created, and must, I fear, forever perpetuate. Whilst all Europe were butchering each other for the love of God, and defending the usurpations of the clergy under the mask of religion, the malignant evil crept into this sacred asylum of liberty. But where the government resides in the body of the people, they can never be corrupted by the artifice or the wealth of the few. They soon banished the daemon of discord, and Protestant and Papist sat down under the peaceful shade of the same tree, whilst in every surrounding state and kingdom the son was dragging the father and the brothers, their brothers, to the scaffold under the sanction of these distinctions. Thus these happy Helvetians have in peace and security beheld all the rest of Europe become a common slaughterhouse. A free Swiss acquires from his infancy a knowledge of the fundamental laws of his country, and the leading principles of their national policy are handed down by tradition from father to son. The first of these is never to trust power to representatives or a national government. A free Swiss pays no taxes. On the contrary, he receives taxes. Every male of 16 years shares near 10 shillings sterling annually, which the rich and powerful surrounding monarchies pay for the friendship of those manly farmers. Whenever their societies become too large, as government belongs to the citizens, and the citizens are the property of no government, they divide amicably, and each separate part pursues the simple form recommended by their ancestors, and becomes venerable by the glorious and happy experience of ages of prosperity. Their frugal establishments are chiefly supported by the pay which the officers of government receive from the services they render individuals. With a country the most unfriendly to industry in the world, they have become, in a series of years, passed in uninterrupted but moderate labor, frugality, peace, and happiness, the richest nation under the sun. I have seen a computation by which it appeared that the interest of the money they have beforehand and that which is due them from the rich nations of Europe would support themselves and their posterity forever, without further exertion, and this whilst every other government is actually as much or more in debt than it is worth. An intelligent author has remarked that passing from a democratic to an aristocratic canton of Switzerland, you quit the society of men to contemplate the regular labor of brutes. They are compelled, indeed, in the aristocratic cantons, to be extremely moderate in their government, and to lay few or no taxes, or they would drive their subjects into the neighboring free states. As it is, they are well clothed, well fed, and taken good care of. The same author remarks that the line which separates all Switzerland from the countries around, where men, like cattle, are the property of their proud lords and kept chained to the soil, is the line of division between light and darkness, between happiness and horror. The love of Switzers for their country is altogether romantic and surpasses the bounds of credibility. Those memorable relations, authenticated by the common consent of all historians, of their beating on all occasions the flower of the Austrian and French troops who have invaded them with numbers so unequal and trifling as scarce to exceed their enemies' outguards. The instances of hundreds of citizens devoting their lives for the safety of their country, of their frequently disdaining life and refusing quarter when overpowered by numbers, have astonished and terrified the neighboring powers, and seem incomprehensible to a people dispirited by taxes, overloaded with debts, and disgusted with government. I cannot omit a striking characteristic, authenticated by Cox and others, whose authority will not be questioned. They relate that there is a rustic tune familiar in the mountains of Switzerland. It is called the Rance des Vaux. It consists of a few simple notes of native wild melody. The French and Dutch governments have been compelled to forbid, under very severe penalties, the playing of this woodland music to those Swiss troops, which they hire for a limited time. The well-known notes revive instantly all the fond images which are impressed on their youthful bosom, their friends, their parents, their relations, and their beloved country, rush into their imaginations in a full tide of affection. No persuasion can detain them. They desert home in regiments, or if retained by force, they pine away in the deepest melancholy. No instance has yet occurred of Swiss troops serving in any part of Europe who have not returned with the diligence and anxiety of affectionate children on the first appearance of danger to their parent country. The same amour patrie, the same divine love of their country, universally pervades the bosom of every citizen, who in his right of birth legislates for himself. Grossly relates that he saw in Rome a poor fellow, who had traveled through great part of Europe and Asia afoot, declaiming to a crowd with the most passionate zeal in praise of his own country, boasting of her happiness, and preferring San Marino to all the world besides. This democratic republic is a little beehive of free citizens, who have made a delicious garden of the top of a bleak barren mountain, situated in the midst of the finest and most fruitful plains of Italy, which tyranny has depopulated around them. Look into the human breast. We love that power which we exercise ourselves, but we detest that which others exercise over us, be they representatives, lords, or kings, and to this source we may trace the abuse which the Americans bestow on their country and their governments. But we are told that Switzerland should be no example for us. I am very sorry for it. They are the only part of the human species that sustains the dignity of character belonging to the divine resemblance we bear. They are few in number, it is said. This is not true. They are more numerous than we are. They cover a small spot of territory. This is also not true. They possess a large tract of country in the very heart of Europe, but this is not all. The Helvetic Confederacy, including the 3 leagues of the Orisons, comprehends 100, perhaps 200, independent governments and states. Nor is there any reason for their history or present state to doubt that the same plan of confederation might not be extended with as lasting and happy effects to 1,000 independent governments. But it is also said they are a poor, frugal people. As to their poverty, that is likewise untrue. They have great sums of money beforehand, and owe not a sixpence. They indeed are wise, and consequently a frugal people, though they still have great estates, and even luxury among them too. But Should we despair their poverty or their frugality? We who are so many millions worse than nothing? But still, we are told we must not take example from them. We must take example from Holland and Germany. They had better at once tell us that we must desert the worship of God and follow that of the devil. From the first dawn of light that broke in upon my reason, I became devoted to governments of simplicity and equal right. The names of heroes whose blood has bedewed the altars of freedom vibrate like the shock of electricity on my frame, and when I read the story of Brutus and of Cassius, the most noble and last of the Romans, tears of admiration gush from my eyes. Under these impressions, which only the grave can erase, I feel unspeakable horror at every step which removes power and rights at a greater distance from the body of the people to whom they belong, and confines them in the hands of the few. I have proposed to myself this question: if representatives cannot govern the people, if they abuse the power entrusted to them, shall they devolve this power on a still smaller number, who must be more liable to corruption from the increase of temptation? Or should they restore it into the hands of the people from whom they received it, who alone are incorruptible, because the wealth of the few can never bribe the many against the duty they owe to themselves? If I am told that the people are incapable of governing themselves, I shall answer that they have never been tried in America except among the native Indians, who are free and happy, and who prove that self-government is the growth of our soil. And I also answer that they are more fit for self-government than they are at present for any of the safe and solid governments founded on representation. When I see all these principles established by the example of the Swiss, who have remained under the simplest of all forms of government for near 500 years, in uninterrupted tranquillity and happiness, whilst every other invention of genius, devise of art, or imposition offeree has been torn up by the roots with every aggravated circumstance of horror, I can no longer doubt. All the mists of theory and speculation vanish before an experiment like this. The greatest human discernment ever concentrated in the mind of one man was the portion of the celebrated Nicholas Machiavelli, a name loaded with abuse by tyrants, flatterers, and the mushrooms of science, because he told the truth, because he was a republican and the friend of mankind in times of usurpation, or because they have never read or do not understand his works. After every inquiry which the most unbounded information and reflection, with a long experience in high public office afforded, Machiavelli delivers his deliberate opinion in favor of the body of the people, as the only safe depository of liberty and power. He prefers it to the aristocracy and the prince, but he does not disgrace the inquiry by mentioning representation. If this was the opinion of Machiavelli, a citizen of Florence, where a numerous populace, confined and crowded within the walls of a city, formed the most turbulent republic that ever disgraced the cause of freedom by cruelty and anarchy, how much more favorably must his decision apply to the yeomanry of America, landholders, and consequently the most independent of mankind, mild by nature, moderate by manners, and persevering in every honest pursuit. Surely, if ever men were worthy of being entrusted with their own rights, the freeholders of America are. Make them, then, and their posterity, legislators by birth. I mean not the lowest populace, I mean that class of citizens to whom this country belongs. Numbers unqualified by property should have their influence. They should be protected. They might preserve the right of election, but they who hold the property of the soil are alone entitled to govern it. To effect this, there would need be little change in the present forms. They might all stand, but the laws which pass the legislature before they become binding should be referred to the different counties and cities. Printed reasons drawn by committees might, if necessary, accompany each, together with an annual estimate of public wants and a detail of the expenditures of former sums granted. Let these laws be submitted to the free deliberation of the freeholders of the counties and cities. The numbers of the yeas and nays be taken on each by the presiding magistrate and transmitted to the executive, who may then, upon comparing the returns from the several counties and corporations, declare what laws are the will of the people. On the appearance of any sudden danger, the two houses, or indeed a majority of one house, might invest the executive with the authority exigency might require for the safety of the republic until remedy should be provided by law. The number of representatives might be decreased and an expense saved. This would at one blow destroy all legislative speculations. The influence of demagogues or oligarchic juntos must then cease. The assemblage of the freeholders, separate in different counties, would prevent disturbance. As no new law could be made in them, little confusion would ensue. After some years, or even immediately, if confined to future cases, the celebrated law of Geneva might be introduced, and no freeholder admitted to the assembly until he had paid his father's debts. Sumptuary laws permitting the use but prohibiting the abuse of wealth might be interposed to guard the public manners. The governor and 2 members of the Senate might constitute a council of censors to punish offenders against the sumptuary laws and the laws of morality by a removal from office, and even disenfranchisement if necessary, with an appeal to the people of the county where the offender resides in the later case, and to the people of the state in the former. Seminaries of useful learning, with professorships of political and domestic. Economy might be established in every county. Discarding the philosophy of the moon and skies, we might descend to teach our citizens what is useful in this world. The principles of free government, illustrated by the history of mankind, the sciences of morality, agriculture, commerce, the management of farms and household affairs. The light would then penetrate where mental darkness now reigns. Do these things, and in a very few years the people, instead of abusing, would wade up to their knees in blood to defend their governments. For some years past, this has been the darling object of my life, to which all my views have tended, and I now think that nothing intermediate would be lasting or worthy the pursuit. Whenever I fairly lose sight of this, as soon as I turn my back forever on these dear illusions, which will be as soon as the proposed federal government is adopted, I shall turn all my wishes to that social state whither that government will lead us, and I both hope and expect that with those amendments and guards which it seems to be the general disposition to provide, it will gradually mature in a safe and reasonable government. Until that adoption, I speak to my fellow citizens in the words of the proverb, "Do not that by others which you can do yourselves." A farmer. End of Letter 5, Section 53. Recorded by Robert Scott, June the 19th, 2007.
This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Anti-Federalist Papers, Section 54. Patrick Henry, speaking at the Virginia Ratifying Convention, Thursday, June 5, 1788. Mr. Chairman, I am much obliged to the very worthy gentleman for his encomium. I wish I was possessed with talents, or possessed of anything that might enable me to elucidate this great subject. I am not free from suspicion. I am apt to entertain doubts. I rose yesterday to ask a question which arose in my own mind. When I asked that question, I thought the meaning of my interrogation was obvious. The fate of this question and of America may depend on this. Have they said, "We the states"? Have they made a proposal of a compact between states? If they had, this would be a confederation. It is otherwise most clearly a consolidated government. The question turns, sir, on that poor little thing, the expression, "We the people," instead of the states of America. I need not take much pains to show that the principles of this system are extremely pernicious, impolitic, and dangerous. Is this a monarchy like England? A compact between prince and people, with checks on the former to secure the liberty of the latter? Is this a confederacy like Holland? An association of a number of independent states, each of which retains its individual sovereignty? It is not a democracy, wherein the people retain all their rights securely. Had these principles been adhered to, we should not have been brought to this alarming transition from a confederacy to a consolidated government. We have no detail of these great considerations, which, in my opinion, ought to have abounded before we should recur to a government of this kind. Here is a resolution as radical as that which separated us from Great Britain. It is radical in this transition. Our rights and privileges are endangered, and the sovereignty of the states will be relinquished. And cannot we plainly see that this is actually the case? The rights of conscience, trial by jury, liberty of the press, all your immunities and franchises, all pretensions to human rights and privileges, are rendered insecure, if not lost, by this change so loudly talked of by some, and inconsiderately by others. Is this tame relinquishment of rights worthy of free men? Is it worthy of that manly fortitude that ought to characterize republicans? It is said 8 states have adopted this plan. I declare that if 12 states and a half had adopted it, I would, with manly firmness and in spite of an erring world, reject it. You are not to inquire how your trade may be increased, nor how you are to become a great and powerful people, but how your liberties can be secured, for liberty ought to be the direct end of your government. Having premised these things, I shall, with the aid of my judgment and information, which, I confess, are not extensive, go into the discussion of this system more minutely. Is it necessary for your liberty that you should abandon those great rights by the adoption of this system? Is the relinquishment of the trial by jury and the liberty of the press necessary for your liberty? Will the abandonment of your most sacred rights tend to the security of your liberty? Liberty, the greatest of all earthly blessings, give us that precious jewel, and you may take everything else. But I am fearful. I have lived long enough to become an old-fashioned fellow. Perhaps an invincible attachment to the dearest rights of man may, in these refined, enlightened days, be deemed old-fashioned. If so, I am content to be so. I say, the time has been when every pulse of my heart beat for American liberty, and which, I believe, had a counterpoint in the breast of every true American. But suspicions have gone forth, suspicions of my integrity, publicly reported that my professions are not real. 23 years ago was I supposed a traitor to my country? I was then said to be the bane of sedition because I supported the rights of my country. I may be thought suspicious when I say our privileges and rights are in danger. But, sir, a number of the people of this country are weak enough to think these things are too true. I am happy to find that the gentleman on the other side declares they are groundless. But, sir, suspicion is a virtue as long as its object is the preservation of the public good, and as long as it stays within proper bounds. Should it fall on me, I am contented. Conscious rectitude is a powerful consolation. I trust there are many who think my professions for the public good to be real. Let your suspicion look to both sides. There are many on the other side who possibly may have been persuaded to the necessity of these measures, which I conceive to be dangerous to your liberty. Guard with jealous attention the public liberty. Suspect every one who approaches that jewel. Unfortunately, nothing will preserve it but downright force. Whenever you give up that force, you are inevitably ruined. I am answered by gentlemen that, though I may speak of terrors, yet the fact was that we were surrounded by none of the dangers I apprehended. I conceive this new government to be one of those dangers. It has produced those horrors which distress many of our best citizens. We are come hither to preserve the poor Commonwealth of Virginia. If it can be possibly done, something must be done to preserve your liberty and mine. The Confederation, this same despised government, merits, in my opinion, the highest encomium. It carries us through a long and dangerous war. It rendered us victorious in that bloody conflict with a powerful nation. It has secured us a territory greater than any European monarch possesses, and shall a government which has been thus strong and vigorous be accused of imbecility and abandoned for want of energy? Consider what you are about to do before you part with the government. Take longer time in reckoning things. Revolutions like this have happened in almost every country in Europe. Similar examples are to be found in ancient Greece and ancient Rome, instances of the people losing their liberty by their own carelessness and the ambition of a few. We are cautioned by the honorable gentleman who presides against faction and turbulence. I acknowledge that licentiousness is dangerous, and that it ought to be provided against. I acknowledge also the new form of government may effectively prevent it. Yet there is another thing it will as effectually do. It will oppress and ruin the people. There are sufficient guards placed against sedition and licentiousness, for when power is given to this government to suppress these, or for any other purpose, the language it assumes is clear, express, and unequivocal. But when this Constitution speaks of privileges, there is an ambiguity, sir, a fatal ambiguity, an ambiguity which is very astonishing. In the clause under consideration, there is the strangest language that I can conceive. I mean, when it says that there shall not be more representatives than one for every 30,000. Now, sir, how easy is it to evade this privilege? Quote, the number shall not exceed one for every 30,000. End quote. This may be satisfied by one representative from each state. Let our numbers be ever so great, this immense continent may, by this artful expression, be reduced to have but 13 representatives. I confess this construction is not natural, but the ambiguity of the expression lays a good ground for quarrel. Why was it not clearly and unequivocally expressed that they should be entitled to have one for every 30,000? This would have obviated all disputes. And was this difficult to be done? What is the inference? When population increases, and a state shall send representatives in this proportion, Congress may remand them, because the right of having one for every 30,000 is not clearly expressed. This possibility of reducing the number to one for each state approximate the probability by that other expression, quote, but each state shall have at least one representative, end quote. Now, is it not clear that, from the first expression, the number might be reduced so much as that some states should have no representatives at all, were it not for the insertion of this last expression? And as this is the only restriction upon them, we may fairly conclude that they may restrain the number to one from each state. Perhaps the same horrors may hang over my mind again. I shall be told I am continually afraid, but, sir, I have strong cause of apprehension. In some parts of the plan before you, the great rights of free men are endangered. In other parts, absolutely taken away. How does your trial by jury stand? In civil cases, gone. Not sufficiently secured in criminal, the best privilege is gone. But we are told that we need not fear, because those in power, being our representatives, will not abuse the powers we put in their hands. I am not well versed in history, but I will submit to your recollection whether liberty has been destroyed most often by the licentiousness of the people or by the tyranny of rulers. I imagine, sir, you will find the balance on the side of tyranny. Happy will you be if you miss the fate of those nations who, omitting to resist their oppressors or negligently suffering their liberty to be wrested from them, have groaned under intolerable despotism. Most of the human race are now in this deplorable condition, and those nations who have gone in search of grandeur, power, and splendor have also fallen a sacrifice and have been the victims of their own folly. While they acquired those visionary blessings, they lost their freedom. My great objection to this government is that it does not leave us the means of defending our rights or of waging war against tyrants. It is urged by some gentlemen that this new plan will bring us an acquisition of strength, an army, and the militia of the states. This is an idea extremely ridiculous. Gentlemen cannot be earnest. This acquisition will trample on our fallen liberty. Let my beloved Americans guard against that fatal lethargy that has pervaded the universe. Have we the means of resisting disciplined armies when our only defense, the militia, is put in the hands of Congress? The honorable gentleman said that the great danger would ensue if the convention rose without adopting this system. I ask, where is that danger? I see none. Other gentlemen have told us within these walls that the Union is gone, or that the Union will be gone. Is this not trifling with the judgment of their fellow citizens? Till they tell us the grounds of their fears, I will consider them as imaginary. I rose to make inquiry where those dangers were. They could make no answer. I believe I never shall have that answer. Is there a disposition in the people of this country to revolt against the dominion of laws? Has there been a single tumult in Virginia? Have not the people of Virginia, when laboring under the severest pressure of accumulated distress, manifested the most cordial acquiescence in the execution of the laws? What could be more awful than their unanimous acquiescence under general distress? Is there any revolution in Virginia? Whither is the spirit of America gone? Whither is the genius of America fled? It was but yesterday, when our enemies marched in triumph through our country. Yet the people of this country could not be appalled by their pompous armaments. They stopped their career and victoriously captured them. Where is the peril now compared to that? Some minds are agitated by foreign alarms. Happily for us, there is no real danger from Europe. That country is engaged in a more arduous business. From that quarter there is no cause of fear. You may sleep in safety forever for them. Where is the danger? If, sir, there was any, I would recur to the American spirit to defend us. That spirit which has enabled us to surmount the greatest difficulties. To that illustrious spirit I address my most fervent prayer to prevent our adopting a system destructive to liberty. Let not gentlemen be told that it is not safe to reject this government. Wherefore is it not safe? We are told there are dangers, but those dangers are ideal. They cannot be demonstrated. To encourage us to adopt it, they tell us that there is a plain, easy way of getting amendments. When I come to contemplate this part, I suppose that I am mad, or that my countrymen are so. The way to amendment is, in my conception, shut. Let us consider this plain, easy way. Quote, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislature of 2/3 of the several States, shall call a convention for proposing amendments, which, in either case, shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several States, or by the conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year 1808 shall in any manner affect the first and fourth clauses of the 9th section of the first article, and no State without its consent shall be deprived of its equal suffrage in the Senate. Hence, it appears that 3/4 of the States must ultimately agree to any amendments that may be necessary. Let us consider the consequence of this. However uncharitable it may appear, yet I must tell my opinion, that the most unworthy characters may get into power and prevent the introduction of amendments. Let us suppose for the case is supposable, possible, and probable that you happen to deal those powers to unworthy hands, will they relinquish powers already in their possession or agree to amendments? 2/3 of the Congress or of the state legislatures are necessary even to propose amendments. If 1/3 of these be unworthy men, they may prevent the application for amendments. But what is destructive and mischievous is that 3/4 of the state legislatures or of the state conventions must concur in the amendments when proposed. In such numerous bodies there must necessarily be some designing bad men. To suppose that so large a number as 3/4 of the states will concur is to suppose that they will possess genius, intelligence, and integrity approaching to miraculous. It would indeed be miraculous that they should concur in the same amendments, or even in such as would bear some likeness to one another. For 4 of the smallest states that do not collectively contain 1/10 part of the population of the United States may obstruct the most salutary and necessary amendments. Nay, in these 4 states 6/10 of the people may reject these amendments, and suppose that amendments shall be opposed to the amendments, which is highly probable. Is it possible that 3/4 can ever agree to the same amendments? A bare majority in these 4 small states may hinder the adoption of amendments, so that we may be fairly and justly conclude that 1/20th part of the American people may prevent the removal of the most grievous inconveniences and oppression, by refusing to accede to the amendments. A trifling minority may reject the most salutary amendments. Is this an easy mode of securing the public liberty? It is, sir, a most fearful situation, when the most contemptible minority can prevent the alteration of the most oppressive government, for it may, in many respects, prove to be such. Is this the spirit of republicanism? What, sir, is the genius of democracy? Let me read that clause of the Bill of Rights of Virginia which relates to this. 3rd clause. That government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community. Of all the various modes and forms of government, that is best, which is capable of producing the greatest degree of happiness and safety, and is most effectually secured against the danger of maladministration. And that whenever any government shall be found inadequate, or contrary to those purposes, a majority of the community hath an indubitable, unalienable, and indefeasible right to reform, alter, or abolish it in such manner as shall be judged most conducive to the public weal. This, sir, is the language of democracy, that a majority of the community have a right to alter government when found to be oppressive. But how different is the genius of your new Constitution from this? How different from the sentiments of free men, that a contemptible minority can prevent the good of the majority? If then, gentlemen, standing on this ground, are come to that point that they are willing to bind themselves and their posterity to be oppressed, I am amazed, inexpressibly astonished. If this be the opinion of the majority, I must submit, but to me, sir, it appears perilous and destructive. I cannot help thinking so. Perhaps it may be the result of my age. These may be feelings natural to a man of my years, when the American spirit has left him, and his mental powers, like the members of the body, are decayed. If, sir, amendments are left to the 20th or 10th part of the people of America, your liberty is gone forever. We have heard that there is a great deal of bribery practiced in the House of Commons in England, and that many of the members raise themselves to preferments by selling the rights of the whole of the people. But, sir, the 10th part of that body cannot continue oppression on the rest of the people. English liberty is, in this case, on a firmer foundation than American liberty. It will be easily contrived to procure the opposition of 1/10 of the people to any alteration, however judicious. The honorable gentleman who presides tells us that, to prevent abuses in our government, we will assemble in convention, recall our delegated powers, and punish our servants for abusing the trust reposed in them. Oh, sir, we should have fine times indeed, if to punish tyrants it were only sufficient to assemble the people. Your arms, wherewith you could defend yourselves, are gone, and you have no longer an aristocratical, no longer a democratical spirit. Did you ever read any of the revolution in the nation brought about by the punishment of those in powers inflicted by those who had no power at all? You read of a riot act in a country which is called one of the freest in the world, where a few neighbors cannot assemble without the risk of being shot by a hired soldiery of the engines of despotism. We may see such an act in America. A standing army we shall have also, to execute the execrable commands of tyranny. And how are you to punish them? Will you order them to be punished? Who shall obey these orders? Will your mace bearer be a match for a disciplined regiment? In what situation are we to be? The clause before you gives a power of direct taxation, unbounded and unlimited exclusive power of legislation, in all cases whatsoever for 10 miles square and over all places purchased for the erection of forts, magazines, arsenals, dockyards, etc. What resistance could be made? The attempt would be madness. You will find all the strength of this country in the hands of your enemies. Their garrisons will naturally be the strongest places in the country. Your militia is given up to Congress also in another part of this plan. They will therefore act as they think proper. All power will be in their own possession. You cannot force them to receive their punishment. Of what service would militia be to you when most probably you will not have a single musket in the state, for arms are to be provided by Congress. They may or may not furnish them. Let me here call your attention to that part which gives the Congress the power, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the States respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. By this, sir, you see that their control over our last and best defense is unlimited. If they neglect or refuse to discipline or arm our militia, they will be useless. The States can do neither, this power being exclusively given to Congress. The power of appointing officers over men not disciplined or armed is ridiculous, so that this pretended little remains of power left to the States may, at the pleasure of Congress, be rendered nugatory. Our situation will be deplorable indeed, nor can we ever expect to get this government amended, since I have already shown that a very small minority may prevent it, and that small minority interested in the continuance of the oppression. Will the oppressor let go the oppressed? Was there ever an instance? Can the annals of mankind exhibit one single example where rulers overcharged with power willingly let go the oppressed, though solicited and requested most earnestly? The application for amendments will therefore be fruitless. Sometimes the oppressed are got loose by one of those bloody struggles that desolate a country. But a willing relinquishment of power is one of those things which human nature never was nor ever will be capable of. The honorable gentleman's observations respecting the people's right of being the agents of the formation of government are not accurate in my humble conception. The distinction between a national government and a confederacy is not sufficiently discerned. Had the delegates who were sent to Philadelphia a power to propose a consolidated government instead of a confederacy? Were they not deputed by states and not by the people? The assent of the people in their collective capacity is not necessary to the formation of a federal government. The people have no right to enter into leagues, alliances, or confederations. They are not the proper agent for this purpose. States and foreign powers are the only proper agents for this kind of government. Show me an instance where the people have exercised this business. Has it not always gone through the legislatures? I refer to you the treaties of France, Holland, and other nations. How were they made? Were they not made by the states? Are the people therefore in their aggregate capacity the proper persons to form a confederacy? This therefore ought to depend on the consent of the legislatures, the people having never sent delegates to make any proposition for changing the government. Yet I must say at the same time that it was made on grounds the most pure, and perhaps I might have been brought to consent to it so far as to the change of government. But there is one thing in it which I never would acquiesce in. I mean, the changing it to a consolidated government, which is so abhorrent to my mind. The honorable gentleman then went on to the figure we make with foreign nations, the contemptible one we make in France and Holland, which, according to the substance of the notes, he attributes to the present feeble government. An opinion has gone forth, we find, that we are contemptible people. The time has been when we were thought otherwise. Under the same despised government, we commanded the respect of all Europe. Wherefore are we now reckoned otherwise? The American spirit has fled from hence. It has gone to regions where it has never been expected. It has gone to the people of France in search of a splendid government, a strong, energetic government. Shall we imitate the example of those nations who have gone from simple to a splendid government? Are those nations more worthy of our imitation? What can make an adequate satisfaction to them for the loss they have suffered in obtaining such a government, for the loss of liberty? If we admit this consolidated government, it will be because we like a great, splendid one. Some way or another we must be a great and mighty empire. We must have an army and a navy and a number of things. When the American spirit was in its youth, the language of America was different. Liberty, sir, was then the primary object. We are descended from a people whose government was founded on liberty. Our glorious forefathers of Great Britain made liberty the foundation of everything. That country has become a great, mighty, a splendid nation, not because their government is strong and energetic, but, sir, because liberty is its direct end and foundation. We drew the spirit of liberty from our British ancestors. By that spirit we have triumphed over every difficulty. But now, sir, the American spirit, assisted by the ropes and chains of consolidation, is about to convert this country into a powerful and mighty empire. If you make the citizens of this country agree to become the subjects of one great consolidated empire of America, your government will not have sufficient energy to keep them together. Such a government is incompatible with the genius of republicanism. There will be no checks, no real balances in the government. What can avail your specious imaginary balances, your rope-dancing, chain-rattling, ridiculous ideal checks and contrivances? But, sir, we are not feared by foreigners. We do not make nations tremble. Would this constitute happiness or secure liberty? I trust, sir, our political hemisphere will ever direct their operations to the security of those objects. Consider our situation, sir. Go to the poor man, and ask him what he does. He will inform you that he enjoys the fruits of his labor, under his own fig tree, with his wife and children around him, in peace and security. Go to every other member of society. You will find the same tranquil ease and content. You will find no alarms or disturbances. Why, then, tell us of danger, to terrify us into adoption of this new form of government? And yet who knows the dangers that this new system may produce? They are out of sight of the common people. They cannot foresee latent consequences. I dread the operation of it on the middling and lower classes of people. It is for them I fear the adoption of this system. I fear I tire the patience of the committee, but I beg to be indulged with a few more observation. When I thus profess myself an advocate for the liberty of the people, I shall be told I am a designing man, that I am to be a great man, that I am to be a demagogue, and many similar illiberal insinuations will be thrown out. But, sir, conscious rectitude outweighs those things with me. I see great jeopardy in this new government. I see none from our present one. I hope some gentleman or other will bring forth in full array those dangers, if there be any, that we may see and touch them. I have said that I thought this a consolidated government. I will now prove it. Will the great rights of the people be secured by this government? Suppose it should prove oppressive, how can it be altered? Our Bill of Rights declares, quote, that a majority of the community hath an indubitable, unalienable, and indefeasible right to reform, alter, or abolish it, in such manner as shall be judged most conducive to the public weal. End quote. I have just proved that 1/10 or less of the people of America, a most despicable minority, may prevent this reform or alteration. Suppose the people of Virginia should wish to alter their government. Can a majority of them do it? No, because they are connected with other men, or, in other words, consolidated with other states. When the people of Virginia, at a future day, shall wish to alter their government, though they should be unanimous in this desire, yet they may be prevented therefrom by a despicable minority at the extremity of the United States. The founders of your own Constitution made your government changeable, but the powers of changing it is gone from you. Whither is it gone? It is placed in the same hands that hold the rights of 12 other states, and those who hold the rights have right and power to keep them. It is not the particular government of Virginia. One of the leading features of that government is that a majority can alter it when necessary for the public good. This government is not a Virginian, but an American government. It is not therefore a consolidated government. The 6th clause of your Bill of Rights tells you, quote, that elections of members to serve as representatives of the people in assembly ought to be free, and that all men having sufficient evidence of permanent common interest with and attachment to the community have the right of suffrage and cannot be taxed or deprived of their property for public uses without their own consent or that of their representatives so elected, nor bound by any law to which they have not in like manner assented for public good. End quote. But what does this Constitution say? The clause under consideration gives an unlimited and unbounded power of taxation. Suppose every delegate from Virginia opposes a law laying a tax. What will it avail? They are opposed by a majority. 11 members can destroy their efforts. Those feeble 10 cannot prevent the passing the most oppressive tax law, so that, in direct opposition to the spirit and express language of your Declaration of Rights, you are taxed, not by your own consent, but by people who have no connection with you. The next clause of the Bill of Rights tells you, quote, that all power of suspending law or the execution of laws by any authority without the consent of the representatives of the people is injurious to their rights and ought not to be exercised, end quote. This tells us that there can be no suspension of government or laws without our own consent. Yet this Constitution can counteract and suspend any of our laws that contravene its oppressive operation, for they have the power of direct taxation, which suspends our Bill of Rights. And it is expressly provided that they can make all laws necessary for carrying their powers into execution, and it is declared paramount to the laws and constitutions of the states. Consider how the only remaining defense we have left is destroyed in this manner. Besides the expenses of maintaining the Senate and other House in as much splendor as they please, there is to be a great and mighty President with very extensive powers, the powers of a king. He is to be supported in extravagant magnificence, so that the whole of our property tax may be taken by this American government by laying what taxes they please, giving themselves what salaries they please, and suspending our laws at their pleasure. I might be thought too inquisitive, but I believe I should take up very little of your time in enumerating the little power that is left to the government of Virginia, for this power is reduced to little or nothing. Their garrisons, magazines, arsenals, and forts, which will be situated in the strongest places within the States, their 10 miles square, with all the fine ornaments of human life, added to their powers and taken from the States, will reduce the power of the latter to nothing. The voice of tradition, I trust, will inform posterity of our struggles for freedom. If our descendants be worthy of the name of Americans, they will preserve and hand down to their latest posterity the transactions of the present times, and, though I confess my exclamations are not worthy the hearing, they will see that I have done my utmost to preserve their liberty. For I never will give up the power of direct taxation but for a scourge. I am willing to give it conditionally, that is, after non-compliance with requisitions. I will do more, sir, and what I hope will convince the most skeptical man that I am a lover of the American Union, that, in case Virginia shall not make punctual payment, the control of our custom houses and the whole regulation of trade shall be given to Congress, and that Virginia shall depend on Congress even for passports, till Virginia shall have paid the last farthing and furnished the last soldier. Nay, sir, there is another alternative to which I would consent, even that they should strike us out of the Union, and take away from us all federal privileges till we comply with federal requisitions. But let it depend upon our own pleasure to pay our money in the most easy manner for our people. Were all the states, more terrible than the mother country, to join against us, I hope Virginia could defend herself. But, sir, the dissolution of the Union is most abhorrent to my mind. The first thing I have at heart is American liberty. The second thing is American union, and I hope the people of Virginia will endeavor to preserve that union. The increasing population of the Southern States is far greater than that of New England. Consequently, in a short time they will be far more numerous than the people of that country. Consider this, and you will find this state more particularly interested to support the American liberty, and not bind our posterity by an improvident relinquishment of our rights. I would give the best security for a punctual compliance with requisitions, but I beseech gentlemen, at all hazards, not to give up this unlimited power of taxation. The honorable gentleman has told us that these powers given to Congress are accompanied by a judiciary which will correct all. On examination, you will find the very judiciary oppressively constructed, your jury trial destroyed, and the judges dependent on Congress. In this scheme of energetic government, the people will find two sets of tax gatherers, the state and the federal sheriffs. This, it seems to me, will produce such dreadful oppression that the people cannot possibly bear. The federal sheriff may commit what oppression, make what distresses he pleases, and ruin you with impunity. For how are you to tie his hands? Have you any sufficiently decided means of preventing him from sucking your blood by speculations, commissions, and fees? Thus thousands of your people will be most shamefully robbed. Our state sheriffs, those unfeeling bloodsuckers, have, under the watchful eye of our legislature, committed the most horrid and barbarous ravages on our people. It has required the most constant vigilance of the legislature to keep them from totally ruining the people. A repeated succession of laws has been made to suppress their iniquitous speculations and cruel exhortations, and as often their nefarious ingenuity devised methods of evading the force of those laws. In the struggle, they have generally triumphed over the legislature. It is a fact that lands have been sold for 5 shillings, which were worth £100. If sheriffs, thus immediately under the eye of our state legislature and judiciary, have dared to commit these outrages, what would they have not done if their masters had been in Philadelphia or New York? If they perpetrate the most unwarrantable outrage on your person or property, you cannot get redress on this side of Philadelphia or New York. How can you get it there? If your domestic avocations could permit you to go thither, there you must appeal to judges sworn to support this Constitution in opposition to that of any state, and who may also be inclined to favor their own officers. When these harpies are aided by excisemen, who may search at any time your houses and most secret recesses, will the people bear it? If you think so, you differ from me. Where I thought there was a possibility of such mischiefs, I would grant power with a niggardly hand, and here there is a strong probability that these oppressions shall actually happen. I may be told that it is safe to err on that side, because such regulations may be made by Congress as shall restrain these officers, and because laws are made by our representatives and judged by righteous judges. But, sir, as these regulations may be made, so they may not, and many reasons there are to induce a belief that they will not. I shall, therefore, be an infidel on that point till the day of my death. This Constitution is said to have beautiful features, but when I come to examine these features, sir, they appear to me horribly frightful. Among other deformities, it has an awful squinting. It squints towards monarchy, and does not this raise indignation in the breast of every true American? Your president may easily become king. Your Senate is so imperfectly constructed that your dearest rights may be sacrificed by what may be a small minority, and a very small minority may continue forever unchangeably this government, although horridly defective. Where are your checks in this government? Your strongholds will be in the hands of your enemies. It is on supposition that your American governance shall be honest, that all the good qualities of this government are founded. But its defective and imperfect construction puts it in their power to perpetrate the worst of mischiefs, should they be bad men. And, sir, would not all the world, from the eastern to the western hemisphere, blame our distracted folly in resting our rights upon the contingency of our rulers being good or bad? Show me that age and country where the rights and liberties of the people were placed on the sole chance that the rulers being good men without a consequent loss of liberty. I say that the loss of the dearest privilege has ever followed, with absolute certainty, every such mad attempt. If your American chief be a man of ambition and abilities, how easy is it for him to render himself absolute? The army is in his hands, and if he be a man of address, it will be attached to him, and it will be the subject of long meditation with him to seize the first auspicious moment to accomplish his design. And, sir, will the American spirit solely relieve you when this happens? I would rather infinitely, and I am sure most of this convention are of the same opinion, have a lord, kings, and commons, than a government so replete with such insupportable evils. If we make a king, we may prescribe the rules by which he shall rule his people, and interpose such checks as shall prevent him from infringing them. But the President, in the field, at the head of the army, can prescribe the terms on which he shall reign master, so far that it will puzzle any American ever to get his neck from under the galling yoke. I cannot with patience think of this idea. If he ever violates the laws, one of 2 things will happen. He will come at the head of his army to carry everything before him, or he will give bail or do what Mr. Chief Justice will order him. If he be guilty, will not the recollection of his crimes teach him to make one bold push for the American throne? Will not the immense difference between being master of everything and being ignominiously tried and punished powerfully excite him to make this bold push? But, sir, where is the existing force to punish him? Can he not, at the head of the army, beat down every opposition? Away with your president! We shall have a king. The army will salute him monarch, your militia will leave you and assist in making him king, and fight against you. And what have you to oppose this force? What will then become of you and your rights? Will not absolute despotism ensue? What can be more defective than the clause concerning the elections? The control given to Congress over the time, place, and manner of holding elections will totally destroy the end of suffrage. The elections may be held at one place, and the most inconvenient in the state, or they may be at remote distances for those who have a right of suffrage. Hence, 9 out of 10 must either not vote at all, or vote for strangers. For the most influential characters will be applied to know who are the most proper to be chosen. I repeat, that the control of Congress over the manner, etc., of electing well warrants this idea. The natural consequence will be that this democratic branch will possess none of the public confidence. The people will be prejudiced against representatives chosen in such an injudicious manner. The proceedings in the Northern Conclave will be hidden from the yeomanry of this country. We are told that the yeas and nays shall be taken and entered on the journals. This, sir, will avail nothing. It may be locked up in their chests and concealed forever from the people, for they are not to publish what parts they think require secrecy. They may think, and will think, the whole requires it. Another beautiful feature of this Constitution is the publication from time to time of the receipts and expenditures of the public money. This expression, from time to time, is very indefinite and indeterminate. It may extend to a century. Grant that any of them are wicked, they may squander the public money so as to ruin you, and yet this expression will give you no redress. I say they may ruin you, for where, sir, is the responsibility? The yeas and nays will show you nothing, unless they be fools as well as knaves, for after having wickedly trampled on the rights of the people, they would act like fools indeed were they the public and divulge their iniquity, when they have it equally in their power to suppress and conceal it. Where is their responsibility, that leading principle in the British government? In that government, a punishment certain and inevitable is provided, but in this, there is no real, actual punishment for the grossest maladministration. They may go without punishment, though they commit the most outrageous violation on our immunities. That paper may tell me they will be punished, I asked. By what law? They must make the law, for there is no existing law to do it. What? Will they make a law to punish themselves? This, sir, is my great objection to the Constitution, that there is no true responsibility, and that the preservation of our liberty depends on the single chance of men being virtuous enough to make laws to punish themselves. In the country from which we are descended, they have real and not imaginary responsibility, for their maladministration has cost their heads to some of the most saucy geniuses that ever were. The Senate, by making treaties, may destroy your liberty and laws for want of its responsibility. 2/3 of those that shall happen to be present can, with the President, make treaties that shall be the supreme law of the land. They may make the most ruinous treaties, and yet there is no punishment for them. Whoever shows me a punishment provided for them will oblige me. So, sir, notwithstanding there are 8 pillars, they want another. Where will they make another? I trust, sir, the exclusion of the evils wherewith this system is replete in its present form will be made a condition precedent to its adoption by this or any other state. The transition from a general unqualified admission to offices to a consolidation of government seems easy, for though the American states are dissimilar in their structure, this will assimilate them. This, sir, is itself a strong consolidating feature, and is not one of the least dangerous in that system. 9 states are sufficient to establish this government over those 9. Imagine that 9 have come into it. Virginia has certain scruples. Suppose she will consequently refuse to join with those states. May not she still continue in friendship and union with them? If she sends her annual requisitions in dollars, do you think their stomachs will be so squeamish as to refuse her dollars? Will they not accept her regiments? They would intimidate you into an inconsiderate adoption, and frighten you with ideal evils, that the Union shall be dissolved. 'Tis a bugbear, sir. The fact is, sir, that the 8 adopting states can hardly stand on their own legs. Public fame tells us that the adopting states have already heartburns and animosity, and repent their precipitate hurry. This, sir, may occasion exceeding great mischief. When I reflect on these and many other circumstances, I must think those states will be found to be in confederacy with us. If we pay our quota of money annually, and furnish our rateable number of men, when necessary, I can see no danger from rejection. The history of Switzerland clearly proves that we might be in amicable alliance with those states without adopting this constitution. Switzerland is a confederacy consisting of dissimilar governments. This is an example which proves that governments of dissimilar structures may be confederated. That confederate republic has stood upwards for 400 years, and although several of the individual republics are democratic and the rest aristocratic, no evil has resulted from this dissimilarity, for they have braved all the power of France and Germany during that long period. The Swiss spirit, sir, has kept them together. They have encountered and overcome immense difficulties with patience and fortitude. In the vicinity of powerful and ambitious monarchs, they have retained their independence, republican simplicity, and valor. Look at the peasants of that country and of France, and mark the difference. You will find the condition of the former far more desirable and comfortable, no matter whether the people be great, splendid, and powerful, if they enjoy freedom. The Turkish Grand Signor alongside of our President would put us to disgrace, but we should be as abundantly consoled for this disgrace when our citizens have been put in contrast with the Turkish slave. The most valuable end of government is the liberty of the inhabitants. No possible advantages can compensate for the loss of this privilege. Show me the reason why the American Union is to be dissolved. Who are these 8 adopting states? Are they averse to give us a little time to consider before we conclude? Would such a disposition render a junction with them eligible? Or is it the genius of that kind of government to precipitate people hastily in the measures of the utmost importance, and grant no indulgence? If it be, sir, is it for us to accede to such a government? We have a right to have time to consider. We shall therefore insist upon it. Unless the government be amended, we can never accept it. The adopting states will doubtless accept our money and our regiments. And what is to be the consequence if we are disunited? I believe it is yet doubtful whether it is not proper to stand by a while, and see the effect of its adoption on other states. In forming a government, the utmost care should be taken to prevent its becoming oppressive, and this government is of such an intricate and complicated nature that no man on this earth can know its real operation. The other states have no reason to think, from the antecedent conduct of Virginia, that she has any intention of seceding from the Union, or of being less active to support the general welfare. Would they not, therefore, acquiesce in our taking our time to deliberate whether the measure be not perilous, not only for us, but the adopting states? Permit me, sir, to say that a great majority of the people, even in the adopting states, are averse to this government. I believe I would be right to say that they have been egregiously misled. Pennsylvania has, perhaps, been tricked into it. If the other states who have adopted it have not been tricked, still they were too much hurried into its adoption. There were very respectable minorities in several of them, and if reports be true, a clear majority of the people are averse to it. If we also accede, and it should prove grievous, that peace and prosperity of our country, which we all love, will be destroyed. The government has not the affection of the people at present. Should it be oppressive, their affections will be totally estranged from it, and, sir, you know that a government without their affections can neither be durable nor happy. I speak as one poor individual, but when I speak the language of thousands. But, sir, I mean not to breathe the spirit, nor utter the language, of secession. I have trespassed so long on your patience. I am really concerned that I have something yet to say. The honorable member has said we shall be properly represented. Remember, sir, that the number of our representatives is but 10, whereof 6 is a majority. Will those men be possessed of sufficient information? A particular knowledge of particular districts will not suffice. They must be well acquainted with agriculture, commerce, and a great variety of other matters throughout the continent. They must know not only the actual state of nations in Europe and America, the situations of their farmers, cottages, and mechanics, but also the relative situations and intercourse of those nations. Virginia is as large as England. Our proportion of representatives is but 10 men. In England, they have 558. The House of Commons in England, numerous as they are, we are told, are bribed, and have bartered away the rights of their constituents. What, then, shall become of us? Will these few protect our rights? Will they be incorruptible? You say that they will be better men than the English commoners. I say they will be infinitely worse men, because they are to be chosen blindfolded. Their election, the term as applied to their appointment is inaccurate, will be an involuntary nomination, and not a choice. I have, I fear, fatigued the committee, yet I have not said the 100,000th part of what I have on my mind and wish to impart. On this occasion, I conceived myself bound to attend strictly to the interest of the state, and I thought her dearest rights at stake. Having lived so long, been so much honored, my efforts, though small, are due to my country. I have found my mind hurried on from subject to subject on this very great occasion. We have been all out of order, from the gentleman who opened today to myself. I did not come prepared to speak on so multifarious a subject, in so general a manner. I trust you will indulge me another time. Before you abandon the present system, I hope you will consider not only its defects most maturely, but likewise those of that which you are to substitute for it. May you be fully apprised of the dangers of the latter, not by fatal experience, but by some abler advocate than I. End Anti-Federalist Papers, Section 54. Patrick Henry addressing the Virginia Ratifying Convention, Thursday, June 5th, 1788. Anti-Federalist Papers, Section 55. Patrick Henry, Virginia Ratifying Convention, Saturday, June 7th, 1788. This is Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Reading by M.L. Cohen, Cleveland, Ohio, May 2007. I have thought, and still think, that a full investigation of the actual situation of America ought to precede any decision of this great and important question. That government is no more than a choice among evils is acknowledged by most intelligent among mankind, and has been a standing maxim for ages. If it be demonstrated that the adoption of the new plan is a little or a trifling evil, then, sir, I acknowledge that adoption ought to follow. But, sir, if this be truth, that its adoption may entail misery on the free people of this country, I then insist that rejection ought to follow. Gentlemen strongly urge its adoption will be a mighty benefit to us. But, sir, I am made of so incredulous materials that assertions and declarations do not satisfy me. I must be convinced, sir. I shall retain my infidelity on that subject till I see our liberties secured in a manner perfectly satisfactory to my understanding. There are certain maxims by which every wise and enlightened people will regulate their conduct. There are certain political maxims which no free people ought ever to abandon, maxims of which the observance is essential to the security of happiness. It is impiously irritating the average hand of heaven when a people who are in full enjoyment of freedom launch out into the wide ocean of human affairs, and desert those maxims which alone can preserve liberty. Such maxims, humble as they are those only which can render a nation safe or formidable. Poor little humble republican maxims have attracted the admiration and engaged the attention of the virtuous and wise in all nations, and have stood the shock of ages. We do not now admit the validity of maxims which we once delighted in. We have since adopted maxims of a different, but more refined nature, new maxims which tend to the prostration of republicanism. We have one, sir, that all men are by nature free and independent, and have certain inherent rights of which, when they enter into society, they cannot by any compact deprive or divest their posterity. We have a set of maxims of the same spirit, which must be beloved by every friend to liberty, to virtue, to mankind. Our Bill of Rights contains these admirable maxims. Now, sir, I say, let us consider whether the picture given of American affairs ought to drive us from those beloved maxims. The honorable gentleman, Governor Randolph, has said that it is too late in the day for us to reject this new plan. That system which was once execrated by the honorable member must now be adopted, let its defects be ever so glaring. That honorable member will not accuse me of want of candor when I cast in my mind what he has given the public, and compare it to what has happened since. It seems to me very strange and unaccountable that that which was the object of his execration should now receive his encomiums. Something extraordinary must have operated so great a change as his opinion. It is too late in the day. Gentlemen must excuse me if they should declare again and again that it was too late, and I should think differently. I never can believe, sir, that it is too late to save all that is precious, if it be proper, and, independently of every external consideration, wisely constructed, let us receive it. But, sir, shall its adoption by 8 states induce us to receive it, if it be replete with the most dangerous defects? They urge that subsequent amendments are safer than previous amendments, and that they will answer the same ends. At present, we have our liberties and privileges in our own hands. Let us not relinquish them. Let us not adopt this system till we see them secure. There is some small possibility that, should we follow the conduct of Massachusetts, amendments might be obtained. There is a small possibility of amending any government. But, sir, shall we abandon our most inestimable rights, and rest their security on a mere possibility? The gentleman fears the loss of the Union. If 8 states have ratified it unamended, and we should rashly imitate their precipitate example, do we not thereby disunite from several other states? Shall those who have risked their lives for the sake of the Union be at once thrown out of it? If it be amended, every state will accede to it. But by an imprudent adoption in its defective and dangerous state, a schism must inevitably be the consequence. I can never, therefore, consent to hazard our most unalienable rights on an absolute uncertainty. You are told there is no peace, although you fondly flatter yourselves that all is peace. No peace, a general cry and alarm in the country, commerce, riches, and wealth vanished, citizens going to seek comforts in other parts of the world, laws insulted, many instances of tyrannical legislation. These things, sir, are new to me. He has made the discovery. As to the administration of justice, I believe that failures in commerce, etc., cannot be attributed to it. My age enables me to recollect its progress under the old government. I can justify it by saying that it continues in the same manner in this state as it did under the former government. As to other parts of the continent, I refer that to other gentlemen. As to the ability of those who administer it, I believe they would not suffer by a comparison with those who administered it under the royal authority. Where is the cause of complaint if the wealthy go away? Is this, added to other circumstances, of such enormity, and does it bring such danger over this commonwealth as to warrant so important and so awful a change in so precipitate a manner? As to insults offered to the laws, I know of none. In this respect, I believe this commonwealth would not suffer by comparison with the former government. The laws are well executed, and as patently acquiesced in as they were under the royal administration. Compare the situation of the country, compare that of our citizens to what it was then, to decide whether persons and property are not as safe and secure as they were at that time. Is there a man in this commonwealth whose person can be insulted with impunity? Cannot redress be had here for personal insults or injuries, as well as in any part of the world, as well as in those countries where aristocrats and monarchs triumph and reign? Is not the protection of property in full operation here? The contrary cannot with truth be charged on this commonwealth. Those severe changes which are exhibited against it appear to be totally groundless. On a fair investigation, we shall be found to be surrounded by no real dangers. We have the animating fortitude and persevering alacrity of republican men to carry us through misfortunes and calamities. It is the fortune of a republic to be able to withstand the stormy ocean of human vicissitudes. I know of no danger awaiting us. Public and private security are to be found here in the highest degree. Sir, it is the fortune of a free people not to be intimidated by imaginary dangers. Fear is the passion of slaves. Our political and natural hemisphere are now equally tranquil. Let us recollect the awful magnitude of the subject of our deliberation. Let us consider the latent consequences of an erroneous decision, and let not our minds be led away by unfair misrepresentations and uncandid suggestions. There have been many instances of uncommon lenity and temperance used in the exercise of power in this commonwealth. I could call your recollection to many that happened during the war and since, but every gentleman here must be apprised of them. The honorable member has given you an elaborate account of what he judges tyrannical legislation, and an ex post facto law (in the case of Josiah Phillips). He has misrepresented the facts. That man was not executed by a tyrannical stroke of power, nor was he a Socrates. He was a fugitive murderer and an outlaw, a man who commanded an infamous banditti, and at a time when the war was at its most perilous stage. He committed the most cruel and shocking barbarities. He was an enemy to the human name. Those who declare war against human race may be struck out of existence as soon as they are apprehended. He was not executed according to those beautiful legal ceremonies which are pointed out by laws in criminal cases. The enormity of his crimes did not entitle him to it. I am truly a friend to legal forms and methods, but, sir, the occasion warranted the measure. A pirate, an outlaw, or a common enemy to all mankind may be put to death at any time. It is justified by the law of nature and nations. The honorable member tells us, then, that there are burnings and discontents in the hearts of our citizens in general, and that they are dissatisfied with their government. I have no doubt the honorable member believes this to be the case, because he says so. But I have the comfortable assurance that it is a certain fact that it is not so. The middle and lower ranks of people have not these illuminated ideas which the well-born are so happily possessed of. They cannot so readily perceive latent objects. The microscopic eyes of modern statesmen can see abundance of defects in old systems, and their illuminated imaginations discover the necessity of a change. They are captivated by the parade of the number 10, the charms of the 10-mile square. Sir, I feel this charge will ultimately lead to our ruin. My fears are not the force of imagination. They are but too well founded. I tremble for my country. But, sir, I trust, I rely, and I am confident that this political speculation has not taken so strong a hold of men's minds as some would make us believe. The dangers which may arise from our geographical situation will be more properly considered a while hence. At present, what may be surmised on the subject, with respect to the adjacent states, is merely visionary. Strength, sir, is a relative term. When I reflect on the natural force of those nations that might be induced to attack us, and consider the difficulty of the attempt, and uncertainty of the success, and compare thereto the relative strength of our country, I say that we are strong. We have no cause to fear from that quarter. We have nothing to dread from our neighboring states. The superiority of our cause would give us an advantage over them, were they so unfriendly or rash to attack us. As to that part of the community, which the honorable gentleman spoke of as being in danger of being separated from us, what excitement or inducement could its inhabitants have to wish such an event? It is a matter of doubt whether they would derive any advantage to themselves, or be any loss to us by such separation. Time has been, and may yet come, when they will find it to their advantage and true interest to be united with us. There is no danger of a dismemberment of our country, unless a constitution be adopted which will enable the government to plan enemies on our backs. By the Confederation, the rights of territory are secured. No treaty can be made without the consent of 9 states. While the consent of 9 States is necessary to the cessation of territory, you are safe. If it be put in the power of a less number, you will most infallibly lose the Mississippi. As long as we can preserve our unalienable rights, we are in safety. This new Constitution will involve in its operation the loss of the navigation of that valuable river. The honorable gentleman cannot be ignorant of the Spanish transactions. A treaty had nearly been entered into with Spain to relinquish that navigation. That relinquishment would absolutely have taken place had the consent of 7 States been sufficient. The honorable gentleman told us then that 8 States have adopted the system. We cannot suppose they will recede on our account. I know not what they may do, but this I know, that a people of infinitely less importance than those of Virginia stood the terror of war. Vermont, sir, withstood the terror of 13 States. Maryland did not accede to the Confederation until the year 1781. These 2 States, feeble as they are comparatively to us, were not afraid of the whole Union. Did either of these States perish? No, sir, they were admitted freely into the Union. Will not Virginia, then, be admitted? I flatter myself that these States which have ratified the new plan of government will open their arms and cheerfully receive us, although we should propose certain amendments as the conditions on which we should ratify it. During the late war, all the States were in pursuit of the same object. To obtain that object, they made most strenuous exertions. They did not suffer trivial considerations to impede its acquisition. Give me leave to say that, if the smallest States in the Union were admitted into it, after having unreasonably procrastinated their accession, the greatest and most mighty State in the Union will be easily admitted, when her reluctance to an immediate accession to this system is founded on the most reasonable grounds. When I call this the most mighty State in the Union, do I not speak the truth? Does not Virginia surpass every State in the Union in number of inhabitants, extent of territory, felicity of position, and affluence and wealth? Some infatuation hangs over men's minds, and they will inconsiderately precipitate into measures the most important, and give not a moment's deliberation to others, nor pay any respect to their opinions. Is this federalism? Are these the beloved effects of the federal spirit, that its votaries will never accede to the just propositions of others? Sir, were there nothing objectionable in it but that, I would vote against it. I desire to have nothing to do with such men as will obstinately refuse to change their opinions. Are our opinions not to be regarded? I hope that you will recollect that you are going to join with men who will pay no respect even to this State. Switzerland consists of 13 cantons expressly confederated for national defense. They have stood the shock of 400 years. That country has enjoyed internal tranquility most of that long period. Their dissensions have been, comparatively to those in other countries, very few. What has passed in the neighboring countries? War, dissensions, and intrigues. Germany involved in the most deplorable civil war 30 years successively, continually convulsed with intestine divisions and harassed by foreign wars. France, with her mighty monarchy, perpetually at war. Compare the peasants of Switzerland with those of any other mighty nation, you will find them far more happy. For one civil war among them, there have been 5 or 6 among other nations. Their attachment to their country and freedom, their resolute intrepidity in their defense, and consequent security and happiness which they have enjoyed, and the respect and awe which these things produced in the bordering nations, have signalized those republicans. Their valor, sir, has been active. Everything that sets in motion the springs of the human heart engaged them to that protection of their inestimable privileges. They have not only secured their own liberty, but have been the arbiters of the fate of other people. Here, sir, contemplate the triumph of the republican governments over the pride of monarchy. I acknowledge, sir, that the necessity of national defense has prevailed in invigorating their councils and arms, and has been, in a considerable degree, the means of keeping these honest people together. But, sir, they have had wisdom enough to keep together, and render themselves formidable. Their heroism is proverbial. They would heroically fight for their government and their laws. One of the illumined sons of these times would not fight for those objects. Those virtuous and simple people have not a mighty and splendid president, nor enormously expensive navies and armies to support. No, sir, those brave Republicans have acquired their reputation no less by their undaunted intrepidity than by the wisdom of their frugal and economical policy. Let us follow their example, and be equally happy. The honorable member advises us to adopt a measure which will destroy our Bill of Rights, for, after having his picture of nations, and his reasoning for abandoning all the powers retained to the States by the Confederation, I am more firmly persuaded of the impropriety of adopting this new plan in its present shape. I had doubts of the power of those who went to the convention, but now we are possessed of it, let us examine it. When we trusted the great object of revising the Confederation to the greatest and best and most enlightened of our citizens, we thought their deliberations would have been solely confined to that revision. Instead of this, a new system, totally different in its nature, investing the most extensive powers in Congress, is presented. Will the 10 men you are to send to the Congress be more worthy than those 7 were? If power grew so rapidly in their hands, what may it not do in the hands of others? If those who go from this date will find power accompanied by temptation, our situation must be truly critical. When about forming a government, if we mistake the principles or commit any other error, the very circumstance promises that power will be abused. The greatest caution and circumspection are therefore necessary, nor does this proposed system, on its investigation here, deserve the least charity. The honorable gentleman says that the national government is without energy. I perfectly agree with him, and when he cries out "Union," I agree with him. But I tell him not to mistake the end for the means. The end is union. The most capital means, I suppose, are an army and navy. On a supposition, I will acknowledge this. Still the bare act of agreeing to that paper, though it may have an amazing influence, will not pay our millions. There must be things to pay debts. What these things are, or how they are to be produced, must be determined by our political wisdom and economy. The honorable gentleman alleges that previous amendments will prevent the junction of our riches from producing great profits and emoluments, which would enable us to pay our public debts by excluding us from the Union. I believe, sir, that a previous ratification of a system notoriously and confessedly defective will endanger our riches, our liberty, our all. Its defects are acknowledged; they cannot be denied. The reason offered by the honorable gentleman for adopting this defective system is its adoption by the 8 States. I say, sir, that, if we present nothing but what is reasonable in the shape of amendments, they will receive us. Union is as necessary for them as for us. Will they, then, be so unreasonable as not to join us? If such be their disposition, I am happy to know it in time. The honorable member then observed that nations will expend millions for commercial advantages. That is, they will deprive you of every advantage if they can. Apply this another way. Their cheaper way, instead of laying out millions and making war upon you, will be to corrupt your senators. I know that, if they not be above all price, they may make a sacrifice to our commercial interests. They may advise your president to make a treaty that will not only sacrifice all your commercial interests, but throw prostrate your Bill of Rights. Does he fear that their ships will outnumber ours on the ocean, or that nations whose interest comes in contact with ours, in the progress of their guilt, will perpetrate the vilest expedients to exclude us from a participation in commercial advantages? Does he advise us, in order to avoid this evil, to adopt a constitution, which will enable such nations to obtain their ends by the more easy mode of contaminating the principles of our senators? Sir, if our senators will not be corrupted, it will be because they will be good men, and not because the Constitution provides against corruption. For there is no real check secured in it, and the most abandoned and profligate act may with impunity be committed by them. With respect to Maryland, what danger from thence? I know none. I have not heard of any hostility premeditated or committed. 9/10 of the people have not heard of it. Those who are so happy as to be illumined have not informed their fellow citizens of it. I am so valiant as to say that no danger can come from that source sufficient to make me abandon my republican principles. The honorable gentleman ought to have recollected that there are no tyrants in America, as there are in Europe. The citizens of Republican borders are only terrible to tyrants. Instead of being dangerous to one another, they mutually support one another's liberties. We might be confederated with the adopting states without ratifying this system. No form of government renders a people more formidable. A confederacy of states joined together becomes strong as the United Netherlands. The government of Holland, execrated as it is, proves that the present confederation is adequate to every purpose of human association. There are 7 provinces confederated together for a long time, containing numerous opulent cities and many of the finest ports in the world. The recollection of the situation of that country would make me execrate monarchy. The singular felicity and success of that people are unparalleled. Freedom has done miracles there in reclaiming land from the ocean. It is the richest spot on the face of the globe. Have they no men or money? Have they no fleets or armies? Have they no arts and sciences among them? How did they repel the attacks of the greatest nations in the world? How have they acquired their amazing influence and power? Did they consolidate government to effect these purposes as we do? No, sir. They have trampled over every obstacle and difficulty, and have arrived at the summit of political felicity and of uncommon opulence by means of a confederacy, that very government which gentlemen affect to despise. They have, sir, avoided a consolidation as the greatest of evils. They have lately, it is true, made one advance to that fatal progression. This misfortune bursts on them by iniquity and artifice. That stadtholder, that executive magistrate, contrived it in conjunction with other European nations. It was not the choice of the people. Was it owing to his energy that this happened? If 2 provinces have paid nothing, what have not the rest done? And have not these 2 provinces made other exertions? Ought they, to avoid this inconvenience, to have consolidated their different states, and have a 10 miles square? Compare that little spot, nurtured by liberty, with the fairest country in the world. Does not Holland possess a powerful navy and army, and a full treasury? They did not acquire these by debasing the principles and trampling on the rights of their citizens. Sir, they acquired these by their industry, economy, and by the freedom of their government. Their commerce is the most extensive in Europe. Their credit is unequaled. Their felicity will be an eternal monument of the blessings of liberty. Every nation in Europe is taught by them what they are and what they ought to be. The contrast between those nations and this happy people is the most splendid spectacle for republicans, the greatest cause of exultation and triumph to the sons of freedom. While other nations, precipitated by the rage, ambition, or folly, have, in the pursuit of the most magnificent projects, riveted the fetters of bondage on themselves and descendants, these republicans secured in their political happiness and freedom. Where is there a nation to be compared to them? Where is there now, or where was there ever, a nation of so small a territory, and so few in numbers, so powerful, so wealthy, so happy? What is the cause of this superiority? Liberty, sir. The freedom of their government. Though they are now unhappily in some degrees consolidated, yet they have my acclamations, when put in contrast with those millions of their fellow men who lived and died like slaves. The dangers of a consolidation ought to be guarded against in this country. I shall exert my poor talents to ward them off. Dangers are to be apprehended in whatever manner we proceed, but those of a consolidation are the most destructive. Let us leave no expedient untried to secure happiness. But, whatever be our decision, I am consoled if American liberty will remain entire only for half a century, and I trust that mankind in general, and our posterity in particular, will be compensated for every anxiety we now feel. Another gentleman tells us that no inconvenience will result from the exercise of the power of taxation by the general government, that 2 shillings out of 10 may be saved by the impost, and that 4 shillings may be paid to the federal collector and 4 to the state collector. A change of government will not pay money. If, from the probable amount of the imposts, you take the enormous and extravagant expenses which will certainly attend the support of this great consolidated government, I believe you will find no reduction of the public burdens by this new system. The splendid maintenance of the President and of the member of both houses, and the salaries and fees of the swarm of officers and dependents of the government, will cost this continent immense sums. Double sets of collectors will double their expenses. To those are to be added oppressive excisemen and custom house officers. Sir, the people have a hereditary hatred to custom house officers. The experience of the mother country leads me to detest them. They have introduced their baneful influence into the administration and destroyed one of the most beautiful systems that ever the world saw. Our forefathers enjoyed liberty there while that system was in its purity, but now it is contaminated by influence of every kind. The style of the government, we the people, was introduced perhaps to recommend it to the people at large, to those citizens who are to be leveled and degraded to the lowest degree, who are likened to a herd, and who, by the operation of this blessed system, are to be transformed from respectable, independent citizens to abject, dependent subjects or slaves. The honorable gentleman has anticipated what we are to be reduced to by degradingly assimilating our citizens to a herd. I will exchange that abominable word for requisitions. Requisitions, which gentlemen affect to despise, have nothing degrading in them. On this depends our political prosperity. I never will give up that darling word requisitions. My country may give it up, a majority may wrest it from me, but I will never give it up till my grave. Requisitions are attended with one singular advantage: they are attended by deliberation. They secure to the states the benefit of correcting oppressive errors. If our assembly thought requisitions erroneous, if they thought the demand was too great, they might at least supplicate Congress to reconsider that it was a little too much. The power of direct taxation was called by the honorable gentleman the soul of the government. Another gentleman called it the lungs of the government. We all agree that it is the most important part of the body politic. If the power of raising money be necessary for the general government, it is no less so for the states. If money be the vitals of Congress, is it not precious for those individuals from whom it is to be taken? Must I give my soul, my lungs, to Congress? Congress must have our souls. The state must have our souls. This is dishonorable and disgraceful. These two coordinate, interfering, unlimited powers of harassing the community are unexampled. It is unprecedented in history. They are the visionary projects of modern politicians. Tell me not of imaginary means, but of reality. This political solecism will never tend to the benefit of the community. It will be as oppressive in practice as it is absurd in theory. If you part from this, which the honorable gentleman tells you is the soul of Congress, you will be inevitably ruined. I tell you, they shall not have the soul of Virginia. They tell us that one collector may collect the federal and state taxes, the general government being paramount to the state legislatures. If the sheriff is to collect for both, his right hand for Congress, his left for the state, his right hand being paramount over the left, his collections will go to Congress. We shall have the rest. Deficiencies in collections will always operate against the states. Congress, being the paramount supreme power, must not be disappointed. Thus, Congress will have an unlimited, unbounded command over the soul of the Commonwealth. After satisfying their uncontrolled demands, what can be left for the states? Not a sufficiency even to defray the expenses of their internal administration. They must therefore glide imperceptibly and gradually out of existence. This, sir, must naturally terminate in a consolidation. If this will do for other people, it never will do for me. If we are to have one representative for every 30,000 souls, it must be by implication. The Constitution does not positively secure it. Even say it is a natural implication. Why not give us a right to that proportion in express terms, in language that could not admit of evasions or subterfuges? If they can use implication for us, they can also use implication against us. We are giving power, they are getting power. Judge then on which side the implication will be used. When we once put it in their option to assume constructive power, danger will follow. Trial by jury and liberty of the press are also on this foundation of implication. If they encroach on these rights, and you give your implication for a plea, you are cast, for they will be justified by the last part of it, which gives them full power, "to make all laws which shall be necessary and proper to carry their power into execution." Implication is dangerous, because it is unbounded. If it be admitted at all, and no limits be prescribed, it admits of the utmost extension. They say that everything that is not given is retained. The reverse of the proposition is true by implication. They do not carry their implication so far when they speak of the general welfare. No implication when the sweeping clause comes. Implication is only necessary when the existence of privileges is in dispute. The existence of powers is sufficiently established. If we trust our dearest rights to implication, we shall be in a very unhappy situation. Implication in England has been a source of dissension. There has been a war of implication between the king and people. For 100 years did the mother country struggle under the uncertainty of implication. The people insisted that their rights were implied, the monarch denied the doctrine. The Bill of Rights, in some degree, terminated the dispute. By a bold implication, they said they had a right to bind us in all cases whatsoever. This constructive power we opposed, and successfully. 13 or 14 years ago, the most important thing that could be thought of was to exclude the possibility of construction and implication. These, sir, were then deemed perilous. The first thing that was thought of was a Bill of Rights. We were not satisfied with your constructive, argumentative rights. A Bill of Rights is indispensably necessary. A general positive provision should be inserted in the new system, securing to the states and the people every right which is not conceded to the general government, and every implication should be done away with. It now being late, I will resume the subject another time. End Anti-Federalist Papers, Section 55. Patrick Henry, Virginia Ratifying Convention, Saturday, June 7, 1788. Anti-Federalist Papers, Section 56. Patrick Henry, Virginia Ratifying Convention, Monday, June 9, 1788. This is a Librivox recording. All Librivox recordings are in the public domain. For more information or to volunteer, please visit Librivox.org. Read by M.L. Cohen, Cleveland, Ohio, May 2007. Mr. Chairman, I find myself again constrained to trespass on the patience of this committee. I wish there was a prospect of union in our sentiments. So much time would not then be taken up. But when I review the magnitude of the subject under consideration, and of dangers which appear to me in this new plan of government, and compare thereto my poor abilities to secure our rights, it will take much more time, in my poor, unconnected way, to traverse the objectionable parts of it. There are friends here who will be abler than myself to make good those objections which to us appear well founded. If we recollect, on last Saturday I made some observations on some of those dangers which these gentlemen would fain persuade us hang over the citizens of this Commonwealth, to induce us to change the government and adopt the new plan. Unless there be great and awful dangers, the change is dangerous, and the experiment ought not to be made. In estimating the magnitude of these dangers, we are obliged to take a most serious view of them, to see them, to handle them, and to be familiar with them. It is not sufficient to feign mere imaginary dangers. There must be a dreadful reality. The great question between us is, does that reality exist? These dangers are partially attributed to bad laws execrated by the community at large. It is said that the people wish to change the government. I should be happy to meet them on that ground. Should the people wish to change it, we should be innocent of the dangers. It is a fact that the people do not wish to change their government. How am I to prove it? It will rest on my bare assertion, unless supported by an internal conviction in men's breasts. My poor say-so is mere nonentity. But, sir, I am persuaded that 4/5 of the people of Virginia must have amendments to the new plan to reconcile them to a change of their government. It is a slippery foundation for the people to rest their political salvation on my or their assertions. No government can flourish unless it be founded on the affection of the people. Unless gentlemen can be sure that this new system is founded on that ground, they ought to stop their career. I will not repeat what the gentlemen say. I will mention one thing. There is a dispute between us and the Spaniards about the right of navigating the Mississippi. This dispute is sprung from the federal government. I wish a great deal to be said on this subject. I wish to know the origin and progress of the business, as it would probably unfold great dangers. In my opinion, the preservation of that river calls for our most serious consideration. It has been agitated in Congress. 7 states have voted, so that it is known to the Spaniards that under our existing system, the Mississippi shall be taken from them. 7 states wish to relinquish this river to them. The 6 southern states opposed it. 7 states not being sufficient to convey it away, it remains now ours. If I am wrong, there is a number on this floor who can contradict the facts. I will readily retract. This new government, I conceive, will enable those states who have already discovered their inclination that way to give away this river. Will the honorable gentleman advise us to relinquish its inestimable navigation and place formidable enemies on our backs? This poor confederation cannot secure us. We are resolved to take shelter under the shield of federal authority in America. The southern parts of America have been protected by that weakness so much execrated. I hope this will be explained. I was not in Congress when these transactions took place. I may not have stated every fact. I may have misrepresented matters. I hope to be fully acquainted with everything relative to the object. Let us hear how the great and important right of navigating that river has been attended to, and whether I am mistaken in my opinion that federal measures will lose it to us forever. If a bare majority of Congress can make laws, the situation of our Western citizens is dreadful. We are threatened with danger for the non-payment of our debt due to France. We have information come from an illustrious citizen of Virginia, who is now in Paris, which disproves the suggestions of such dangers. This citizen has not been in the airy regions of theoretic speculation. Our ambassador is this worthy citizen. The ambassador of the United States of America is not so despised as the honorable gentleman would make us believe. A servant of a republic is as much respected as that of a monarch. The honorable gentleman tells us that hostile fleets are to be sent to make reprisals upon us. Our ambassador tells you that the King of France has taken into consideration to enter into commercial regulations on reciprocal terms with us, which will be a peculiar advantage to us. Does this look like hostility? I might go farther. I might say, not from public authority, but good information, that his opinion is that you reject this government. His character and abilities are in the highest estimation. He is well acquainted in every respect with this country, equally so with the policy of the European nations. This illustrious citizen advises you to reject this government till it be amended. His sentiments coincide entirely with ours. His attachment to and services done for this country are well known. At a great distance from us, he remembers and studies our happiness. Living in splendor and dissipation, he thinks yet of Bill of Rights, thinks of those little, despised things called maxims. Let us follow the sage advice of this common friend of our happiness. It is little usual for nations to send armies to collect debts. The House of Bourbon, that great friend to America, will never attack her for her unwilling delay of payment. Give me leave to say that Europe is too much endangered about objects of greater importance to attend to us. On that great theater of the world, the little American matters vanish. Do you believe that the mighty monarch of France, beholding the greatest scenes that ever engaged the attention of a prince of that country, will divert himself for those important objects and now call for a settlement of accounts with America? This proceeding is not warranted by good sense. The friendly disposition to us and the actual situation of France render the idea of danger from that quarter absurd. Would this countryman of ours be fond of advising us to a measure which he knew to be dangerous? And can it reasonably be supposed that he can be ignorant of any premeditated hostility against this country? The honorable gentleman may suspect the account, but I will do our friend the justice to say that he would warn us of any danger from France. Do you suppose the Spanish monarch will risk a contest with the United States when his feeble colonies are exposed to them? Every advance that people make to the westward makes him tremble for Mexico and Peru. Despised as we are among ourselves, under our present government, we are terrible to that monarchy. If this not be a fact, it is generally said so. We are, in the next place, frightened by dangers from Holland. We must change our government to escape the wrath of that republic. Holland groans under a government like this new one. A stadtholder, sir, a Dutch president, has brought on that country miseries which will not permit them to collect debts with fleets or armies. The wife of a Dutch stadtholder brought 100,000 men against the republic and prostrated all opposition. This president will bring the miseries on us like those of Holland. Such is the condition of European affairs, that it would be unsafe for them to send fleets or armies to collect debts. But here, sir, they make a transition to objects of another kind. We are presented with dangers of a very uncommon nature. I am not acquainted with the arts of painting. Some gentlemen have a peculiar talent for them. They are practised with great ingenuity on this occasion. As a counterpart to what we have already been intimidated with, we are told that some lands have been sold, which cannot be found, and that this will bring war on this country. Here the picture will not stand examination. Can it be supposed, if a few land speculators and jobbers have violated the principles of probity, that it will involve this country in war? Is there no redress to be otherwise obtained, even admitting the delinquents and sufferers to be numerous? When gentlemen are thus driven to produce imaginary dangers, to induce this convention to assent to this change, I am sure it will not be uncandid to say that the change itself is really dangerous. Then the Maryland compact is broken, and will produce perilous consequences. I see nothing very terrible in this. The adoption of the new system will not remove the evil. Will they forfeit good neighborhood with us because the compact is broken? Then the disputes concerning the Carolina line are to involve us in dangers. A strip of land running from the westward of the Alleghany to the Mississippi is the subject to this pretended dispute. I do not know the length or breadth of this disputed spot. Have they not regularly confirmed our right to it, and relinquished all claims to it? I could venture to pledge that the people of Carolina will never disturb us. The strength of this despised country has settled an immense tract of the country of the westward. Give me leave to remark that the honorable gentleman's observation on our frontiers, north and south, east and west, are all inaccurate. Will Maryland fight against this country for seeking amendments? Were there not 60 members in that state who went in quest of amendments? 60 against 8 or 10 were in favor of pursuing amendments. Shall they fight us for doing what they themselves have done? They have sought amendments, but differently from the manner in which I wish amendments to be got. The honorable gentleman may plume himself on this difference. Will they fight us for this dissimilarity? Will they fight us for seeking the objects they seek themselves? When they do, it will be time for me to hold my peace. Then, sir, comes Pennsylvania, in terrible array. Pennsylvania is to go in conflict with Virginia. Pennsylvania has been a good neighbor heretofore. She is federal, something terrible. Virginia cannot look her in the face. If we sufficiently attend to the actual situation of things, we shall conclude that Pennsylvania will do what we do. A number of that country are strongly opposed to it. Many of them have lately been convinced of its fatal tendency. They are disgorged of their federalism. I beseech you to bring this matter home to yourselves. Was there a possibility for the people of that state to know the reasons of adopting that system, or understanding its principles in so very short a period after its formation? This is the middle of June. Those transactions happened last August. The matter was circulated by every effort of industry and the most precipitate measures taken to hurry the people into adoption. Yet now, after having had several months to investigate it, a very large part of this community, a great majority of this community, do not understand it. I have heard gentlemen of respectable abilities declare that they did not understand it. If, after great pains, men of high learning, who have received the aids of a regular education, do not understand it, if the people of Pennsylvania understood it in so short a time, it must have been from intuitive understandings and uncommon acuteness of perception. Place yourselves in their situation. Would you fight your neighbors for considering this great and awful matter? If you wish for real amendments, such as the security of trial by jury, it will reach the hearts of the people of that state. Whatever may be the disposition of the aristocratical politicians of that country, I know there are friends of human nature in that state. If so, they will never make war on those who make professions of what they are attached to themselves. As to dangers arising from borderers, it is mutual and reciprocal. If it be dangerous for Virginia, it is equally so for them. It will be their true interest to be united with us. The danger of our being their enemies will be a prevailing argument in our favor. It will be as powerful to admit us into the Union as a vote of adoption, without previous amendments, could possibly be. Then the savage Indians are to destroy us. We cannot look them in the face. The danger is here divided. They are as terrible to the other states as to us. But, sir, it is well known that we have nothing to fear from them. Our back settlers are considerably stronger than they. Their superiority increases daily. Suppose the states to be confederated all around us, what we want in numbers we shall make up otherwise. Our compact situation and natural strength will secure us. But to avoid all dangers, we must take shelter under the federal government. Nothing gives us a decided importance but this federal government. You will sip sorrow, according to that vulgar phrase, if you want any other security than the laws of Virginia. A number of characters of the greatest eminence in this country object to this government for its consolidating tendencies. This is not imaginary. It is a formidable reality. If consolidation proves to be as mischievous to this country as it has been to other countries, what will the poor inhabitants of this country do? This government will operate like an ambuscade. It will destroy the state governments and swallow the liberties of the people without giving previous notice. If gentlemen are willing to run the hazard, let them run it, but I shall exculpate myself by my opposition and monitory warnings within these walls. But then comes paper money. We are at peace on this subject. Though this is a thing which the mighty Federal Convention had no business with, yet I acknowledge that paper money would be the bane of this country. I detest it. Nothing can justify people in resorting to it but extreme necessity. It is at rest, however, in this commonwealth. It is no longer solicited or advocated. Sir, I ask you, and every other gentleman who hears me, if he can retain his indignation at a system which takes from the state legislatures the care and preservation of the interest of the people. 180 representatives, the choice of the people of Virginia, cannot be trusted with their interests. They are a mobbish, suspected herd. This country has not virtue enough to manage its own internal interests. These must be referred to the chosen 10. If we cannot be trusted with the private contracts of the citizens, we must be depraved indeed. If he can prove that, by one uniform system of abandoned principles, the legislature has betrayed the rights of the people, then let us seek another shelter. So degrading an indignity, so flagrant an outrage on the states, so vile a suspicion, is humiliating to my mind, and many others. Will the adoption of this new plan pay our debts? This, sir, is a plain question. It is inferred that our grievances are to be redressed, and the evils of the existing system to be removed by the new Constitution. Let me inform the honorable gentleman that no nation has ever paid its debts by a change of government, without the aid of industry. You will never pay your debts but by a radical change of domestic economy. At present you buy too much, and make too little to pay. Will this system promote manufactures, industry, and frugality? If, instead of this, your hopes and designs will be disappointed, you relinquish a great deal, and hazard indefinitely more, for nothing. Will it enhance the value of your lands? Will it lessen your burdens? Will your looms and wheels go to work by the act of adoption? If it will, in its consequence, produce these things, it will consequently produce a reform and enable you to pay your debts. Gentlemen must prove it. I am a skeptic, an infidel on this point. I cannot conceive that will have these happy consequences. I cannot confide in assertions and allegations. The evils that attend us lie in extravagance and want of industry, and can only be removed by assiduity and economy. Perhaps we shall be told by gentlemen that these things will happen because the administration is to be taken from us and placed in the hands of the few, who will pay greater attention and be more studiously careful than we can be supposed to be. With respect to the economical operation of the new government, I will only remark that the national expenses will be increased. If not doubled, it will approach it very nearly. I might, without incurring the imputation of illiberality or extravagance, say that the expense will be multiplied tenfold. I might tell you of a numerous standing army, a great powerful navy, a long and rapacious train of officers and dependents, independent of the President, senators, and representatives, whose compensations are without limitation. How are our debts to be discouraged unless the taxes are increased, when the expenses of the government are so greatly augmented? The defects of this system are so numerous and palpable, and so many states object to it, that no union can be expected unless it be amended. Let us take a review of the facts. New Hampshire and Rhode Island have rejected it. They have refused to become federal. New York and North Carolina are reported to be strongly against it. From high authority, give me leave to tell that New York is in high opposition. Will any gentleman say that North Carolina is not against it? They may say so, but I say the adoption of it in those two states amounts to an entire uncertainty. The system must be amended before these 4 states will accede to it. Besides, there are several other states who are dissatisfied and wish alterations. Massachusetts had, in decided terms, proposed amendments, but, by her previous ratification, has put the cart before the horse. Maryland instituted a committee to propose amendments. It then appears that 2 states have actually refused to adopt. 2 of those who have adopted have a desire of amending, and there is a probability of its being rejected by New York and North Carolina. The other states have acceded without proposing amendments. With respect to them, local circumstances have, in my judgment, operated to produce its unconditional, instantaneous adoption. The locality of the seat of government, 10 miles square, and the seat of justice, with all their concomitant emoluments, operated so powerfully with the first adopting state that it was adopted without taking time to reflect. We are told that numerous advantages will result from the concentration of the wealth and grandeur of the United States in one happy spot to those who will reside in or near it. Prospects of profits and emoluments have a powerful influence on the human mind. We, sir, have no such projects as that of a grand seat of government for 13 states, and perhaps for 100 states hereafter. Connecticut and New Jersey have their localities also. New York lies between them. They have no ports and are not importing states. New York is an importing state, and, taking advantage of its situation, makes them pay duties for all the articles of their consumption. Thus these two states, being obliged to import all they want through the medium of New York, pay the particular taxes of that state. I know the force and effect of reasoning of this sort by experience. When the impost was proposed some years ago, those states which were not importing states readily agreed to concede to Congress the power of laying an impost on all goods imported, for the use of the continental treasury. Connecticut and New Jersey, therefore, are influenced by advantages of trade in their adoption. The amount of all imposts to go into one common treasury. This favors adoption by the non-importing states, as they participate in the profits which were before exclusively enjoyed by the importing states. Notwithstanding this obvious advantage to Connecticut, there is a formidable minority there against it. After taking this general view of American affairs as respecting federalism, will the honorable gentleman tell me that he can expect union in America? When so many states are pointedly against it, when two adopting states have pointed out in express terms their dissatisfaction as it stands, and when there is so respectable a body of men discontented in every state, can the honorable gentleman promise himself harmony of which he is so fond? If he can, I cannot. To me it appears unequivocally clear that we shall not have that harmony. If it appears to the other states that our aversion is founded on just grounds, will they not be willing to indulge us? If disunion will really result from Virginia's proposing amendments, will they not wish the reestablishment of the Union and admit us, if not on such terms as we prescribe, yet on advantageous terms? Is not union as essential to their happiness as to ours? Sir, without a radical alteration, the states will never be embraced on one federal pale. If you attempt to force it down men's throats and call it union, dreadful consequences must follow. He has said a great deal of disunion, and the dangers that are to arise from it. When we are on the subject of disunion and dangers, let me ask, how will his present doctrine hold with what has happened? Is it consistent with that noble and disinterested conduct which he displayed on a former occasion? Did he not tell us that he withheld a signature? Where, then, were the dangers which now appear to him so formidable? He saw all America eagerly confiding that the result of their deliberations would remove their distresses. He saw all America acting under the impulses of hope, expectation, and anxiety arising from their situation, and their partiality for the members of that convention. Yet his enlightened mind, knowing that system to be defective, magnanimously and nobly refused its approbation. He was not led by the illumined, the illustrious few. He was actuated by the dictates of his own judgment, and a better judgment than I can form. He did not stand out of the way of information. He must have been possessed of every intelligence. What alteration has a few months brought about? The eternal difference between right and wrong does not fluctuate. It is immutable. I ask this question as a public man, and out of no particular view. I wish, as such, to consult every source of information to form my judgment on so awful a question. I had the highest respect for the honorable gentleman's abilities. I considered his opinion as a great authority. He taught me, sir, in despite of the approbation of that great federal convention, to doubt of the propriety of that system. When I found my honorable friend in the number of those who doubted, I began to doubt also. I coincided with him in opinion. I shall be a staunch and faithful disciple of his. I applaud that magnanimity which led him to withhold his signature. If he thinks now differently, he is as free as I am. Such is my situation, that as a poor individual I look for information everywhere. This government is so new, it wants a name. I wish its other novelties were as harmless as this. He told us we had an American dictator in the year 1781. We never had an American president. In making a dictator, we followed the example of the most glorious, magnanimous, and skillful nations. In great dangers, this power has been given. Rome had furnished us with an illustrious example. America found a person for that trust. She looked to Virginia for him. We gave a dictatorial power to hands that used it gloriously, and which were rendered more glorious by surrendering it up. Where is there a breed of such dictators? Shall we find a set of American presidents of such a breed? Will the American president come and lay prostrate at the feet of Congress his laurels? I fear there are few men who can be trusted on that head. The glorious Republic of Holland has erected monuments of her warlike intrepidity and valor, yet she is now totally ruined by a stadtholder, a Dutch president. The destructive wars into which that nation has been plunged have since involved her in ambition. The glorious triumphs of Blenheim and Ramillies were not so conformable to the genius, nor so much to the true interest of the Republic, as those numerous and useful canals and dikes and other objects at which ambition spurns. That Republic has, however, by the industry of its inhabitants and policy of its magistrates, suppressed the ill effects of ambition. Notwithstanding 2 of their provinces having paid nothing, yet I hope the example of Holland will tell us that we can live happily without changing our present despised government. Cannot people be as happy under a mild as under an energetic government? Cannot content and felicity be enjoyed in republics as well as in monarchies, because there are whips, chains, and scourges used in the latter? If I am not as rich as my neighbor, if I give my might, my all, republican forbearance will say that it is sufficient. So said the honest Confederates of Holland. You are poor, we are rich. We will go on, and do better than be under an oppressive government. Far better will it be for us to continue as we are than to go under that tight, energetic government. I am persuaded of what the honorable gentleman says, that separate confederacies will ruin us. In my judgment, there are evils never to be thought of till a people are driven by necessity. When he asks my opinion of consolidation, of one power to reign over America with a strong hand, I will tell him, I am persuaded of the rectitude of my honorable friend's opinion, Mr. Mason, that one government cannot reign over so extensive a country as this is without absolute despotism. Compared to such consolidation, small confederacies are little evils, though they ought to be recurred to but in case of necessity. Virginia and North Carolina are despised. They could exist separated from the rest of America. Maryland and Vermont were not overrun when out of the Confederacy. Though it is not a desirable object, yet I trust that on examination it will be found that Virginia and North Carolina would not be swallowed up in case it was necessary for them to be joined together. When we come to the spirit of domestic peace, the humble genius of Virginia has formed a government suitable to the genius of her people. I believe the hands that formed the American Constitution triumph in the experiment. It proves that the man who formed it, and perhaps by accident, did what design could not do in other parts of the world. After all your reforms in government, unless you consult the genius of its inhabitants, you will never succeed. Your system can have no duration. Let me appeal to the candor of the committee, if the want of money be not the source of all our misfortunes. We cannot be blamed for not making dollars. This want of money cannot be supplied by changes in government. The only possible remedy, as I have before asserted, is industry, aided by economy. Compare the genius of the people with the government of this country. Let me remark that it stood the severest conflict during the war to which ever human virtue has been called. I call upon every gentleman here to declare whether the King of England had any subjects so attached to his family and government, so loyal as we were. But the genius of Virginia called on us for liberty, called us from those beloved endearments which from long habits we were taught to love and revere. We entertained from our earliest infancy the most sincere regard and reverence for the mother country. Our partiality extended to a predilection for her customs, habits, manners, and laws. Thus inclined, when the deprivation of our liberty was attempted, what did we do? What did the genius of Virginia tell us? Sell all and purchase liberty. This was a severe conflict. Republican maxims were then esteemed. Those maxims and the genius of Virginia landed you safe on the shore of freedom. On this awful occasion, did you want a federal government? Did federal ideas possess your minds? Did federal ideas lead you to the most splendid victories? I must again repeat the favorite idea that the genius of Virginia did, and will again, lead us to happiness. To obtain the most splendid prize you did not consolidate. You accomplished the most glorious ends by the assistance of the genius of your country. Men were then taught by that genius that they were fighting for what was most dear to them. View the most affectionate father, the most tender mother, operated on by liberty, nobly stimulating their sons, their dearest sons, sometimes their only son, to advance the defense of their country. We have seen the sons of Cincinnatus, without splendid magnificence of parade, going, with the genius of their great progenitor Cincinnatus, to the plough. Men who served their country without ruining it, men who had served to the destruction of their private patrimonies, the country owing them amazing accounts for the payment of which no adequate provision was then made. We have seen such men throw prostrate their arms at your feet. They did not call for those emoluments which ambition presents to some imaginations. The soldiers, who were able to command everything, instead of trampling on those laws which they were instituted to defend, most strictly obeyed them. The hands of justice have not been laid on a single American soldier. Bring them into contrast with Europeans. You will see an astonishing superiority over the latter. There has been a strict subordination to the laws. The honorable gentleman's office gave him an opportunity of viewing if the laws were administered so as to prevent riots, routs, and unlawful assemblies. From his then situation, he could have furnished us with the instances in which licentiousness trampled on the laws. Among all our troubles, we have paid almost to the last shilling for the sake of justice. We have paid as well as any state. I will not say better. To support the general government and our own legislature, to pay the interest of the public debts and defray contingencies, we have been heavily taxed. To add to these things, the distress produced by paper money and by tobacco contracts were sufficient to render any people discontented. These, sir, were great temptations. But in the most severe conflict of misfortune, this code of laws, this genius of Virginia, call it what you will, triumphed over everything. Why did it please the gentleman, Mr. Corbin, to bestow such epithets on our country? Have the worms taken possession of the wood, that our strong vessel, our political vessel, has sprung a leak? He may know better than I, but I consider such epithets to be the most illiberal and unwarrantable aspersions on our laws. The system of laws under which we have lived has been tried and found to suit our genius. I trust we shall not change this happy system. I cannot so easily take leave of an old friend, till I see him following after and pursuing other objects, which can pervert the great objects of human legislation. Pardon me if I withhold my assent. Some here speak of the difficulty in forming a new code of laws. Young as it were not wonderful if there was a difficulty in forming and assimilating one system of laws. I shall be obliged to the gentleman if he would point out those glaring, those great faults. The efforts of assimilating our laws to our genius have not been found altogether vain. I shall pass over some other circumstances which I intended to mention, and endeavor to come to the capital objection which my honorable friend has made. My worthy friend said that a republican form of government would not suit a very extensive country, but that if a government were judiciously organized and limits prescribed to it, an attention to these principles might render it possible for it to exist in an extensive territory. Whoever will be bold to say that a continent can be governed by that system contradicts all the experience of the world. It is a work too great for human wisdom. Let me call for an example. Experience has been called the best teacher. I call for an example of great extent of country, governed by one government or Congress, call it what you will. I tell him that a government may be trimmed up according to gentlemen's fancy, but it never can operate. It would be but very short-lived. However disagreeable it may be to lengthen my objections, I cannot help taking notice of what honorable gentlemen said. To me it appears that there is no check in that government. The President, Senators, and Representatives all, immediately or mediately, are the choice of the people. Tell me not of checks on paper, but tell me of checks founded on self-love. The English government is founded on self-love. This powerful, irresistible stimulus of self-love has saved that government. It has interposed that hereditary nobility between the king and commons. If the host of lords assist or permit the king to overturn the liberties of the people, the same tyranny will destroy them. They will therefore keep the balance in the democratic branch. Suppose they see the commons encroach upon the king. Self-love, that great energetic check, will call upon them to interpose, for if the king be destroyed, their destruction must speedily follow. Here is a consideration which prevails in my mind to pronounce the British government superior, in this respect, to any government that ever was in any country. Compare this with your congressional checks. I beseech gentlemen to consider whether they can say, when trusting power, that a more patriotic profession will be equally operative and efficacious as the check of self-love. In considering the experience of ages, is it not seen that fair, disinterested patriotism and professions of attachment to rectitude have never been solely trusted to by enlightened free people? If you depend on your presidents' and senators' patriotism, you are gone. Have you a resting place like the British government? Where is the rock of your salvation? The real rock of political salvation is self-love, perpetuated from age to age in every human breast, and manifested in every action. If they can stand the temptations of human nature, you are safe. If you have a good president, senators, and representatives, there is no danger. But can this be expected from human nature? Without real checks, it will not suffice that some of them are good. A good president, or senator, or representative will have a natural weakness. Virtue will slumber. The wicked will be continually watching. Consequently, you will be undone. Where are your checks? You have no hereditary nobility, an order of men to whom human eyes can be cast up for relief. For, says the Constitution, there is no title of nobility to be granted, which, by the by, would not have been so dangerous as the perilous succession of powers contained in this paper, because, as Montesquieu says, when you give titles of nobility, you know what you give, but when you give power, you know not what you give. If you say that, out of this depraved mass, you can collect luminous characters, it will not avail unless this luminous breed will be propagated from generation to generation. And even then, if the number of vicious characters will preponderate, you are undone. And that this will certainly be the case is, to my mind, perfectly clear. In the British government, there are real balances and checks. In this system, there are only ideal balances. Till I am convinced that there are actual efficient checks, I will not give my assent to its establishment. The President and Senators have nothing to lose. They have not that interest in the preservation of the government that the King and Lords have in England. They will, therefore, be regardless of the interests of the people. The Constitution will be as safe with one body as with two. It will answer every purpose of human legislation. How was the Constitution of England when only the Commons had the power? I need not remark that it was the most unfortunate era when that country returned to King, Lords, and Commons without sufficient responsibility in the King. When the Commons of England, in the manly language which became free men, said to their King, "You are our servant," then the temple of liberty was complete. From that noble source have we derived our liberty, that spirit of patriotic attachment to one's country, that zeal for liberty, and that enmity to tyranny, which signalized the then champions of liberty, we inherit from our British ancestors. And I am free to own that, if you cannot love a republican government, you may love the British monarchy, for although the King is not sufficiently responsible, the responsibility of his agents and the efficient checks interposed by the British Constitution render it less dangerous than other monarchies or oppressive tyrannical aristocracies. What are the checks of exposing accounts? The checks upon paper are inefficient and nugatory. Can you search your president's closet? Is this a real check? We ought to be exceedingly cautious in giving up this life, this soul of money, this power of taxation to Congress. What powerful check is there here to prevent the most extravagant and profligate squandering of the public money? What security have we in money matters? Inquiry is precluded by this Constitution. I never wish to see Congress supplicate the States. But it is more abhorrent to my mind give them an unlimited and unbounded command over our souls, our lives, our purses, without any check or restraint. How are you to keep inquiry alive? How discover their conduct? We are told by that paper that a regular statement and account of receipts and expenditures of all public money shall be published from time to time. Here is a beautiful check. What time? Here is the utmost latitude left. If those who are in Congress please to put that construction upon it, the words of the Constitution will be satisfied by publishing these accounts once in every 100 years. They may publish or not as they please. Is this like the present despised system, whereby the accounts are to be published monthly? I come now to speak something of requisitions, which the honorable gentleman thought so truly contemptible and disgraceful. That incorrigible gentleman, being a child of the Revolution, must recollect with gratitude the glorious effects of requisitions. It is an idea that must be grateful to every American. An English army was sent to compel us to pay money contrary to our consent, to force us, by arbitrary and tyrannical coercion, to satisfy their unbounded demands. We wished to pay with our own consent. Rather than pay against our consent, we engaged in that bloody contest which terminated so gloriously. By requisitions we pay with our own consent. By the means we have triumphed in the most arduous struggle that ever tried the virtue of man. We fought then for what we are contending for now, to prevent an arbitrary deprivation of our property, contrary to our consent and inclination. I shall be told in this place that those who are to tax us are our representatives. To this I answer, that there is no real check to prevent their ruining us. There is no actual responsibility. The only semblance of a check is the negative power of not re-electing them. This, sir, is but a feeble barrier when their personal interest, their ambition, and avarice come to be put in contrast with the happiness of the people. All checks founded on anything but self-love will not avail. The Constitution reflects in the most degrading and mortifying manner on the virtue, integrity, and wisdom of the state legislatures. It presupposes that the chosen few who go to Congress will have more upright hearts and more enlightened minds than those who are members of the individual legislatures. To suppose that 10 gentlemen shall have more real, substantial merit than 170 is humiliating to the last degree. If, sir, the diminution of numbers be an augmentation of merit, perfection must center in one. If you have the faculty of discerning spirits, it is better to point out at once the man who has this most illuminated qualities. If 10 men be better than 170, it follows of necessity that 1 is better than 10. The choice is more refined. Such is the danger of the abuse of implied power, that it would be safer at once to have 7 representatives, the number to which we are now entitled, than depend upon the uncertain and ambiguous language of this paper. The number may be lessened instead of being increased, and yet, by argumentative constructive implied power, the proportion of taxes may continue the same, or be increased. Nothing is more perilous than constructive power, which gentlemen are so willing to trust their happiness to. If sheriffs prove now an overmath for our legislature, if their ingenuity has eluded the vigilance of our laws, how will the manner be amended when they come clothed with federal authority? A strenuous argument offered by gentlemen is, that the same sheriffs may collect for the continental and state treasuries. I have before shown that this must have an inevitable tendency to give a decided preference to the federal treasury in actual collections, and to throw all deficiencies on the state. This imaginary remedy for the evil of congressional taxation will have another oppressive operation. The sheriff comes today as a state collector, next day as federal. How are you to fix him? How will it be possible to discriminate oppressions committed in one capacity from those perpetrated in another? Will not this ingenuity perplex the simple and honest planter? This will at least involve in difficulties those who are unacquainted with legal ingenuity. When you fix him, where are you to punish him? For I suppose they will not stay in our courts, they must go to the federal court. For if I understand that paper right, all controversies arising under the Constitution or under the laws made in pursuance thereof are to be tried in that court. When gentlemen told us that this part deserved the least exception, I was in hopes they would prove that there was plausibility in their suggestions, and that oppression would probably not follow. Are we not told that it shall be treason to levy war against the United States? Suppose an insult offered to the federal laws at an immense distance from Philadelphia. Will this be deemed treason? And shall a man be dragged many hundred miles to be tried as a criminal for having, perhaps justifiably, resisted an unwarrantable attack upon his person or property? I am not well acquainted with federal jurisprudence, but it appears to me that these oppressions must result from this part of the plan. It is at least doubtful, and where there is even a possibility of such evils, they ought to be guarded against. There are to be a number of places fitted out for arsenals and dockyards in the different states. Unless you sell to Congress such places as are proper for these, within your state, you will not be as consistent after adoption. It results, therefore, clearly that you are to give into the hands all such places as are fit for strongholds. When you have these fortifications and garrisons within your state, your legislature will have no power over them, though they see the most dangerous insults offered to the people daily. They are also to have magazines in each state. These depositories for arms, though within the state, will be free from the control of its legislature. Are we at last brought to such a humiliating and debasing degradation that we cannot be trusted with arms for our own defense? Where is the difference between having our arms in our possession and under our own direction and having them under the management of Congress? If our defense be the real object of having those arms, in whose hands can they be trusted with more propriety, or equal safety to us, as in our own hands? If our legislature be unworthy of legislating for every foot in this state, they are unworthy of saying another word. The clause which says the Congress shall, quote, provide for arming, organizing, and disciplining in the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers, end quote, seem to put the states in power of Congress. I wish to be informed, if a Congress neglected to discipline them, whether the states were not precluded from doing it. Not being favored with a particular answer, I am confirmed in my opinion that the states have not the power of disciplining them, without recurring to the doctrine of constructed implied powers. If by implication the states may discipline them, by implication also Congress may officer them, because, in a partition of power, each has a right to come in for part, and because implication is to operate in favor of Congress on all occasions, where their object is an extension of power, as well as in favor of the states. We have not 1/4 of the arms that would be sufficient to defend ourselves. The power of arming the militia, and the means of purchasing arms, are taken from the state by the paramount powers of Congress. If Congress will not arm them, they will not be armed at all. There have been no instances shown of a voluntary cession of power sufficient to induce me to grant the most dangerous power. A possibility of their future relinquishment will not persuade me to yield such powers. Congress, by the power of taxation, by that of raising an army, and by their control over the militia, have the sword in one hand and the purse in the other. Shall we be safe without either? Congress have an unlimited power over both. They are entirely given up by us. Let him candidly tell me where and when did freedom exist when the sword and purse were given up from the people? Unless a miracle in human affairs interposed, no nation ever retained its liberty after loss of the sword and purse. Can you prove by any argumentative deduction that it is possible to be safe without retaining one of these? If you give them up, you are gone. Give us least a plausible apology why Congress should keep their proceedings in secret. They have the power of keeping them secret as long as they please, for the provision for periodical publication is too inexplicit and ambiguous to avail anything. The expression from time to time, as I have more than once observed, admits of any extension. They may carry on the most wicked and pernicious schemes under the dark veil of secrecy. The liberties of a people never were nor ever will be secure when the transactions of their rulers may be concealed from them. The most iniquitous plots may be carried on against their liberty and happiness. I am not an advocate for divulging indiscriminately all the operations of government, though the practice of our ancestors in some degree justifies it. Such transactions, as relate to military operation or affairs of great consequence, the immediate promulgation of which might defeat the interest of the community, I would not wish to be published, till the end which required their secrecy should have been effected. But to cover with the veil of secrecy the common routine of business is an abomination in the eyes of every intelligent man and every friend to his country. I appeal to this convention if it would not be better for America to take off the veil of secrecy. Look at us. Here are transactions. If this had been the language of the Federal Convention, what would have been the result? Such a constitution would not have come out, to your utter astonishment, conceding such dangerous powers and recommending secrecy in the future transactions of government. I believe it would have been given more general satisfaction if the proceedings of that convention had not been concealed from the public eye. This Constitution authorizes the same conduct. There is not an English feature in it. The transactions of Congress may be concealed a century from the public, consistent with the Constitution. This, sir, is a laudable imitation of the transactions of the Spanish treaty. We have not forgotten with what a thick veil of secrecy those transactions were covered. We are told that this government, collectively taken, is without an example, that it is national in this part and federal in that part, etc. We may be amused, if we please, by a treatise on political anatomy. In the brain it is national, the stamina are federal, some limbs are federal, others national. The senators are voted for by the state legislatures, so far it is federal. Individuals choose the members of the first branch, here it is national. It is federal in conferring general powers, but national in retaining them. It is not to be supported by the states, the pockets of individuals are to be searched for its maintenance. What signifies it to me that you have the most curious anatomical description of it in its creation? To all the common purposes of legislation, it is a great consolidation of government. You are not to have the right to legislate in any but trivial cases. You are not to touch private contracts. You are not to have the right of having arms in your own defense. You cannot be trusted with dealing out justice between man and man. What shall the states have to do? Take care of the poor, repair and make highways, erect bridges, and so on and so on? Abolish the state legislatures at once. What purposes should they be continued for? Our legislature will indeed be a ludicrous spectacle. 180 men marching in solemn, farcical procession, exhibiting a mournful proof of the lost liberty of their country, without the power of restoring it. But, sir, we have the consolation that it is a mixed government. That is, it may work sorely on your neck, but you will have some comfort by saying that it was a federal government in its origin. I beg, gentlemen, to consider. Lay aside your prejudices. Is this a federal government? Is it not a consolidated government for almost every purpose? Is the government of Virginia a state government after this government is adopted? I grant that it is a republican government, but for what purposes? For such trivial domestic considerations as to render it unworthy the name of a legislature. I shall take leave of this political anatomy by observing that it is the most extraordinary that ever entered into the imagination of man. If our political diseases demand a cure, this is unheard of medicine. The honorable member, I am convinced, wanted a name for it. Were your health in danger, would you take new medicine? I need not make use of these exclamations, for every member in this committee must be alarmed at making new and unusual experiments in government. Let us have national credit and a national treasury in case of war. You never can want national resources in time of war, if the war be a national one, if it be necessary and this necessity be obvious to the meanest capacity. The utmost exertions will be used by the people of America in that case. A republic has this advantage over a monarchy, that the wars are generally founded on more just grounds. A republic can never enter into a war unless it be a national war, unless it be approved of or desired by the whole community. Did ever a republic fail to use the utmost resources of the community when war was necessary? I call for an example. I call also for an example where a republic has been engaged in a war contrary to the wishes of the people. There are thousands of examples where the ambition of its prince has precipitated a nation into the most destructive war. No nation ever withheld power when its object was just and right. I will hazard an observation. I find fault with the paper before you, because the same power that declares war has the power to carry it on. Is it so in England? The king declares war, the House of Commons gives the means of carrying it on. This is a strong check on the king. He will enter into no war that is unnecessary, for the Commons have the power of withholding the means, will exercise that power, unless the object of the war be for the interest of the nation. How is it here? The Congress can both declare war and carry it on, and levy your money as long as you have a shilling to pay. I shall now speak a little of the colonial confederacy which was proposed at Albany. Massachusetts did not give her consent to the project at Albany, so as to consolidate with the other colonies. Had there been a consolidation at Albany, where would have been their charter? Would that confederacy have preserved their charter from Britain? The strength and energy of the then designed government would have crushed American opposition. The American Revolution took its origin from the comparative weakness of the British government, not being concentrated in one point. A concentration of the strength and interest of the British government in one point would have rendered opposition to its tyrannies fruitless. For want of the consolidation do we now enjoy liberty, and the privilege of debating at this moment. I am pleased with the colonial establishment. The example which the honorable member has produced, to persuade us to depart from our present confederacy, rivets me to my former opinion, and convinces me that consolidation must end in the destruction of our liberties. The honorable gentleman has told us of our ingratitude to France. She does not intend to take payment by force. Ingratitude shall not be laid to my charge. I wish to see the friendship between this country and that magnanimous ally perpetuated. Requisitions will enable us to pay the debt we owe to France and other countries. She does not desire us to go from our beloved republican government. The change is inconsistent with our engagements with those nations. It is cried out that those in opposition wish disunion. This is not true. They are the most strenuous enemies to it. This government would clearly operate disunion. If it be heard on the other side of the Atlantic that you are going to disunite and dissolve the Confederacy, what says France? Will she be indifferent to an event that will so radically affect her treaties with us? Our treaty with her is founded on the Federation. We are bound to her as 13 states confederated. What will become of the treaty? It is said the treaties will be on better footing. How so? Will the President, Senate, and House of Representatives be parties to them? I cannot conceive how the treaties can be as binding if the Confederacy is dissolved as they are now. Those nations will not continue their friendship then. They will become our enemies. I look on the treaties as the greatest pillars of safety. If the House of Bourbon keeps us, we are safe. Dissolve that confederacy, who has you? The British. Federalism will not protect you from the British. Is a connection with that country more desirable? I was amazed when gentlemen forgot the friends of America. I hope that this dangerous change will not be effected. It is safe for the French and Spaniards that we should continue to be 13 states, but it is not so that we should be consolidated into one government. They have settlements in America. Will they like the schemes of popular ambition? Will they not have some serious reflections? You may tell them that you have not changed your situation, but they will not believe you. If there be a real check intended to be left on Congress, it must be left in the state governments. There will be some check as long as the judges are incorrupt. As long as they are upright, you may preserve your liberty. But what will the judges determine when the state and federal authority comes to be contrasted? Will your liberty then be secure when the congressional laws are declared paramount to the laws of your state and the judges are sworn to support them? I am constrained to make a few remarks on the absurdity of adopting this system and relying on the chance of getting it amended afterwards. When it is confessed to be replete with defects, is it not offering to insult your understandings to attempt to reason you out of the propriety of rejecting it till it be amended? Does it not insult your judgments to tell you, adopt first and then amend? Is your rage for novelty so great that you are first to sign and seal and then to retract? Is it possible to conceive a greater solecism? I am at a loss of what to say. You agree to bind yourselves hand and foot for the sake of what? Of being unbound? You go into a dungeon for what? To get out? Is there no danger when you go in that the bolts of federal authority shall shut you in? Human nature never will part from power. Look for an example of voluntary relinquishment of power from one end of the globe to the other. You will find none. 9/10 of our fellow men have been, and are now, depressed by the most intolerable slavery in the different parts of the world, because the strong hand of power has bolted them in the dungeon of despotism. Review the present situation of the nations of Europe, which is pretended to be the freest quarter of the globe. Cast your eyes on the countries called free there. Look at the country from which we are descended, I beseech you, and although we are separated by everlasting, insuperable partitions, yet there are some virtuous people there, who are friends to human nature and liberty. Look at Britain. See there the bolts and bars of power. See bribery and corruption defiling the fairest fabric of that ever human nature reared. Can a gentleman who is an Englishman, or who is acquainted with the English history, desire to prove these evils? See the efforts of a man descended from a friend of America. See the efforts of that man, assisted even by the king, to make reforms. But you find the faults too strong to be amended. Nothing but bloody war can alter them. See Ireland. That country groaned from century to century without getting their government amended. Previous adoption was the fashion there. They sent for amendments from time to time, but never obtained them, though pressed by the severest oppression, till 80,000 volunteers demanded them, sword in hand, till the power of Britain was prostrate, when the American resistance was crowned with success. Shall we do so? If you judge by the experience of Ireland, you must obtain the amendments as early as possible. But I ask you again, where is the example that a government was amended by those who instituted it? Where is the instance of the errors of a government rectified by those who adopted them? I shall make a few observations to prove that the power over elections which is given to Congress is contrived by the federal government, that the people may be deprived of their proper influence in the government by destroying the force and effect of their suffrages. Congress is to have discretionary control over the time, place, and manner of elections. The representatives are to be elected, consequently, when and where they please. As to the time and place, gentlemen have attempted to obviate the objection by saying that the time is to happen once in 2 years, and that the place is to be within a particular district or in the respective counties. But how will they obviate the danger of referring the manner of election to Congress? Those illuminated genii may see that this may not endanger the rights of the people, but in my unenlightened understanding it appears plain and clear that it will impair the popular weight in the government. Look at the Roman history. They had 2 ways of voting, the one by tribes and the other by centuries. By the former numbers prevailed, in the latter riches preponderated. According to the mode prescribed, Congress may tell you that they have a right to make the vote of the one gentleman go as far as the votes of 100 poor men. The power over the manner admits of the most dangerous latitude. They may modify it as they please. They may regulate the number of votes by quantity of property, without involving any repugnancy to the Constitution. I should not have thought of this trick or contrivance had I not seen how the public liberty of Rome was trifled with by the mode of voting by centuries, whereby one rich man had as many votes as a multitude of poor men. The plebeians were trampled on till they resisted. The patriarchs trampled on the liberties of the plebeians till the latter had the spirit to assert their right to freedom and equality. The result of the American mode of election may be similar. Perhaps I may be told that I have gone through the regions of fancy, that I deal in noisy exclamations and mighty professions of patriotism. Gentlemen may retain their opinions, but I look on that paper as the most fatal plan that could possibly be conceived to enslave a free people. If such be your rage for novelty, take it and welcome, but you shall never have my consent. My sentiments may appear extravagant, but I can tell you that a number of my fellow citizens have kindred sentiments, and I am anxious, if my country should come into the hands of tyranny, to exculpate myself from being in any degree the cause, and to exert my facilities to the utmost to extricate her. Whether I am gratified or not in my beloved form of government, I consider that the more she had plunged into distress, the more it is my duty to relieve her. Whatever may be the result, I shall wait with patience till the day may come when an opportunity shall offer to exert myself in her cause. But I should be led to take that man for a lunatic who should tell me to run into the adoption of a government avowedly defective in hopes of having it amended afterwards. Were I about to give away the meanest particle of my own property, I should act with more prudence and discretion. My anxieties and fears are great lest America, by the adoption of this system, should be cast into a fathomless bottom. I must now conclude, but I have not gone through all I intended to say, and I beg to be indulged at another time. End Anti-Federalist Paper, Section 56, Patrick Henry, Virginia Ratifying Convention, Monday, June 9, 1788. End Anti-Federalist Papers.